Can I get you guys anything?
I think we're good. Are you good, Cheyenne?
I'm good. I thought you said that I had presentations for Chris Cox.
That should have been a video that already would have been in there.
Okay, just the video. Okay.
Yeah, the PowerPoint would have been for the Owen Miller, Knox Williams, and I think
Chris.
Michael Williams presentation.
Okay.
So whatever one's at 10:45.
Perfect.
And I can I just saw Matt, so if you want, I can send him over if that would.
Yeah, we just talked. I was just making sure that I wasn't missing a presentation.
Why did it come up there?
Why don't I'll just send him over just so that way you guys can double check and I don't interfere in his world.
No, let's do it this way.
Just went out to tell everybody to open the doors.
Yes.
By the way, that sounds great.
Okay. There might be one for tomorrow that you don't have.
Yeah, we haven't went over tomorrow yet, so
Okay.
I think we're going over that tonight.
Okay, okay,
So-
all right, cool. Then we will, yes, no, okay, never mind. We are rad then. I will. Hey, Charlie. Thank you.
Yep.
Here's your pen back. Let me give that back to you. Otherwise, I'll steal it. Hey, Charlie. Real fast. Here's your copy for tomorrow. Okay. There are probably you're gonna over to tomorrow morning. Come back and just verify. We got up to the fair board.
And I left my entire technical thing to show.
No. You want to look through this rack and see if there's any? They do have a
For what?
recorder in that room, so.
What are you looking for?
Because they can be AirPods, because they'll Bluetooth through his thing.
Yeah, I can use my AirPods if nothing else.
So they're not gonna need to use the red button on the clicker at all. When they're done, you're gonna control everything here in advance to the next.
Yep.
So all they need to do is green button, right? Unless
Yep.
they wanna go back.
Unless they want to go back.
Black will, or the red will send it.
That'll set it back, pretty much all forward arrows.
Sounds great. You guys are, you're advancing the slide, the faces.
Yes.
We have places, you have to go on introduction, we'll pull it in the last thing instead.
Right. And then the PowerPoints associated with it will be ready behind it, and they'll control it to green, but that will advance their PowerPoint.
Do you have holding slides between each headshot or no?
I don't have them between each headshot, but I do have it at the end of the PowerPoint.
Okay, end of the PowerPoint, we have this slide.
So again, what you tell me is the last slide, your PowerPoint will be done. One more green button, pull up the whole slide.
Okay.
Good introduction.
Good to hear.
From the headshot part.
Yeah, headshot fires presentation, if they're at, they hit the green button when they're done from the last, and it goes to the whole screen.
If they don't, we'll control it.
Great.
Do you know how to do presets on this if you want them? On this controller?
I did not learn
It's
that.
store, I'm just gonna do one, enter, but you gotta go back here
To
to
view.
use them.
Yep.
Store, number, enter, view.
Are we going to have a panel today?
Yes. Overheating. Have food here in about 20 minutes. Guess this is my table. I need to mark another mic here, I think. We'll call that a 2. Call that a 1. By the way, putting tape here, they don't go in the charging bays. Very good.
Oh.
Better not.
Did you put that tape in?
No. I'm leaving it for now.
I'm not getting audio. I'm getting this computer.
Huh?
I'm getting this microphone.
No, that's the, because I can see it bouncing when I'm talking right here.
This is me firing the handheld. No way, that's not this. The second one down.
Come on.
That mic is not picking up. He's tapping on this mic. It could be picking up back though, I guess. Why isn't that going?
No, I'm hearing it through this. Why is it not? All of a sudden
It's sitting here.
yeah. Why is this not?
No way this microphone's that sensitive, dude.
I mean, it sounds like it's.
Yeah, no way it's that sensitive. The mic on that.
But I hear us louder than I hear that.
Like you can hear us talking right
Yeah.
now. Test 1, 2, 3, 4.
Yeah.
But you're streaming, so we can't make changes to all this stuff.
Ladies and gentlemen, just to let you know, we'll begin in about 2 minutes. 2 minutes. Thank you.
Test.
Ladies and gentlemen, if you're in the first group of speakers, if you would please head up to the speakers table. If you're looking at the stage, to your left, we need the first group of speakers. That would be CD Michael. If CD is around, you can pop on up. And over to that table by Charlie Kirk, we're good to go. Turn it over to Alan Gottlieb.
Thank you. Thank you, Mark. For those who don't know who I am Alan Gottlieb. I'm the founder of the Second Amendment Foundation and chairman of the Citizens Committee for the Right to Keep and Bear Arms. I'd like to all welcome you here this morning, being the 39th Gun Rights Policy Conference. It's sort of become an institution in itself. It is the gun rights event of the year. And I just want to say to you that a lot of the important things that go on at this conference may not be printed on your agenda. They happen sometimes in the hall, at the receptions, during our breaks. So get to know each other and spread your gospel from your own states to other people. And sometimes it gets copied from one state to another, and it expands the gun rights victories we have all across the country. So I really appreciate you being here, and again, being the Gun Rights Event of the Year, you'll realize the importance and the impact this has in the coming year for the whole gun rights movement. Thank you very much.
Good morning, everybody. My name is Adam Crowd. I'm the Executive Director here at the Second Amendment Foundation. Just want to welcome you all to the 39th Annual Gun Rights Policy Conference. As Alan has said, this has kind of become an institution of itself, and I just wanted to take a few moments to welcome you. This year, obviously, as you know, because we're sitting in the room, we're in San Diego, California, and one of the questions we got from a lot of people was, why would you go to California? What could possibly bring you to a state like California when you're talking about gun rights? And the truth of the matter is that there's millions of gun owners in California. There's millions of our friends and fellow Americans in a state that continuously attacks their Second Amendment rights. And so it was important for us as an organization, along with our sister C4, the Citizens Committee, to bring an educational event to empower people, to educate them, and allow them to defend their Second Amendment rights in a state where those bad ideas are born and then exported across the country. They don't just stop here at the state lines in California. They find their way all the way to the East Coast, in New Jersey, in New York, in Connecticut, in Massachusetts, and other places. So we hope that while you're here, we can help educate you and allow you to educate your fellow neighbors, citizens, and stop this nonsense before it becomes a law and we're forced to sue them, which we're really good at, by the way. And I also want to take a moment to just acknowledge some of our friends in the room, like Chuck, who you'll be hearing from in a couple minutes at CRPA, and Mike Schwartz from the San Diego County Gun Owners and his crew. You guys have been phenomenal to be partners with, and we're very proud to work with you on a number of lawsuits here in California. I believe the Second Amendment Foundation has about 15 active lawsuits in California, and we're always looking for more to help with, so let us know. Anyway, with that, I'd like to introduce the MC for today, Mark Walters, the host of Armed American Radio, and I hope you all enjoy your time here. Thank you.
Thank you, Adam. How's everybody doing this morning? Feel like we're taking another trip around the sun together, right? 39th Annual GRPC, and I want to welcome everybody here to the event today. First off, I see a lot of familiar faces. Anybody here for the first time? Would you raise your hands? Oh, look at that. Are most of you from California? Let me get a shout. Just shout it from some. Where are you from? Connecticut, very nice. Idaho, San Diego, Jersey, good to have you here. Palm Springs, and over here? Virginia. So we got a good mix. What about you? Say that again? Okay, and in the back? Beautiful. Well, welcome. And sir, where from? Well, you know about California laws. You're one and the same. Yeah. Welcome to another unfree state. I'm sorry we couldn't help you this weekend. All right, well, we're going to get started. But before we do, I'd ask everybody to please rise, face the flag for the national anthem. Guys ready to get this party started? Who do I introduce next? Who's next? Nobody caught that? That was my Biden impersonation from the other day? He forgot where he was? Is it too soon? It's too soon. California Pistol and Rifle Association, California role in the exportation of gun bans. CD Chuck Michael joins us now, senior partner at Michael and Associates and president of California Rifle and Pistol Association. Come on up. Welcome. Oh, you have your clock. You have your clock in front of you. It's 45 seconds. Start to wrap up. 30 minutes. Oh, you as long as you need. Okay, cool. Have at it.
Morning, everybody. And welcome to the People's Republic of California. I first want to start by thanking Alan and all the folks at SAF for this year and all the other years that they've done the Gun Rights Policy Conference, and I'm glad that they did it in California. California is a leading battleground state when it comes to fighting against our gun rights and our right to choose to own a gun to defend our families or for sport. And for 150 years, CRPA has been pushing back against that, fighting for the right to make that choice. But on behalf of CRPA and also my law firm, Michelle and Associates, and the Second Amendment Law Center, which is something I want everybody to make sure everybody knows about, I want to thank Alan and SAF for putting this on and inviting me and my associate Costas to speak. He'll be up after me. And to get some information to you guys that should help you out. We have a full-time state legislative advocate in Sacramento, Rick Travis. He's here somewhere. He'll be out in the hallway at the booth at the CRPA's table on breaks. I encourage you to go talk to him. And also make sure you grab a copy of the CRPA's magazine. There's a litigation report, a legislative update report, and a local action report in here. You see all the things that CRPA is doing in California. Not to mention the cover story, which is the assault weapon case from Maryland. Maryland or Massachusetts? Thank you. That's now asking the Supreme Court to hear it. And there's 9 states with semi-auto bans that any one state, if it gets struck down in any one state, it'll help us in California, even though we were already fighting the semi-auto bans in California. And then last but not least, let me make sure that you guys know that I have a book out with my partner, Matt Cabero, California Gun Laws. I can't wait till this turns into a little brochure because right now it's 600 pages. It's a labor of love, but it's easier for me, believe it or not. I get so many, gun laws in California are so confusing. We get questions, phone calls, asking questions about things every day. And it was easier to spend all the time trying to put it together in this so I can just give them or sell them a book than have to spend all the time answering these questions, because that's how confusing the gun laws are. The legacy of most California gun laws is not public safety, it's accidental criminals who broke the law because it's so difficult to follow. Dan Lundgren, former Attorney General, once said, California's gun laws are more complicated than our tax and environmental laws. But tax and environmental laws, you typically have a lawyer on retainer, a compliance counsel on retainer who helps you figure out what your obligations are. Gun owners, the average guy, you don't have a gun lawyer sit in your closet at home, get ready to give you advice on what you have to do to not break the law. That's how confusing it is. So today I'm going to talk about sort of the evolution of gun laws in California and how they did become an exporting state of sort of the petri dish of bad ideas in the California laboratory. But let me say one thing before I move on. One of the great things that's come out of some of the Supreme Court rulings and the blue resistance to that, the pushback against Bruen, the twisting by courts and state attorneys general to try and turn Bruen into something that it never was and make it say something that it never said, is that all the gun rights groups now are working more closely together than they ever have before. That includes Second Amendment Foundation, CRPA, Gun Owners of America, Gun Owners of California, FPC, Second Amendment Law Center, which I mentioned, and forgive me, there's a number of other groups that are all really communicating more than we ever have before, and that's a good thing. And the NRA is, it's coming back, and I'm going to talk about some of the things that NRA and CRPA did together for 25 years in California, but I think I have a lot of hope. I've talked to the folks at NRA and the new leadership, and I think I have a lot of hope that they're going to rise from the ashes and be back in the game full-fledged. So I'm going to start in 1993. I'm going to give you the context of how the gun ban advocacy groups have kind of grown in California. Then I'm going to jump back to 1923 and then to 1982 and kind of hit some highlights. I joined the movement in 1993. I was working at a large firm downtown, and I made a lot of money representing oil companies, but I didn't particularly enjoy it, so I started my own firm, which has since morphed into Michelle & Associates with all the lawyers that we have. And then coincidentally, about the same time, tragically, a gunman went into a law firm in San Francisco, Pettit & Martin, and killed 8 people, lawyers and clients and some others. And there's a great book about that I co-wrote with David Frankel on Amazon. It's called Coming to Terms, about the evolution, what came out of that law firm shooting. And what came out of it was the San Francisco Bar Association, all of the lawyers that are members of the San Francisco Bar, came together and created something called the Legal Community Against Violence. Now, the San Francisco Bar and the LA County Bar and the American Bar Association, they've all been left-leaning forever, and they've all been basically anti-gun owner. But they got organized after this, and they created that group. And that group is what really kind of changed the game in California. So hold that thought. We're going to pick up, we're going to jump back to 1923 when the Sullivan Act was being passed. And California's concealed carry laws evolved. Now, I'm sure everybody here knows what good cause, what the nightmare good cause was, and the fights that we had over that, and how that all changed after Bruin, and now they're trying new things to delay and increase the costs and stop people from being able to get CCW, concealed carry permits. But in 1923, we actually considered it a victory when we did not adopt the Sullivan Law. We adopted what became the good cause law for CCWs. The fight back then was over handguns, primarily. And so they wanted to ban handguns and restrict being able to take them out in public. And in 1982, they actually launched, and remember at that time, the Brady Center was called Handgun Control. In 1982, they launched Prop 15, which would have banned the civilian possession of handguns in the state of California. It was a ballot measure. And SAF was involved in opposing that, GOA, GOC, NRA, everybody came together and fought that ballot proposal, and we won, and we stopped them from banning handguns. They sort of turned their attention to semi-autos because California in 1989 passed the first version of its Assault Weapon Control Act after the Stockton schoolyard shootings. Interestingly enough, it didn't ban the SKS that shooter used in those shootings because it was so confused about what it was trying to ban and what it wasn't banning, trying to figure out what an assault weapon actually is, that they missed a lot. And so it's been modified 4 times since then to try and encompass more and more and more. And there are obviously several challenges going on in court to that law. Okay, now coming back to 1993, the LCAV is formed. The San Francisco Bar Association gets very involved. A lot of other lawyers at a lot of other law firms get very involved. And one of their at this point, the Sacramento legislature was not in the pockets of the progressive liberal Democrats. You could actually still stop some things. So they took a different strategy. They went, and this was before Heller and all the cases that came after at the Supreme Court. And so we didn't really have the ironclad Second Amendment as an individual right case law at that point in time. So what we had was preemption, which is that the state laws conflict, so local cities can't do different things that conflict with state laws. So the LCAV lawyers came up with this creative argument to get around preemption, and they went out and started what they called the Local Ordinance Project, where they went to city by city and tried to push different local ordinances. The primary sort of centerpiece of that purpose of that initiative initially was the Saturday night special ban, which was still going along with their efforts to try and ban more and more handguns in more and more places. So in response to that, NRA and CRPA got together and created a number of different programs, including a hunting and conservation program, a state legislative council program, a range protection and development program, and a local ordinance project of our own. And we've pushed back against all these local ordinances that they, LCAV was pushing these out. This is not like somebody hears about it and they call LCAV and get it. These guys are actively pushing these initiatives throughout California, these local ordinances, to try and make it, part of the effort is, along with what they're doing with one particular law, is to just make it so confusing that you got to buy a 600-page book to try and figure out what applies in your jurisdiction, and making it different in every municipality just goes right along with their game plan, which is to murder the gun culture by making it impossible to buy a gun, making it less places where you can have a gun, less people that qualify to buy a gun, making it as expensive as possible to get a CCW or a gun or ammo. All of this is banning gun shows, banning gun ranges, making it impossible to operate one, an FFL or whatever. All of that is part of a concerted effort to eradicate the gun culture, and Newsom has said this on record. But anyway, back to the local ordinance project. So we started suing and started sending out opposition letters. LCAV was ready to get several hundred cities to pass Saturday night special laws and other laws that they were pushing around the time. And we stopped most of them because we sent these opposition letters, and folks got involved locally. We were able to recruit some local folks. And on that line, let me just mention, talk to Rick and the folks at CRPA about their local chapters. We have one in San Diego and throughout the state. You should definitely think about getting involved in those. But so the local folks helped us fight city by city. This became, by the way, the tobacco industry, when they said, when the folks who wanted to ban tobacco said, we're going to go locally, city by city, to ban whatever aspect of smoking we want to ban, the tobacco industry said, we can't fight that, it's too big. CRPA and NRA, through their local ordinance project, actually fought city by city to stop the LCAV's local ordinance project. I don't remember the exact year, early 2000s, Sacramento kind of became under Democrat control. So they really didn't need to push things locally as much anymore because they could get it passed at the state level, so they kind of changed their focus. But LCAV still, it morphed into the Law Center to Prevent Gun Violence and then the Gifford Center. It's still up there in San Francisco, and it's still cranking out model gun control laws, and they're not local ordinances anymore. They work very closely with Everytown and Brady Center and all the other gun control advocacy groups to pass as many laws as many states as they can. And it's proactive. They're pushing it out. They're not waiting for people to call in and ask for help. They're working with attorneys general across the country and giving them the model briefs. I mean, we see the same arguments, the same brought by the states when we challenge something in any of these states. It's the same kind of thing. This is being coordinated nationally by Everytown. So I guess the point of that is California, between the 1989 Assault Weapon Control Act, the local ordinances, the other gun control laws that California has passed, was definitely a leader in pushing things out across the country and trying to set an example for progressive and liberal states. But I think that's kind of morphed now because of Heller and Bruen and their perceived need, and they're correct, to have an organized opposition to the efforts to use Bruen and Heller to advance our Second Amendment rights. So now we know that Everytown and all the other gun control groups, for example, get on phone calls with the California Department of Justice and talk about what they can do next. Now, we don't know what they're talking about because the last time they did this, they put it in emails, and we did a Public Records Act request and got all their communications and saw their whole game plan, and we used that in Sacramento very helpfully. So now they've wised up. They don't put it in the email. All we get in the emails that we get public records responses for are scheduling the phone calls. But we know they're all talking regularly about what they can push in California. And these are not just folks from California. They're from all across the country. Let me jump to 2005. Again, going along with the theme that they wanted to regulate handguns before they sort of shifted their attention to semi-autos. And you had Proposition H in San Francisco. And again, this was before Heller, just a few years, 3 years before Heller. And so we didn't have the Second Amendment locked in yet. So but Kamala Harris, and I hope you saw this on the news because I think we broke this story, or Costas did, my associate who's going to come up and talk next, where she supported Proposition H, which would have banned the civilian possession of handguns in the city and county of San Francisco. We challenged that in court, and I got to jump back again because this was the second time that San Francisco had tried to do this. First, they did it after the Harvey Milk shooting, and Dianne Feinstein pushed for a handgun ban. And the SAF led the effort, Second Amendment Foundation led the effort to stop that one. And that's where I met Don Cates. Some of you may remember him, my mentor and friend who's since moved on, passed on. But he led that case, and they stopped that initial effort by Feinstein to ban handguns. Then they did it again in 2005 because one of the deputy district attorneys at Kamala Harris's district attorney's office came up with a creative argument to get around the preemption argument that had prevailed on Feinstein's attempt. So, but thankfully, we sued and we stopped Proposition H. They did not get to ban handguns in San Francisco. And again, that's part of the reason why I think they've sort of shifted their attention. Handgun control changed its name to Brady Center, and they're not focused so much on banning all handguns, and Kamala Harris is even feigning respect for the right to choose to own a handgun to defend yourself in your home. But still, you've got the California is still the sort of the laboratory, but now it's working together with other groups, and I think every town is kind of leading that effort across the country, and they're going into all the battleground states and trying to push semi-auto bans, magazine capacity bans, ammo purchase restrictions, all the kind of things that you see in California. They're trying to push those to be adopted across the country, and part of the strategy for that is that they want to overwhelm us. They want to get it to the point where, because Bloomberg 10 years ago pledged $800 million to gun control advocacy groups. Who knows how many, it's over $1 billion, I'm certain now, and probably maybe more than one, that he's put into the effort to ban guns. So they assume, and then they spend taxpayer money, so they assume that they can overwhelm us with laws that we can't keep up with the lawsuits. So that's another reason why it's a good thing that all the gun rights groups are working more closely together than they ever have, and that NRA is, Phoenix rising from the ashes, I think, coming back into the game off the sidelines, and will be much more involved as it was for 20 years through all the partnerships that it had with CRPA for lawsuits and for all the programs I mentioned, hunting and legislative and range development. And so, forgive me, I didn't have a lot of time to organize this, and I think I might have covered everything. I may finish early. I can't do this. I'm a lawyer. I have to use up all my time and then run. I gotta run long.
Counsel, you have 13 minutes.
Yeah, I got a lot of time here. So what I will do is talk about some of the lawsuits that we are bringing to fight back, and then the Second Amendment Law Center. And unfortunately, I forgot my glasses. But some of the big ones are the Duncan case, which is the magazine capacity limitation law that we got. By the way, everybody take a second and genuflect to St. Benitez, the judge down here in San Diego, who we love so much. Those are making it worse. That's how I felt after 2 Manhattans last night. Okay, so that case had an interesting tortured history. Started with St. Benitez, went up to the Ninth Circuit 3-judge panel, we won. It went up to the en banc panel, we lost 7-5. We took it up to the Supreme Court. This was before Bruin had been ruled on. The Supreme Court held it until they ruled on Bruin, then remanded it back to the Ninth Circuit. The Ninth Circuit then sent it back down to Judge Benitez. We won again, and he's also struck down semi-auto bans. He struck down the ammunition purchase restrictions in the Rohde case, Kim Rohde, who we should all know and love, the Olympic gold medalist, trap shooter. So we won with Judge Benitez again, and then we were ready to go back to a 3-judge panel, and the en banc court grabbed it. The same en banc panel that we had lost 7-5 with the first time around. And that's now been argued in front of that en banc panel, and we will see what they say, but it's probably headed to the Supreme Court along with or secondary to the Bianchi case, which now called the Snopes case. So that Duncan case, since it's en banc, it's in sort of the pole position, the first or second place to get to the Supreme Court, and that's the big lesson here. We need to get another ruling from the Supreme Court, because just like the lower courts did in Heller, where they twisted the ruling to try and make it something that it never was, they're trying to do the same thing with Bruin. They're trying to conflate the two-step process into a two-test process and say that magazines are not arms under the right to keep and bear arms, or that gun parts are not arms, or that certain firearms aren't even considered arms, like semi-automatics that are too close to fully automatics, whatever the heck that means. So the Supreme Court said in the Rahimi case that came down that they're going to have to clarify some of these things. So we're very hopeful that, and all of the groups that I mentioned earlier, including SAF and CRPA and Second Amendment Law Center, everybody's jumped in, and I know the Minnesota folks are in the room somewhere. They contributed to that too. Everybody's trying to get the Supreme Court. Usually when a party asks the Supreme Court to take the case, it's just that one brief. Other people don't try and get the Supreme Court to take the case. They'll weigh in if the Supreme Court does take the case. Then you get all these amicus briefs supporting the case on the merits. But there were half a dozen briefs filed just joining the petitioners in the Bianchi case and asking the Supreme Court to take the case for review. So we'll see what happens. They come back into session the first Monday in October. They will have their conferences and they vote on what cases to take. Depending on when the Ninth Circuit acts and how it acts, and whether we can change two minds to be truthful and faithful to the Bruin ruling, we may win. If not, we will be asking the Supreme Court to take that case again. We've also struck down the roster. We blocked out microstamping in the Bolin case. That's up on appeal. We're still litigating that one. I mentioned the Rhodey case, which Judge Benitez gave us a great ruling on, and that is scheduled for oral argument in December. CRPA v. LA County Sheriff is in litigation in the trial court. We got a big win for non-resident to get CCWs, to get licenses to carry. And now the sheriffs are kind of panicking about how they're going to process that administratively, and I think that's going to result in the Sheriff's Association asking for some positive revisions to the laws on CCW licensing, like knock off the 2-year term, turn it into a 5-year term like every other state, so they don't have to reprocess these applications every 2 years, which they don't want to do. The administrative headache for sheriff's departments or issuing jurisdictions, police chiefs, whatever, they don't want that job. It's like working for the DMV. You know, they would rather be on the streets in patrol cars. We've got May versus Bonda. That's the Attorney General Bonta. That's the one where we knocked out a lot of the sensitive places, but we're not giving up. We're working on more. And remember, you know, they portray this as a gun ban, or a ban on guns in certain areas. Well, it never was a ban on guns in certain areas. You could never have a gun unless it was locked and unloaded in a locked container in those areas to begin with. But you could have one if you had a CCW. And for 100 years, since 1923, if you had a CCW, you could bring it into those areas, and it was never a problem. But the press never picked up on the distinction between a gun ban in a certain zone, gun-free zone, and a CCW invalidation zone. So we're working to make that clear and to get those more sensitive areas opened up to possess firearms so you can defend yourself in those places. We're working with SAF and local counsel. We're working as local counsel on a challenge to the FFL excise tax. We knocked out the junior sports, the ban on marketing to minors. That's the junior sports magazines case. We're working to defend gun shows, and we'll probably need to take that to the Supreme Court. And then let me talk about Second Amendment Law Center and tell you what that is. So Second Amendment law, with all these cases going on across the country, there is a need for a coordinating body to coordinate friend of the court briefs, amicus briefs. And so Second Amendment Law Center, I pulled together some of the leading Second Amendment lawyers across the country, and they're all listed on the website, 2alc.org, to kind of make a pool of lawyers and a pool of amicus parties, potential amicus, whether it's one of the big ones, SAF, GOA, GOC, whatever, GCRPA, whatever, or the smaller groups, Pink Pistols, Operation Blazing Sword, the Minnesota guys, the Colorado guys, various state associations. They can all jump on these amicus briefs, and then we give them template fundraisers that they can send out and try and raise money for to contribute to amicus brief efforts, but also for their general operations, because state associations, and this is another thing that CRPA is doing, state associations really need to become more empowered. Like Colorado wasn't ready for the threat that it had and so, this last year. And CRPA is now working with state associations because we're probably the most highly developed of all the state associations in the country. We've got the administrative roles down, the operations down, the fundraising down, the different programs and how they're administered, shooting programs, training programs. I mean, CRPA is way out ahead. I remember the litigation counsel for the NRA described most state associations as 6 guys at a picnic table with a 6-pack and a bag of chips. That's still what many state associations are, because they're not facing the kind of threats. They didn't have to respond and evolve to the threat that, like we did in California. And CRPA has done that. As NRA kind of stepped to the sidelines, CRPA really had to step in and step up and take over a lot of those functions, and they have. And I thank everybody in the room who is a member of and contributes to the CRPA, because I'm not just a legal advocate, I'm an activist. My wife won't let me work for free, but let me say, the CRPA gets great rates. Not like the NRA's paid some of its lawyers, as you probably have heard. So we get a lot, the CRPA gets a lot of bang for the buck. So Second Amendment Law Center, the most recent one we did was the Snope v. Brown. That's the Bianchi case in the Supreme Court, asking them to take that. But we've been involved in Massachusetts, in a case challenging a machine gun ban. This is where sort of the cutting edge argument is, are fully automatics protected by the Second Amendment? They should be, they're bearable arms. Then the question becomes, are they dangerous and unusual? And that's debatable. But this court said they're not protected. They moved it into the first question, which is it an arm under the language keep and bear arms in the Second Amendment? And that's the big battle that we're still having. That's not supposed to be a test. You don't get to say what bearable arms are or are not covered by arms. They all are. Then it's a question of whether there's a historical analog. Hopefully you guys all know what I'm talking about. This is the Bruin two-step test. Historical analog law that is similar to the modern day law that would tell you that the founding fathers would have tolerated the modern day law back in 1791. So when you say a fully automatic firearm is not an arm, you're cheating the whole test and perverting the test, and that's what many courts are doing, which is why the Supreme Court really needs to get involved and fix that. So there's been several others, and they're all listed on the 2ALC website. I encourage everybody to have a look there and support us if you can, support those amicus efforts, support all the other groups. You should be a member of all of them. One thing I think the groups have learned, it's not a zero-sum game. If one group gets big contributions, we're working on the honor system. If you get a big contribution and you have more money to support a lawsuit, and the other group is not getting as much, because fundraising is very challenging these days, given the inflation rate. So we're all kind of sharing the resources. So join up, get involved, and stay informed. Sign up at crpa.org for their. You don't need to even join to get their information, which is, knowledge is power. So know what's going on. Talk to Rick Travis out there in the lobby about what's happening in Sacramento. Check out the reports in the magazine. And I'll be around if you have any questions. Thanks very much.
Thank you, Chuck. Well played on the time, my friend. Well done. Next, also from California. Delays in the issuance of CCW permits in sensitive places post-Bruin, many of you in this state very familiar with facing those delays, and some of you in New Jersey and other states are as well. And joining us to talk about this today, attorney for Michael and Associates PC is Moros Costas. Moros, welcome up, brother. Thank you, sir. If you have a presentation, you can use that.
Make sure I don't mess up the stage here. So good morning, everyone. It's great to be here in my hometown of San Diego for the Gun Rights Policy Conference. Thank you, Second Amendment Foundation, for hosting. So my name is Costas. A lot of you know me from my Twitter account, but believe it or not, I'm also an attorney sometimes. Everyone in the room might appreciate that joke except for Chuck. So while my own interest in the Second Amendment is pretty broad, as those of you who follow me know, today I actually want to talk about the specific topic of carry rights in California. And update, we now have some, a little bit. And the right to carry is critically important to me because even in the broad spectrum of Second Amendment rights, it comes out on top for me, particularly now, because now I have a toddler. She's almost 2. She's a delight, and we love to take her to plenty of places around town. We live in LA, and as those of you who also have been to LA know, it's a wonderful city, but it also is a challenged city in that there's been historical crime problems, and when I take my daughter to the park, there's a lot of unsavory characters around, and thank God nothing's ever happened, and I hope the odds are that nothing ever will happen, but I would never allow my daughter to be in danger, and California is doing their damnedest to try and take that right away from me by keeping us all disarmed. People who have gone through the process to get a permit, which has been very difficult, very trying, and have basically non-existent crime rates, yet they still harass us. So it's very important to me that good people have a reasonable path to be able to exercise their right to carry, and they be able to do so in most places, barring except places like courthouses and other places that have security. You should be allowed to carry, especially if you've gone through the trouble to get a CCW permit. So California does CCW permitting in an interesting way. While most states, I think New York might be similar to California, but most states issue on a statewide basis, we actually issue by county and city. So you apply with your sheriff or your chief of police. And what that meant before Bruin was that California had a sort of mixed result. If you lived in LA or San Francisco, unless you were someone rich and famous, you were never getting a CCW permit. It's just not possible. Whereas if you lived in somewhere like Tehama County or one of the other many rural counties, your sheriff would say on their website, yes, we have a good cause law, but if you are a law-abiding citizen and you say you want it for self-defense, that's good enough for me. And they would issue the permit, and you would be able to carry statewide, so you could visit San Francisco with your CCW, even though nobody there could carry. So it was this sort of disparate system. Bruin resulted in a sea change to that. So all of a sudden, people, even in these unfriendly counties, could apply for a CCW permit. And they did in huge numbers. Within months of Bruin, LA had, the Los Angeles County Sheriff's Department had thousands of applications in. And this sure pissed off some of our best friends like Governor Newsom, who began calling out judges by name in press conferences. This is after he had criticized former President Trump for the same thing. He began doing it himself. And he also mocked the very idea of a right to carry. He used scare quotes when he described it at a press conference as if it's not a real thing, because he doesn't believe it's a real thing. So these floodgates opened, and there were all these issuing authorities who had never before issued permits. They hadn't been set up because they hadn't done it before. So we were patient at CRPA. We wrote them letters, but we were understanding that if they were making good faith efforts, we would give them some breathing room to get set up before we started suing. And we had some great success stories. San Francisco was very tough at first, but then a lieutenant took over their CCW department who was acting, and still is, in very good faith to get it up and running. And now, although there are a lot of hoops to jump through, lots of people have gotten CCW permits in San Francisco. It's actually probably the biggest surprise of this whole effort that resulted without any litigation. There were threats of litigation, but that's okay. Water under the bridge, San Francisco. So then the empire vampire really struck back in two main ways. The first was that they banned carry basically everywhere meaningful except streets and sidewalks. That was SB 2. And then they also made permits in the same bill much harder to get, but also not just through law, but through practices like 2-year wait times in LA and Alameda, or $1,000, and that's actually cheap now, but $1,000 expenses in cities like Laverne. Now San Jose is, I think, up to $1,500 for a CCW permit. So first, let's talk about these so-called sensitive places. In 2023, the legislature passed its Bruin Response Bill, which, just like New York, New Jersey, and Hawaii the year before, it banned carry pretty much everywhere. So that's parks, state parks, libraries, anywhere that serves alcohol, this hotel, for example, public transportation, banks, public gatherings, playgrounds, athletic facilities, casinos. I need to take a break here. Zoos, museums, places of worship, and I'm probably forgetting a bunch more. So most maliciously, like the other states before it, California banned carry on all private property by default if you are a person with a CCW. So it would only be legal to carry if the business had posted a sign saying carry allowed. And you can imagine most businesses, even those that are friendly to carry rights, don't really want to post a sign like that in California. It's going to scare off customers. So it was very cynical. I think my friend on Twitter, Rob Romano, called this the vampire rule because, like vampires of folklore, you had to be invited in to enter if you had a CCW. So I like that idea so much that I immediately stole it and put it in all our briefs. So this is a far, far cry from what Bruin intended. Bruin was supposed to establish a general right to publicly carry handguns for self-defense. You do not have a general right to publicly carry handguns if you can only carry on the street and sidewalk and the very few businesses that post a sign allowing carry. So we sued in a lawsuit called Reno May et al. V. Bonta, and we were joined by the Second Amendment Foundation, GOA, GOC, and I believe the Liberal Gun Club in that one. I'm sorry if I'm forgetting anyone. And we won a preliminary injunction on every category of place we sued on. FPC also filed a lawsuit that was heard with ours called Carolero v. Bonta, and they won an injunction on some of the places we had not sued on. So all in all, we had mostly nullified this effort. So then we did our briefing. Of course, California appealed. There was this whole drama about the Ninth Circuit staying, then unstaying the ruling. Well, that's a little inside baseball, so we'll skip it. And then I found out in April who our panel was that was going to hear the appeal. And guess what? It was a judge appointed by Joe Biden, a judge appointed by Bill Clinton, and believe it or not, a judge appointed by Jimmy Carter. So not exactly a dream panel for us. It was a tough break, and I think I joked with Chuck that I was going to start writing the Supreme Court cert petition that day. So if I'm being honest, though, we got a better ruling than we expected considering the panel. So we won on hospitals, churches, public transportation, which is a big one, banks, public gatherings, and the parking areas connected to each of those places. And we also won, importantly, on the vampire rule. Of course, we did lose on places that serve alcohol, parks and even state parks, playgrounds, libraries, zoos, casinos, museums, stadiums, and arenas, and the parking areas. And when I say we, I mean all the cases, because we were heard with, as I said, the FPC case, Carolero, and the Wolford case. I don't know if Alan Beck's in the room, but the Hawaii case, which was Hawaii's almost identical law. The Ninth Circuit heard us all together. But the most concerning thing the panel did on this preliminary injunction, because we do go back down to the district court and try again, but the most malicious thing they did, I think, was that they upheld Hawaii's version of the vampire rule, and they did this because of a distinction in the laws under which California's law requires that you have to post a sign, but Hawaii allows any form of consent. And while I'm glad we were spared the vampire rule for now, that distinction probably isn't meaningful. So because of this egregious action, the plaintiffs in all three cases decide to pursue en banc review. And we've filed for that review. We'll see if it gets granted. It's usually a long shot. But the reason I think we might have a chance is because in upholding Hawaii's vampire rule, the panel relied on just two laws. One from colonial New Jersey that was clearly about hunting. It was called an Act for the Preservation of Deer, and it prohibited you carrying a gun for hunting onto someone else's property. So that's not really applicable to carry for self-defense. But more embarrassingly, the panel cited an 1865 law from Louisiana, and it was one of the black codes. It was a law that was, as the then governor of Louisiana would say in his memoirs, it was a law that was specifically targeted at freedmen. This was right after the Civil War, right after they had lost, and they were terrified of armed freed slaves, former slaves, carrying firearms. So they passed this law saying that they couldn't enter any private property without consent. And the panel called this law uncontroversial, which makes me hope that they just didn't realize what they were doing. We'll see. We've petitioned for en banc review. I hope they change their decision. So that is, and we also talk about reviewing other places, like we think, for example, the state park thing is ridiculous and places that serve alcohol. But for now, because this is a preliminary injunction, our main hope is that we fix Hawaii's problem, because right now, Hawaii will have no right to carry if the vampire rule is in effect, other than, I guess they can walk to the bank because the panel struck down restrictions on banks. So that's it. So we'll see about that one. So that's sensitive places. But last year, we also filed a lawsuit pertaining to the issuance of permits. So there's one side of it is where you can carry, and the other side is if you can carry. Given so many authorities have implemented unconstitutional policies, and like I said, California has this city by city, county by county system where we have to play whack-a-mole, we just had to pick someone and make an example of them. And so we sued Los Angeles Sheriff Department over their 2-year-long wait times, Laverne for their expenses of almost $1,000 to get a CCW permit, and they require a psych exam, and the Attorney General because California refused to provide any method at all for non-Californians to carry here. Again, we were joined by the Second Amendment Foundation, the Gun Owners of America, Gun Owners of California, and we were assigned to a newly appointed judge nominated by Joe Biden, which, you know, it's always tough, you lose the judge role. But we did get a partial victory here on the preliminary injunction. So this was another split decision, but the judge agreed with us that 2-year-long wait times were likely unconstitutional. Unfortunately, she limited relief to the named plaintiffs in the action, which was frustrating for us, but at least we have something established now where we know the judge at least broadly agrees with us, and we'll have to pursue broader relief going forward. Unfortunately, in dodging the Bruin analysis, in my opinion, she said that while Laverne had presented no historical record justifying its high fees, we had not explained sufficiently why the practice even implicates the plain text of the Second Amendment. So this, too, is frustrating because we believe the conduct is exactly what it was in Bruin, carrying a firearm publicly for self-defense, and we don't think we should have to spell out carrying a firearm publicly for self-defense without having to pay Laverne $1,000 in fees. Just like just like in Bruin, the petitioners didn't have to say without, you know, satisfying the special need or just cause requirement. It's a silly distinction, but now we are amending our complaint such that we can address this judge's particular concerns and hopefully satisfy her in pursuing a final judgment. But the most sizable victory we scored, as Chuck discussed when he was speaking, was that while the judge would not give us the win for now on reciprocity, because we had asked that California be forced to honor the permits of other states, she did agree with us the fact that non-Californians have no right to carry in the state was not acceptable. So she ordered the parties, us and DOJ, to figure out how this would actually work and submit a proposed order to her to allow non-residents to apply for California permits for the first time. So we went into these negotiations just in recent weeks with DOJ, and our goal was for non-residents to not have to come to California at all, because it would be kind of meaningless if you could apply for a California permit, but you would have to come here to do your police interview, come here to do your fingerprinting, come here again to do your training. That would be a right that would only be available to maybe someone who lives on the border with California and nobody else. So DOJ was, we had to give up a few things, which I'll discuss, but they ultimately met us in the middle there. People can do their interview online. You'll be able to mail in your fingerprints. And although the training was the final sticking point in these negotiations, we got them to compromise there too. And that is that because some sheriffs have approved online training courses, and remember this is a 16-hour training course now, so you can do that online. And as for the live fire portion, DOJ agreed that non-residents can find a trainer in their area, tell their sheriff who that trainer is, and do their shooting qualification there. So the process is such that you will be able to get a permit, apply for one, and go through the process without actually coming to California, assuming the judge signs our order, which she hasn't yet, but I think she will because it's agreed on between the parties. The limitations are you have to be a member of CRPA, SAF, GOA, or GOC. That was something the DOJ insisted on. We promise it wasn't a fundraiser, but you all should be a member of all those anyways, so I don't want to hear complaints. And there were other compromises. For example, you have to choose the sheriff to apply to where you have a good faith intention of visiting. So make sure you really, really want to see Tehama or Riverside or one of those good counties. You don't want to go to LA. So all in all, while there have been setbacks, it's been a momentous couple of years for the right to carry in California, and CRPA and its partner organizations are working hard with their allies to defeat the efforts of Newsom and others who are trying to undermine the Bruen decision. Please feel free to ask any questions or say hello to me after this. Thank you for your time, everyone. I hope you enjoy the rest of the conference.
Thank you, Morris. Appreciate it very much. Wow, first GRPC. Everybody's doing great. Everybody's on time. It's wonderful. Next presenter is a legend here at Gun Rights Policy Conference. You've seen him. If you're a veteran here, you know who he is. Don Kilmer, Litigation Counsel for the Second Amendment Foundation from the law offices of Donald Kilmer. And the topic for Don today is lower courts defying the Supreme Court, reason for caution or proof of victory. Don Kilmer.
All right, knock it off, everyone. This is a little difficult for me because I often get accused by judges of wandering around the courtroom and not, instead of standing at a podium, I'm going to have to do it now because I'm in front of a camera and I've got a microphone and these lights are a little bright, so bear with me. So when I was approached about a topic for this year's conference, I assigned myself this subject for somewhat selfish reasons. I wanted to confront an issue that has troubled me ever since I began my career as a Second Amendment litigator, and I wanted to do it in the presence of people who share my values and goals on the Second Amendment. The topic, are we winning or losing, and what is the evidence, can be sort of restated as follows. If the adjudication of the Second Amendment is so clear to me and you and my other circle of friends, why is it so opaque to others? And here I'm not talking about the advocacy groups like Bloomberg and Mothers Against Drunk Shooting or something. I'm talking about judges and government lawyers, okay, people who are trained in the law. And I don't think that partisanship is the entire answer here. Now, trust me when I tell you that Heller, McDonald, and Bruen are not just well-researched appellate decisions backed by history and text. They're also models of clarity. And this is not the case with all judicial opinions. Trust me, when I teach constitutional law to my students, I sympathize with them sometimes when we are slugging through some opaque Supreme Court opinions on dormant commerce or the 11th Amendment or rules for standing. But Heller, McDonald, and Bruen, in my opinion, are some of the clearest writing that we've ever seen from judges. And in my humble opinion, if you have a high school diploma or high school reading comprehension, you can understand these cases. Now, these three stars in the constellation are written with prose accessible to everybody. So what is the phenomenon at work here that has judges and government lawyers failing to understand what seems so clear and simple to people like you and me? Well, as I started my career litigating Second Amendment cases in the Ninth Circuit. So let me tell you a little story. When I began, there was a 1997 article that came out titled, "The Judge the Supreme Court Loves to Overturn." It was about Judge Stephen Reinhart, who's no longer with us. He passed away a couple of years ago. But he believed and stated openly that the courts can and should be agents of social change. Of course, the problem with Judge Reinhart was he meant change that actually wasn't written in the Constitution, whereas we are working to get change to reestablish what is already in the Constitution. But here was a jurist who seemed to relish his oppositional defiance of the Supreme Court, because when he was asked about his reversal rate, what he said was, they, meaning the Supreme Court, can't catch them all. Well, I suppose that could form the nucleus of a plan for judicial defiance, but at some point it becomes counterproductive. The Supreme Court gets to control its docket, you see, and it doesn't have to decide every case on a circuit split. It can delay action on some cases and wait for just the right case to come along, and then like a butterfly net, gather up all the ones that have cert petitions pending and do what it did in Bruen. It gave us a magisterial opinion on how to apply the Second Amendment law, and then it did what we call GVR, grant, vacate, and remand a bunch of cases. This is this had the effect of telling a lot of circuit courts, you're getting it wrong, it's time to get it right. But I don't think that the judicial defiance is just based on partisanship. I think there's something more at work here. And I have to credit a friend of mine who kind of quipped this to me one time when we were sitting around discussing this stuff. He says, all these people have PTSD. I said, what are you talking about? He says, post-Thomas stress disorder. And of course, here I'm referring to Justice Thomas and his crystal clear judicial prose that makes any gamesmanship harder and harder to implement. But the trauma for these judges and government lawyers comes from them losing power. See, no living creature wants to lose power or prestige or influence. Okay, these smart and accomplished people, and make no mistake, the judges and government lawyers we oppose are smart, okay, and they are accomplished, okay, and they're not to be underestimated. But they too want their ideas about fixing problems, okay? They think like Judge Reinhardt that they should be, agents of social change. But then Bruin pounded home the holdings from Heller and McDonald that expressly rejected the application of judge interest balancing inquiries. See, what's at play here when applying intermediate scrutiny tests or having judges decide whether or not a gun is an arm or not is we've got judges basically injecting their own value decisions, and of course they're unelected. Well, the Supreme Court has now thrice emphasized that the enumeration of a right takes it out of the hands of government, even the third branch of government, because a constitutional guarantee to future judges' assessment of its usefulness is no constitutional guarantee at all. Well, when you take that kind of power away from people, it leaves a mark. Let me give you another example of this collective post-Thomas stress disorder. I'm known for basically litigating Second Amendment commercial rights, mostly gun shows. Well, I filed my second gun show case in, I think it was 1999 in Alameda County. Now, I'm not conceited enough to claim that no one was litigating the Second Amendment before I came along. My mentor, as Chuck mentioned, was Don Cates Jr., who's no longer with us. But Don Cates would sit me down and kind of, crack the stubborn brain of mine and say, Don, you can't litigate the Second Amendment head on. You have to do a due process claim or an equal protection claim or use some other amendment to try and protect the Second Amendment, because if we end up with an adverse decision, that closes the door forever. So that actually was the practice of most Second Amendment lawyers back in the late 90s, early 2000s. But then I ran into this judge on this gun show case, and the word Second Amendment did not appear in the complaint. It wasn't argued at all to the court. It was a pure First Amendment commercial speech case. But this judge took the liberty, in his opinion, dismissing our case, obviously, to gratuitously remark that, and the plaintiffs did not even plead a Second Amendment claim, and well, they should not have, because we all know that the Second Amendment is not a fundamental individual right. It's a right of states, it's a collective right, and no individual plaintiffs have the right to raise it. Well, funny thing happened, though. When the judge did that, he introduced the issue into the case, and we didn't. So when we got to the Court of Appeal and actually had a favorable panel, we argued it. And the Ninth Circuit panel found that, indeed, the Second Amendment is an individual right, and it did apply to the states, and then all hell broke loose on the Ninth Circuit. Without either party asking for en banc review, the court on its own motion took the case up on en banc review, and there was a battle back and forth and back and forth. The case ended up being litigated for almost 13 years. And then during that time, Heller came down, and then 2 years later, McDonald came down. So this defiance, this attitude of, well, we can just inject our personal political views into a case where an issue's not raised, kind of backfired. The point of the story is that the trial judge felt confident enough in 1999-2000 to just make a gratuitous swipe at the Second Amendment, and then to say that it was dormant and meaningless, and that the right to keep and bear arms, was stillborn. The plan backfired. Well, what's the point of this? Well, all of this has happened from 1999 to now in about 20, 25 years. Contrast this with the 14th Amendment being ratified in 1868, and then the Privileges or Immunity Clause being gutted in 1872, the Equal Protection Clause being reinterpreted to mean separate but equal in 1896, and then the 14th Amendment lay all but dormant until 1954's Brown versus Board of Education that overturned Plessy. And we're still litigating to this day what the Equal Protection and Due Process Clause of the 14th Amendment means. Is there hope to resuscitate the Privileges or Immunities Clause, as Justice Thomas's magisterial concurring opinion in McDonald talks about? Don't bet against Justice Thomas on this, okay? We're moving farther and faster on resurrecting what was a dormant Second Amendment since the late 1990s than the Equal Protection and Due Process Clause of the 14th Amendment did over almost a century of being gutted by the Supreme Court right after the Civil War. Now, the journey today and forward still requires more work. Here's what you need to understand, folks. There is no final victory. I do a lot of other civil rights litigation, Fourth Amendment, First Amendment. Our rights are never secure in a one and done case. We always have to keep fighting these people because they keep coming back. The first cases I ever filed as a Second Amendment litigator were to protect gun shows. We're still fighting to protect gun shows in California because they keep passing more laws. They think that if the county policy gets struck down, well, maybe the state can try it. And they're basically using, our resources, our tax dollars to do it. But there are cracks in the facade. The Ninth Circuit itself is coming apart. There are judges on the Ninth Circuit that are documenting in dissents from en banc review and dissents from en banc decisions overturning favorable three-judge panels that are saying, look, there are procedural irregularities in what are taking place. Well, what happens when the opposing team wants to change the rules mid-game? That means they're panicking. That means they're frightened. That means they know they're going to lose on substance. Another sign that we're winning is here we are in 2024, just 25 years later after this judge in the Ninth Circuit, the trial judge thought that he could just dismiss the Second Amendment with an offhand comment, where one of the candidates for the President of the United States, a person who was actually Attorney General of this state, is having to put on the charade of pretending to support the right to keep and bear arms and admitting that she owns a handgun for self-defense. Folks, this is constitutional whiplash, and I believe it is part of the source of the defiance we see from judges and government lawyers. I want to say a few other comments on why there's hope here. The fight is now being waged by some heavy-hitting law firms out of Washington, D.C., and some of the big capitals. It's no longer being done by little solo practitioner firms like me or small firms like Chuck Michelle down south, trying to get funding from NRA or Second Amendment Foundation. There are some big heavy hitters coming into this and helping this. And I also want to pause here also and commend some of the young blood and young lawyers that are coming along. I've worked with several of the lawyers in Chuck Michelle's firm. I want to give a shout out to Joshua Dale, Costas Morris, who spoke before me, Alexander Frank, and my co-counsel on several of the Second Amendment commercial rights cases I've been working on recently, Anna Barvier. We won the junior sports marketing case, which is strictly a commercial speech case. We're still working on a gun show case, and we have several other commercial rights cases in the pipeline. So us old guys, as we reach the end of our useful life, just know this, that there is plenty of young blood that is flooding the market. And the Second Amendment is no longer some boutique, obscure area of law that you could theoretically be sanctioned for talking about or discussing in your briefs before. Because as this judge learned in 1999, it's not a constitutional anachronism. So where are we? I guess if I have to answer the question posed by the title, are we winning or losing, I'm going to resort to lawyers' weasel words and say both. We're winning because our opponents are in a panic. They're resorting to procedural games to try and win substantive arguments, but we're turning the table on them. To paraphrase Judge Stephen Reinhart, not what he actually meant, but what we mean, if we keep filing cases to hold the line to preserve our right to keep and bear arms, the bad judges won't be able to catch them all, and the honest judges will start ruling in our favor. So keep spreading the message of right to keep and bear arms. Please keep supporting the Second Amendment Foundation, and please keep insisting on exercising all of your rights under the Constitution. And one final thought. Everyone thinks that the first words of the Second Amendment start off, come on with me, a well-regulated militia, right? We all know that. But there is an argument for the proposition that the actual first three words are we the people. And it's up to us to insist that government obeys that sentiment, that we are the government and they work for us. Thank you.
Thank you, Don. Thank you, Don Kilmer. Legend for a reason. All right, we got a couple fun things coming up after our next speaker. I want to remind everybody we're doing something a little bit different this year for the first time, but we have a fireside chat coming up from 9:30 to 10, and it's going to be really nice. We're going to hold it over here for the first time ever with Kwang Nguyen and Rebecca Schmo, both of whom I know, and one who's been on my program. It'll be a great conversation for 30 minutes. But we've got just a couple seconds here. Let's go, staying right on time. Repeating Arms in Early America. Joseph Greenlee, Director of the Office of Litigation Counsel for the National Rifle Association Institute for Legislative Action. Joseph, the floor is yours.
Good morning. My name is Joseph Greenlee. I want to thank you all for having me. I want to thank SAF and the Citizens Committee for the invitation. And I want to congratulate SAF on their 50th anniversary. We are all living in a much better country than we otherwise would be if not for SAF and for really the lifetimes that Alan and Julianne have devoted to protecting our rights. And with Adam Crowd as the executive director, I could not be more enthusiastic and optimistic about the future of the organization. I was thinking about all the 50th anniversary stuff and how much progress we've made over the last 50 years. Certainly throughout my lifetime and in the most recent years, it seems that we are losing rights in every aspect of our lives at a rapid rate. But the exception to that is the right to keep and bear arms. So 50 years ago, there was a prevailing argument that the Second Amendment protects some collective right that maybe belongs to states. And in 2008, in the Heller decision, the Supreme Court held that no, as the founders intended, this protects an individual right that belongs to each of us individually. There was an argument that the Second Amendment restricted only the federal government from infringing on our rights, and then in SAF's win in the 2010 McDonald case, the Supreme Court said no, it protects you against state infringements as well. And then the trend for shall-issue carry laws began in the mid-1980s, and then in the NRA's win in the 2022 Bruin case, the Supreme Court held that may-issue laws are unconstitutional, indicated that the most restrictive laws states can pass are the shall-issue laws, and now we have 29 states with constitutional carry. So there's a lot to be proud of and good reason to be hopeful that we can continue to make progress in reclaiming our rights in the future. But I'm actually not here to talk about any of that today. I thought it'd be interesting to discuss repeating arms in early American history. Many of you have likely heard the argument that the Second Amendment shouldn't protect weapons like the AR-15 because these weapons were unimaginable to the founders at the time they ratified the Second Amendment. And likewise in court, we often hear that the government argues that they should be held to a lesser burden because when we challenge so-called assault weapon bans, because these weapons represent dramatic technological changes that were unforeseeable at the time of the founding. To be sure, even if that were the case, that shouldn't matter. The Supreme Court has made clear in the Heller decision that the Second Amendment protects modern weapons, just as the First Amendment protects modern forms of speech, and the Fourth Amendment applies to modern forms of search. But in any event, the founders were certainly aware of repeating arms, they embraced them, and they never did anything to restrict them. In fact, no state nor the federal government restricted repeating arms, even through the 19th century when we saw the explosion in popularity of all sorts of repeating arms, including Colt revolvers, Winchesters, semi-automatics came into the market. With the exception of Florida passed racist licensing law in 1893. But as Harold Peterson, the great 20th century arms historian, explained, the desire for repeating arms is about as old as firearms themselves. In fact, repeating arms have existed for half a millennium. The first known repeating firearms were 10-shot matchlock arquebuses, built sometime between 1490 and 1530. King Henry VIII owned one. He reigned from 1509 to 1547. And he also owned another interesting multi-shot weapon. It was called the Holy Water Sprinkler. It's this large club, had 4 9-inch barrels coming out of it, and 2 of the barrels had 6 spikes each attached to them. And it was made in Germany, but it was actually called Henry VIII's walking stick, because he would go in disguise at night and roam around the cities, make sure things were kept in order as he desired. And as a quick story, one time he was arrested, and the arresting officer feared execution when he realized he had arrested the king, and instead Henry VIII gave him a raise for doing his job properly. The first known repeater capable of firing more than 10 shots was invented by a German gunsmith in the 1500s. It could fire 16 superposed rounds in Roman candle fashion, meaning that each shot fired one after another, really whether you wanted to or not. You had to fire all 16 at once. There was no firing twice and then waiting, maybe firing another if you needed it. Similar mechanism was patented by Charles Cardiff in England in 1682. It appears he developed pistols, muskets, and carbines using this Roman candle fashion. Several other types of repeaters were invented in 17th century Europe, and they were typically too expensive or unreliable to become common, but at least 2 gained some popularity. The first was a Kalthoff repeater, which was made in Denmark by 1645, and it used 2 magazines, one for powder and one for balls, and these weapons could hold up to 30 rounds in a magazine. And the firearms were used by the Danish military, and they were sold everywhere from London to Moscow. The other type of repeating arm that gained some popularity were the Lorenzonis, which were invented in Italy, but Lorenzoni pattern firearms, pistols, and long guns gained some popularity all throughout Europe. They typically fired about 7 shots consecutively. Some European-made repeating arms reached the American colonies during the 1600s, including one, a 10-shot repeater made by the famous English gunsmith John Cookson. One of these firearms was believed to have been brought to America by one of the first settlers in Maryland. Newspaper articles and advertisements show that Americans continued to possess repeating arms throughout the early 1700s. John Pym was a Boston gunsmith who demonstrated an 11-shot repeater that he produced in 1722, and he also produced a 6-shot revolving firearm. In 1730, another Boston gunsmith, Samuel Miller, demonstrated a 20-shot repeater that he was selling and would demonstrate for a fee. And a gentleman named Joseph Massey passed away in South Carolina in 1736, and his estate sale shows that he had possessed a 6-shot repeating arm that he left behind. Then in April 1756, John Cookson, who some believe is a descendant of the English gunsmith John Cookson, he advertised in the Boston Gazette twice in April of 1756 a gun that he made and was selling from his home in Boston that he described as a handy gun that will fire 9 times distinctly, as quick or as slow as you please, with one turn with the handle of the said gun. During the Revolutionary War, Joseph Belton, he was an inventor born in Connecticut, living in Philadelphia at the time, and a friend of Benjamin Franklin. He turned his mind to military inventions. The first one, unfortunately, didn't come to fruition, but he offered to the Pennsylvania Committee of Safety the submersible machine that would take him with a cannon underwater, get him up alongside a British ship. It would elevate him to the surface, and then he would just appear and shoot a hole through the side of the British ship with a cannonball. But more relevant to our discussion, Belton informed the Continental Congress on April 11, 1777, that he had invented a common small arm that could discharge 16 or 20 rounds in 16, 10, or 5 seconds of time. That summer, so the Continental Congress was very interested. They sent some people out to check out this gun, including famous generals Horatio Gates, Major General Benedict Arnold, leading scientists like David Rittenhouse, and they attested that Belton discharged 16 balls loaded at one time. The Continental Congress then ordered 100 of Belton's guns, but the deal fell through. Belton demanded too much money, and the Continental Congress did not have much. So the deal fell through, but the example still proves that the founders knew about repeating arms. Certainly, they embraced them, they wanted them. And among the many notable members of the Congress who sought to purchase Belton's arms were Roger Sherman, who signed the Declaration of Independence and the Constitution, Samuel Adams, John Hancock, future Supreme Court Justices Samuel Chase and James Wilson, the first Chief Justice of the Supreme Court, John Jay, and future President John Adams. As for Belton, he moved to England, where he produced repeating arms for the East India Company. When the Second Amendment was ratified, the state-of-the-art repeater was the Jaradani. It was an air rifle, can consecutively shoot up to 22 shots, and although it was an air gun, it was powerful enough to take an elk with one shot and ballistically equal to a powder gun. In fact, several air guns were made in the late 1700s for the purpose of big game hunting and military use. The Jaradani was invented for the Austrian army around 1779, and it stayed in service for, they issued 1,500 to sharpshooters, and they remained in service for 25 years, including in the Napoleonic Wars. In addition to the roughly 20 or so rounds that could be stored in the gun at once, Austrian soldiers would typically carry 2 additional pressurized butt reservoirs and 4 additional tubes containing 20 balls each, so they could fire quickly up to 100 shots. And as a testament to the rifle's effectiveness, Napoleon would, when he captured the riflemen, he would treat them as terrorists and torture them and execute them in the hopes of deterring other Austrian men from joining these air rifle companies. Meriwether Lewis carried one of these Jaradanis on the Lewis and Clark expedition. He purchased it in Pennsylvania, possibly from clockmaker Isaiah Lukens, who sometimes made guns on his own time. The air gun proved extremely important on the expedition, although they got off to a rocky start with it. So we picked it up in Philadelphia, Meriwether Lewis, and then in the first entry in the Lewis and Clark journals on August 30th, 1803, he explains that he's around Pittsburgh. Some men call him up to demonstrate his air rifle to him, and he shoots, I think it's 7 shots successfully from 55 yards, and then somebody comes up and says, "Can I try that out?" And this guy picks up the gun, accidentally fires it, hits a lady in the head. She's gushing. She goes down, gushing blood from her temple, but fortunately, she was okay. It just grazed her temple, and she popped up, and they concluded she was just fine and continued on their way. Fortunately, after that mishap, they had more luck throughout the rest of the expedition. They mention it at least 39 times in the journals, and every single time, it's when they encounter a new American Indian tribe, and they want to impress them and make the point that they can. Immediately, the first thing they do is start shooting their air rifle to make the point that they may be smaller, but they're still capable of defending themselves. And they deliberately gave the impression that every man on the expedition had the rifle, even though, in fact, only Lewis had it. The first American military contract for repeating arms was the U.S. Navy's 1813 contract with Joseph Chambers. Chambers produced what he called machine guns, which included long and short swivel guns, muskets, and pistols. Chambers' muskets fired up to 12 shots consecutively, and his pistols fired up to 6. Most impressive were his swivel guns, which were commonly composed of 7 or 8 musket barrels. They contained 25 shots in each and could thus fire up to 200 shots in quick succession. The swivel guns he made for the Pennsylvania militia had 224 shot capacities. It's also worth noting that Americans could own cannons in the founding era. President Biden repeatedly tries justifying his proposed bans on so-called assault weapons by asserting that people couldn't own cannons in the founding era. He says it's not a right to protect any gun that you want. You couldn't own cannons in the founding era. That's not true. People certainly did. To provide a few examples, frontiersmen in colonial and founding era America often kept cannons to defend fortified buildings against attacks by the French, Spanish, and Indians. When the Quaker dominated Pennsylvania legislature in 1747, refused to fund a militia, Benjamin Franklin and his friends arranged a lottery so that they could purchase privately owned cannons, and they borrowed some others. During the French and Indian War, Georgia authorized militia officers to impress privately owned cannons for use by the militia. In 1774, leading up to the Revolutionary War, Samuel Adams complained that the British were seizing privately owned cannons. That was one of his grievances. And then during the Revolutionary War, New Jersey borrowed 3 privately owned cannons to form an artillery company. Maybe most significantly, colonial newspapers often contained advertisements for cannons just from people announcing that they're selling their cannon and looking for another private owner to purchase it. So in conclusion, based on the founders' knowledge and their embracing of repeating arms and the advancements in arms technology that they witnessed during their lifetimes, it is implausible to suggest that the common firearms of today would make them rethink the Second Amendment. Thank you.
Thank you, Joseph. Thank you very much. Welcome to our first fireside chat ever at a Gun Rights Policy Conference. I don't know what happened to it. Got you guys? I'll let you guys get up there. If you guys would take the...
Just making sure that I don't go off on side of the Oh, look good.
Yeah. You all set? You all
Look good.
right? That's good. Very good. We have a broken ankle. It's terrible. Ladies and gentlemen, this is the first fireside chat we've ever done, and I'm really looking forward to this because you're going to get an opportunity to hear conversation from two state legislators in states that are very instrumental in passing pro-gun legislation. Rebecca Schmo, Kansas state legislator, and Kwong Win from Arizona state legislator. Wait till you hear the story from this gentleman and from Rebecca. If you would welcome them both to the GRPC this year. Pleasure's all mine. Good to see you.
Thank you.
And Kwong, pleasure's mine. So I'm going to forego the notes. Rebecca, you've been on my show before, and we had an opportunity to talk about some of the moves that you were making in Kansas. So let me start with you, because a lot of people around the country might not realize really how pro-gun Kansas is. And it is very pro-gun. First off, if you would start, tell us about the makeup of the Kansas State Legislature and some of the recent pro-gun legislation that has passed in Kansas.
All right. Kansas State Legislature, I am in the House of Representatives. We have 125 of us over there. The Senate has 40. We do have a supermajority, but that's in name only. So we really do walk a fine line. Anything that the governor vetoes is likely to be touch and go when we come back to override. As you guys all know, gun rights and the issues surrounding those are volatile at best, even in safe states like Kansas. One of the things that I got to do as soon as I was elected, they call it a freshman term. So my first year, freshman term, I was able to go up and remove the state fee for our concealed carry license. Thank you. We do still have to pay the local sheriff's office $32 or so in order to do the processing, the paperwork, the picture, all of that. When we go back next session, we're actually looking at making sure to remove that fee as well. That way it will be no cost whatsoever to get your concealed carry permit in the state of Kansas. We also are constitutional carry, and we are true constitutional carry as in you don't have to have a permit when you come to the state of Kansas. Anyone can come into the state, and if you are legal to carry at the federal level, then you are legal to carry in the state of Kansas, to the point where you are legal to carry in our capital in the state of Kansas. So it's pretty free.
Rebecca, does that include 18 to 21, or is it 21 up only?
18 to 21, you do need to have your concealed carry permit. You do need to go through the training. Over 21, you don't need to go through the course, but there are still a lot of really good, legitimate reasons to do that.
That would be state reciprocity, that would be background checks, et cetera, purchase firearms. What about wait periods in Kansas for firearms?
Oh, you just walk in and pick out
Free
what
state,
you want,
ladies and gentlemen.
and
I
then
said
you come
that to
home.
respect to Californians, right?
Yeah.
A lot of people from California here, when we walk in Georgia, for example, or Kansas, we walk in, we buy a gun, we walk out. It's that simple. Kwong, thank you. We'll go back to a lot to cover with you. Kwong, you and I had a great conversation last night outside. I was shocked. the argument can be made and has been made for many years that Arizona is the quote-unquote most gun-friendly state in the nation. I would argue that, and maybe we'll talk about a little bit about that up here. And I'll just give you an example why, but we'll do that in just a second. First, you made some comments last night that utterly shocked me about how much legislation you personally have stopped in what I consider to be the very free state of Arizona. Would you tell us about that?
Thanks, Mark, for the question. Amazingly, we only have 30 senators in the Senate and 60 in the House, and we only have one vote lead in each chamber. So you know how dangerous that in Arizona. Plus, we have a crazy Democrat governor, Governor Hobbs, and so you can see how difficult that is. Now, so in 2023, I was appointed as the chairman of Judiciary. And, I'm looking out there, I'm seeing so many scholars out there and litigators, and just so you know, officially, I'm not as smart as you guys, but what I can do as a chairman of Judiciary is to kill every single bad gun bill before they get to you guys. So,
how many was that you
in 2023, I personally shredded 24. In 2024, 34. And I can promise you right now, in January, I'm going to be facing about 30 of them. It's not very difficult if you have a shredder right next to your desk. So,
would you be kind enough to talk? A lot of people might be shocked. I was shocked to hear that coming from Arizona. You're shaking your head, yes. Would you have expected that in a state?
Absolutely.
Let's talk about the opposition in Kansas real quick before we go back to Kwong. What do you face from the Democrats? Just when you think they can't get any lower, they lower the bar further. Are you up against the same thing in the legislature?
Oh, we absolutely are. We also have a Democrat governor. She actually puts on the red shirt and invites the demanding mom activist.
Demonic was right. You
Yeah,
can say
well,
that. Freudian slip.
That too. So she actually invites them to come to the Capitol and host them in our Capitol. So any gun legislation we try to put through that is pro, we're facing her veto. Aside from that, they will put forth things like safe storage and similar issues. The thing is that now that at the DC level, they have the How to Infringe Better on Your Rights department that Kamala is in charge of. They're actually training state legislators with your tax money in DC. They, 4 of our Democrat legislators, 3 from the House and 1 from the Senate, actually went to the first conference that they hosted, training on how to get little pieces added into good bills that would infringe on your rights. And so that was new for us going in, because all of a sudden we had all of these really interesting amendments that didn't say exactly what, like they weren't being totally honest about what the goal was. In fact, some of it was safe storage, some of it was removing campus carry, things like that. But they were wording it in such a way, because they had been trained, that it could have slipped through. Luckily, we have a lot of really good people in Kansas that are making sure that we catch all of those. But it's hard when they're being trained with our
and they're
tax
tricky
money.
about what they do. You're absolutely correct, because I'll insert this legislation that people don't understand. If it passes and it gets by, it will repeal what's already in place. So they're making those attempts in Kansas as well. In Arizona, Arizona is a very pro-gun state. There are some laws that need to be changed, hence why there's an Arizona Citizens Defense League. I'm a life member of the organization. I've been going to the meetings as often as I can possibly get out there. And a lot of people don't think, wow, what are they doing in Arizona? But you just enlightened us. A 1-seat majority. That's dangerous in a state like Arizona, particularly when you're looking at the demographic shift of sorry, Californians, but a lot of you Californications have turned Arizona very purple. But I sense that we're starting to see more conservative gun-owning Californians flee to Arizona. Could we be seeing the same shift that we saw in Florida that went from purple and blue to purple, now back to very solid red? Could that be happening in Arizona now because of that demographic shift? Is it changing?
I'm a refugee from California myself, right? So probably the only person who had escaped communism twice, right? Vietnam and now California. So
Congratulations.
So I will say this, it's kind of funny how people move from California to Arizona because they're trying to escape tax and all kinds of policy, but then when they get to Arizona, they vote the same way as they do. And so it's really perplexing for me but I thank God every day because you think about it, you can't pass a simple, meaningful gun bill to protect the Second Amendment in the state of Arizona in the last 2 years. But so the best thing that you can do is to convince all of your colleagues that, hey, if we can't pass them, we ought to kill the other ones. And I'm able to convince people to do that. So I hope to come back as a majority. And I hope to be able to come back and maintain my chairmanship. Because without it, we do have some people that are on our side a little squishy about it. And so, we need to stand strong. And
let me interrupt. Why are they squishy? What makes them on our side squishy? What are they squishy about?
So occasionally, it's important to work with the other side to make us look like we're fair people. And when it comes to gun ownership, there's nothing fair about it on my terms. So either you like guns or you don't. And I think the Second Amendment, I want to touch on this a little bit too. The Second Amendment is very personal to me because I know what it's like losing my freedom and my country. And so I don't want you to have to face that, your grandchildren, your children to have to face that. So I'm going to do everything I can to make sure I get to do my part. I don't want you to have to litigate these bills, these laws that they're going to pass when they take over the House and the Senate. I want to make sure they're gone before they get to you.
Yeah, the fear, that's what's always shocked me about a place like Arizona. You don't think that you're that close in Arizona. Maybe you would think about Kansas, a little bit more Midwestern state, but Kansas, you have a supermajority. He's not facing a supermajority right now, and in a place like Arizona, is very, very dangerous when that occurs. I'm going to touch on a couple laws, and I want to talk with you about some of your state laws as well. In Arizona, I would argue, and I come now from Georgia, prior to that from Florida, both very pro-gun states. When I moved from Florida to Georgia, Florida was light years ahead of Georgia's gun laws. And because of GeorgiaCarry.org, now GA2A.org, in a short 10-year period, we were able to flip that script. Georgia is light years ahead of Florida right now. Even with the passage of Florida's constitutional carry, it's still not an open carry state. You still can't carry in certain places. In the state of Georgia, not that I do this, but I can walk into a bar with an openly carried handgun and have a Jack Daniels on the rocks, and the only thing the bartender will ask me besides, do I want that a double, is what kind of pistol am I carrying? That's a true story. Mm-hmm. In the state of Arizona, I visit at least 4 times a year, much fond of the state. There's nowhere I can go in Scottsdale, for example, that doesn't have a no-gun sign on the wall. And in Arizona, that carries the full weight of law. Very few signs do I see in Georgia, and even if I do walk past it, which I do, if I see them, and it's very infrequent, it does not carry the weight of law. So how do you get that back? How do you advance that in Arizona, in a free state? Are you up against a dead end with Hobbs? She's not going to sign anything.
No, she's not going to sign anything, and to some unknown reason, under Republican Governor Doug Ducey, we weren't all that friendly either. So, but I do want to say this though: as a freshman, I did pass a bill that is the state version of the federal PLACA. So if you guys are manufacturers out there, please come to Arizona. You're not going to be sued. And as a freshman, I mean, I just stuck my head out there and did it. And, fortunately, Governor Ducey did sign it. But, regarding all these signs, I'm not sure I should be saying this as a lawmaker, but I tend not to see those signs.
I know what you mean. I've missed a few myself. By accident, of course.
Right. Movie theaters. Yeah. I don't know.
Zoos?
Zoos. Yeah, and things like that. But but that's one of the reasons why I love concealed carry, and Arizona is a constitutional carry state. And just to let you know, the Democrats are introducing bills this coming January about taking away your constitutional carry. limit your magazine capacity. Now, when it comes to magazine capacity, it's kind of a fun thing for me. Why is it 10? Why is it 20? Because I think magazine capacity is, for me, is 1,000 plus 1. And so I actually don't understand until somebody defines what high capacity means to me. It doesn't mean, I mean, I like Gatling guns sticking out of C-130, right? I've been on a C-130. So is that capacity? I don't know. And so, you know, it's a very, one thing about the way I behave at the state of Arizona is this. As a chairman, when I introduce gun bills, Democrat members do not ever challenge me. And as, you know, I was kind of wondering, is that me? Do I look funny or something? But it turned out that I actually asked the majority leader, and I said, why aren't they challenging me when I introduce gun bills? Kwong, it's because you make them look stupid when they ask questions. So
the weakness shows because of your strength, and that's huge. And you, the same thing applies to you. Let's stay on that tack. I find this, it's fascinating to me. As a state legislator, how does the other side approach you? You know, we see this, our friends on the other side. Are they really our friends?
It depends on the bill. It genuinely, it depends on the bill. There are friendlies that, depending on what the bill is and what the bill's about and how likely it is to get passed, that we all work together really well, very, very nicely. And then there is anything having to do with liberty. And so we can work together on a few things. In fact, in Kansas, we just had a phenomenal, the House actually had a unanimous vote in favor of a tax cut. That has never happened in the history of Kansas. So everybody in every party was just, you know, of course people need their money back. And then there's gun bills. Right. And I'm a little bit of a different case because prior to becoming a legislator, I was an advocate. And so I actually started with a couple of national organizations, mostly women's organizations for gun rights, 1 Million Moms Against Gun Control, and then Women for Gun Rights, formerly known as the DC Project. And so I was already doing the advocate thing. Most people that I now work shoulder to shoulder with and that come against me about gun laws already know me from my time testifying in their committees before I was ever a legislator. So they understand that I have the background. They understand that I know what I'm talking about. I know what the laws are. And honestly, most of the time, that garners some respect. And then on the House floor, not as much.
Well, there's also money on the other side, too. You know, KSRA, I've spoken at their meetings before, a great group and a great group of people. But we have to fight, as everybody in this room knows, we have to fight with our $25 donations here, our $50 donations there, right? AZCDL, phenomenal group. And in fact, so good, I think between VCDL and AZCDL, those are the two groups that most other state gun rights groups have been patterned after at some point. People have looked to those two groups for some type of authority. Now, you've already said they're scared of you. I can understand why, because you're successful at squashing their bills. Is there a chance down the road, would Hobbs, if it was a bipartisan bill, well, first off, let me ask you this. Is there any bipartisan pro-gun legislation that the Democrats would be willing to talk to you about in the state of Arizona, knowing its constituency base, that it is a pro-gun constituency?
None exists that I know of, all right? So it's very simple. The minute you, for example, they're screaming about, you know, 104 children accidentally killed themselves, you know, with guns that are not stored. And so my seatmate and I immediately introduced the bill. And we actually work with the NRA and the AZCDL on this bill as well. It says, you know, we're going to introduce a firearm safety course. And that's part of the ASRPA, which I'm a president of. You know, we teach firearm safety. We'll go in there, we'll volunteer. There's no cost to the state. We're going to get a bunch of ASRPA instructors and NRA instructors to go into the school. Teach your kids in high school once a year about gun safety. And what's the answer? First, we're going to veto it. And then we'll tell you that you are indoctrinating our children with the NRA information, right? Which is furthest from the truth. But speaking of indoctrination, they're at it for 60 years. And here we are, we're talking about firearm safety to bring into school to teach our children what? Run away, tell the adult, blah, 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 all this stuff. It's good stuff for children. Storage information, and she vetoed it twice already in 23 and 24. So when they come around and they tell you that they really care about children, they really are not. That's number one. Number two, nice thing about me being a chair of judiciary is I did ask the speaker for every single gun bill, good or bad. And then I asked for every abortion bill on top of that as well. So they're sitting there crying every day when I get onto my chair, every Wednesday, because their bills are not on the agenda.
Right. Good for you. You're shaking your hand over there. Kids, obviously, they play the card every single day. It's all about the kids. We're a bunch of extremists. We don't care about our kids. Everybody's in bed with the NRA. You see that there. Who are the most formidable gun groups, anti-gun groups that you're facing in Kansas?
Okay, so just the same as Arizona, we've been trying to pass a bill in the state of Kansas to standardize safety training for kids in public school for years. I mean, it's over 8 years that we've been trying to get this bill passed. The problem is that it's always referred to as the Eddie Eagle bill. And so the NRA is a 4-letter word. And therefore, it's easy to attack that. It is easy for them to just dismiss the fact that we are actually actively trying to help and keep kids safe and keep families safe because they can attack the NRA. They're the big boogeyman in the room at that point in time. So then it's still legal to teach firearm safety in the state of Kansas in a public school, but there is no standardization. So you can have a teacher in there that says whatever she wants. We can't have that. That is the indoctrination.
So let me stop you. What about guns in schools as far as armed teachers? I want to ask you about that as well in Arizona. But where are we in Kansas right now with that? Are there armed teachers in schools?
Technically, it is not against the law so long as you have your concealed carry permit and you have permission from the local authorities, including the school board and the superintendent.
Is it common? Do you know? Do you have any information on that?
Honestly, people don't advertise. And I'm a big believer in just take the stickers off the wall. Nobody's hiding behind those stickers. Those stickers are not keeping you safe when you walk past them. I worked in a public school setting for 5 years, and I had to walk past one of those stickers every day, and it never kept me safe once. And so if we just remove the stickers, then that in and of itself is a deterrent, and it doesn't cost the taxpayers any money at all.
Yeah, that's a great point. As you know, I'm very familiar with Arizona. I'm a big fan of Tombstone, been going out there for about 30 years.
Yes,
Actually, every time I'm out there, I take a picture of the sign in front of the Tombstone High School and the elementary school. Warning, any deadly force will be met with deadly force. Our teachers may be armed. And that's a beautiful thing to put out there and remind people. So I know the answer to that in Arizona. Here's the reason I mention that. Most of you know, I come from Georgia now, and we just had a school shooting a couple weeks back in a county called Winder, in a city called Winder County. And I found out and was able to confirm through 2 legislators, to the best of my ability, that is one. Now, we have school carry. We also have campus carry in Georgia. But that was one of 4 counties. They couldn't tell me who the other counties were. They don't publicize it. That allowed armed teachers on campus. I can't tell you if there was an armed student there, but what I can tell you is 2 armed individuals stopped that carnage and probably saved at least another dozen lives before responding authorities could have gotten there. So we know it works. And it doesn't matter that it was a school resource officer, there was a guy, what was it, what do they say? A good guy with a gun doesn't stop a bad guy with a gun. That's BS, and we all know it. And what happened in Winder, Georgia was proof of that. So hopefully you guys move forward on that and we get some more. Look, I mean, even put the sign up, right? Just put the sign up. You might be reached.
Right.
You know it works. There's a Guardian program in Florida that's been in place since Parkland for the last 6 years. How many school shootings have there been in Florida since Parkland? 0. Because bad guys know that every single school is armed. Where would you?
Right. So unfortunately, in the state of Arizona, it's up to the school districts. So the school district will make the determination whether they want to have a school resources officer or not.
Safe to say Maricopa does not have it in their school district.
Probably not. And I've been trying to run bills, and I said, you know, how much money do we waste on incarceration? There's a lot of money in incarceration, so let's just, and I'm okay incarcerating people. I love incarcerating people. As a matter of fact, as chairman of Judiciary, when it comes to criminal justice reform, I want to reform a 5-year sentence to 10 years, and that's how I want to reform it. But go back to the guns. I introduced a bill in 22, that would allow CCW holders to carry on college campuses, right? And we had about 13 years of states that would allow college students to carry. I mean, obviously you have to be 21 to have a CCW. And out of those 13 years, we cannot find a single case where a CCW holder would shoot somebody on a college campus. And I remember when I introduced that bill, ASU came out and sent the police chief to the podium to argue with me. And what he said was, we have, and I'm coming as close as I can to the quote, we have a lot of mentally issued at ASU. We have drug users at ASU, and we also, he's coming from a police chief. Which marketing department sent him to the committee? And we have a lot of people using drugs. And I sat there flabbergasted, and I said, thank you for making your point, because I would never send my children to ASU because I don't want them to deal with drunk drivers, crazy people, and drug users. And basically, the next day, somebody said, who sent this police guy to go with Kwong? I don't know, but that's how crazy they are.
It's an uphill battle.
It is an uphill battle every day.
It's an uphill battle. It took us many years to move that in the state of Georgia. We finally got it signed. I know a lot of people don't like Governor Kemp, but he did some great things for gun rights. Later and longer, it took him longer than he should have. It was politically expedient for him to do it. I understand the politics of it. But we did become constitutional carry, and Arizona has been in fact, I was in Arizona when your governor signed that bill back in 2010.
And it was Matt Salmon that actually worked on that.
Beautiful work that you guys have done. So the future of Kansas, with the last 4.5 minutes we have, what do you see moving forward? What are your goals now to advance? And then I want to follow up to both of you. I'll ask you the same thing. What a Kamala Harris presidency would do, just to Kansas, to the country. So take both if you would.
Okay, so we actually last year introduced a state constitutional amendment that would clarify what arms means. So that would include components, accessories, and ammunition, because without those three things, your firearm is just a paperweight. On top of that, it also introduced strict scrutiny language into our state constitution, making it harder for the other side to come in and chip away at our rights. Aside from that, we have an entire list of things that we want to make sure to get done. We've got a Second Amendment Protection Act that we refer to as Hauser's Bill. He was a former representative. And basically what it would do is make sure that state resources could not assist federal alphabet soup agencies coming in to try to enforce their rules, which are not laws. We also would like to make sure that credit card companies are not discriminating. We want to eventually take the sales tax off of exercising your right, so no sales tax on firearms, ammunition, things like that. We want to make sure that 18 to 20-year-olds can walk in and purchase a handgun since they're legal to carry them. We would like to make it to where someone else doesn't have to provide that, because that's a fine line.
Yeah, I'm glad you brought that up, because my son called me last night while we were having our deal. He was going to a Braves game. He'll be 20 tomorrow, 20 on Monday. He called me. He was taking a buddy to the Braves game. He said, "Mom's gun is in the car. Am I okay?" He was already 10 minutes from home. I said, "No, you're not. Unless he owns the vehicle. If the vehicle's not in his name," I had to send him back home. I said, "I don't want you to take a chance. If something happened, you're charged with a felony." Even though he can shoot, even though he can go in and buy a rifle, that's the ridiculousness of it. Kwong, what are you doing? We've got 2 minutes. Tell us
Yeah, so real quickly, we're kind of in a situation where we need 90 votes plus the governor, and the governor is always against anything that has the word firearm or guns in it.
I've heard her say she supports the Second Amendment.
So basically what we're going to do is we're going to resort to just killing bills. A lot of my colleagues are saying, well, Kwong, why can't you hear this bill? Because you're going to put it on her table, her desk, for her to be on the record that she's against the Second Amendment. Well, could you tell me which Democrat governor is supporting Second Amendment that I have to put her on the record? No, it doesn't work that way. Unfortunately, this is what happened when we put a gun bill on her desk. We put it on her desk, she vetoes it, and then she raises money off of it. That's the thing. She is so proud of vetoing these bills that she can go to her base and see, look what I did in the state of Arizona. I veto every single gun-friendly bill, and I don't want her to have the pleasure of doing that. So I'm going to continue to kill it for the next 2 years until I get a friendly governor, and then we'll talk legislation again. But we're going to continue to talk with AZCDL and the NRA and the NSSF to make sure that we work on meaningful things that can be passed.
And you know that the SAF has your back, that if something happens,
absolutely,
to help sue the crap out of it. I think we're going to run out of time, but I think you would both agree that Kamala Harris is not only going to be bad for the country, but bad for your states individually as well. You would agree with that?
I definitely would agree with that. But yeah, it'll motivate me to be at these organizations more often. But regarding SAF, did I say that right?
Yes, you did.
Yeah. I don't want you to have to defend us because I want to get to the front end of it.
Boom. That's it. You're spot on. You wanted to close out? We've got 40 seconds.
Absolutely. Kamala Harris would absolutely change the face of gun ownership in the nation, across the nation.
She's a gun owner. She's going to shoot an intruder, and she supports our gun rights. Now, she said that from the border
I
yesterday.
understand what she says. However, I also understand what she does, and I believe what she does far more than what she says. I tell people all the time, coming from the world of advocacy into legislation, look for the people who are protecting your rights. Support those who support your rights. If you cannot find a good representative, become that representative.
Boom. Ladies and gentlemen, first fireside chat. That was fun. The next one is going to be California Representative Darrell Issa, coming up around 1:15 to 1:30. So hope you enjoyed that. Thanks, guys. Kwong Nguyen from Arizona, Rebecca Schmo, Kansas. We'll get some help out here for you. Hold on. Ladies and gentlemen, could I ask everybody to come back in and take their seats, please, so we can stay on time? Thank you very much. Ladies and gentlemen, if we could have everybody come back in and take their seats, we'll continue with the morning program. If we could ask everybody to come back in and take their seats, we'll get started. Thank you. Ladies and gentlemen, final call. We'll get started. If everybody could get back to their seats, please. All right, well, for the sake of time, we're going to get started again. Everybody outside, if you want to come back in. Up next, Industry Under Fire, How Attacks on the Firearms Industry Hurt the Second Amendment. Sean Smith is going to be joining us. It's his first GRPC, so welcome, Sean, for the first time. Manager of Government Relations, Federal Affairs for none other than the National Shooting Sports Foundation. We love your organization. Come on up, Sean. Thank you very much for being here.
Hello, everyone. As he said, I'm Sean Smith, Manager of Government Relations for NSSF. For those of you who might not know about NSSF, we are the trade association for the firearm, ammunition, hunting, and recreational shooting sports industry, representing over 10,500 member companies nationwide. For more than a decade, we have fought continuous attacks against our industry and law-abiding citizens' Second Amendment rights. NSSF, along with other members of the firearm community, have been there to push back against these attacks by working with members of Congress and their staff to craft legislation to support and defend the Second Amendment and the industry and the customers we serve, each of you. The first issue I want to discuss is financial discrimination, which started with Operation Choke Point. As many of you may know, the Operation Choke Point was an Obama-Biden era effort led by the Federal Deposit Insurance Corporation and the Department of Justice to coerce banks and other financial institutions into closing or denying business accounts of clients they and the FDIC deemed as high risk. FFLs and other companies were caught up in this, were not immune to this discrimination. Due to the deliberate action, some banks ended years-long relationships with legal and legitimate companies based on social and political views. When the FDIC had indicated it would take steps to end the targeting of the industry, the DOJ also admitted that the initiative was inappropriate and claims it has been terminated. The pattern of financial discrimination has not ended and has instead been privatized by financial institutions and businesses pressured by liberal activist investors pushing their woke ideology. NSSF has worked with members of Congress to introduce 3 bills that push back against the financial discrimination our industry faces: the Fair Access to Banking Act, Firearm Industry Non-Discrimination Act, and the Protecting Privacy in Purchases Act. The Fair Access to Banking Act, introduced by Congressman Andy Barr of Kentucky and Senator Kevin Cramer of North Dakota, would ensure that banking and credit decisions are based on individualized creditworthiness and impartial risk-based standards. It would also prevent major financial institutions from accessing taxpayer-funded government programs such as the Automated Clearinghouse Network, Federal Reserve discount window lending programs, and FDIC insurance when they are at the same time denying banking services to legal businesses under federal law. The firearm industry respects the free market, and financial institutions should be able to work with whomever they wish. However, we are a constitutionally protected industry, and we should have access to financial services. And we, collectively, the taxpayers, should not be forced to foot the bill to advance the social agenda of the left. The Firearm Industry Non-Discrimination Act, introduced by Congressman Jack Bergman of Michigan and Senator Steve Daines of Montana, like the Fair Access to Banking Act, works to put an end to the woke corporations profiting from taxpayer-funded benefits. However, the FIND Act is specific to the firearm industry and applies specifically to federal contractors. The FIND Act would prohibit the federal government from entering into contracts with an entity that discriminates against the firearm industry and denies them essential services. Additionally, the FIND Act would require federal contractors to certify that they do not currently have, nor will they adopt a policy that discriminates against the industry during the term of their contract. The FIND Act does not tell companies who to do business with, allowing them to engage in boardroom gun control at their will. If they do, however, the legislation makes it to where they forfeit the ability to engage in federal contracts due to their discriminatory practices. Our state-level lobbying team has been working tirelessly with state legislators on similar legislation and have successfully helped pass the state-level FIND Act in some form in 9 states, including Alabama, Florida, Georgia, Idaho, Louisiana, Montana, Texas, Utah, and Wyoming. The anti-gun groups have also pursued their social agenda through the international community, with the latest effort of pushing for creation of a merchant category code specific to the firearm industry. In September of 2022, the Geneva-based International Organization of Standardization created an MCC specific to the firearm industry at the request of Amalgamated Bank after years of effort. While the MCC gives no visibility to what a person purchases, it has been celebrated by the anti-gun community as a win because it is an initial step towards government bureaucrats monitoring and approving the purchase of firearms and ammunition at federally licensed firearm retailers. The Protecting Privacy in Purchases Act, introduced by Congresswoman Elise Stefanik of New York and Bill Hagerty of Tennessee in the Senate, would prohibit requiring the use of or assigning an MCC specific to a firearm retailer. This measure ensures that the privacy of law-abiding citizens is not compromised and has already been exploited by the federal government. No American should be concerned that the government is employing this scheme concocted by gun control advocates that weaponizes an individual's finances and their free exercise of the Second Amendment to wrongly identify them as a criminal in waiting. Like the FIND Act, our state-level lobbying team has worked with state legislators to enact the Second Amendment Privacy Act, which has been passed in 17 states and introduced in another 8. Unfortunately, we are seeing certain states passing legislation mandating the use of a firearm-specific MCC. These states include California, Colorado, and New York. Now I'd like to pivot to congressional oversight of government agencies, specifically the Department of Commerce, Bureau of Industry and Security, or BIS, and the ATF. On October 27, 2023, BIS implemented a major and unprecedented policy change, halting the issuance of new export licenses for firearms and parts, shotguns, and optics to non-government agencies with certain exceptions at the time of publication for 90 days. In December, a leaked draft final rule showed BIS's so-called 90-day pause was anything but temporary and included even harsher policy and procedural changes that affect those purportedly exempted from the 90-day pause. BIS stated that the pause was to assess and mitigate risk of firearms being diverted to entities or activities that promote regional instability, violate human rights, or fuel criminal activities. A 2023 ATF report proves this wrong. According to the report, between 2016 and 2020, recovered and traced crime guns represented less than 1% of the total firearms lawfully exported out of the U.S. The other 99.33% are not being used in crime and are not ending up in conflict zones used to commit human rights violations. On April 30th, BIS submitted an interim final rule, or IFR, which solidified their 90-day pause and went into effect on May 30th. NSSF estimates the IFR will have a nearly $500 million annual economic impact on the firearm and ammunition industry, directly impacting the U.S. economy and putting many small and mid-sized companies at risk of total loss, as well as putting us at a competitive disadvantage in the international marketplace. The move by BIS was simply just another punitive action by the administration intended to weaken the industry. Several NSSF-supported letters and bills have been introduced to push back against this problem. The Protect American Gun Exporters Act, introduced by Congressman Mark Green of Tennessee and Mike Lee of Utah, was first out of the gate and aimed to prohibit the department's blanket pause and subjects any change in policy to meet the requirements of the Congressional Review Act, known as a CRA. Congressman Mark Green then introduced the Stop the Bureaucratic Ineptitude Shuttering Respectable and Upstanding Lawful Exporters Act, also known as Stop the BIS Rule Act. They like their acronyms on the Hill. The day after the IFR was released, and it would prohibit the use of federal funds to finalize, implement, or enforce BIS's interim final rule. Most recently, Congressman Mark Green, along with Senator Bill Hagerty from Tennessee, introduced House Joint Resolution 164 and Senate Joint Resolution 93 to provide for congressional disapproval under the Congressional Review Act of the Commerce Department's Bureau of Industry and Security's interim final rule that cements the export pause into permanent policy. On July 10th, House Foreign Affairs marked up the CRA introduced by Dr. Green, which narrowly passed along party lines with a 24-23 vote, and now awaits action by the full House. We urge you to call your members of Congress to bring the CRA up for a vote. The final issue I'd like to discuss is ATF's zero tolerance policy, which is another Biden-Harris effort to target the industry they consider the enemy for crimes they did not commit. When they fail in their attempts to ban our guns, they go after those who make and sell them. 3 years ago, under the failed leadership of the Biden-Harris administration and their Department of Justice, ATF adopted this zero-tolerance policy for what they called rogue dealers, forcing ATF industry operation investigators to look for any minor infractions to justify a license revocation, with the hopes of shuttering the doors of businesses entirely. This policy has affected stores ranging from small retailers to big box stores. Many local family-owned retailers are being intimidated by the ATF's aggression or cannot afford legal counsel to take on a federal agency. By and large, these are not major or intentional violations, they are paperwork mistakes. and it's alarming that ATF would escalate paperwork mistakes where no firearm ended up in the wrong hands to the same level as an illegal transfer. Unfortunately, ATF has been turned into a sledgehammer to carry out the Biden-Harris administration's extreme anti-gun policies. The Reining in Federal Licensing Enforcement Act of 2024, or Rifle Act, introduced by Congressman Tracy Mann of Texas, would protect FFLs by clearly defining what constitutes a willful violation, ensures the ATF works with FFLs, giving them a chance to comply before ATF revokes their license, allows FFLs to review and appeal ATF determinations before an administrative law judge, and allows individuals who had their licenses revoked to reapply for their license under the new definition of willful. Additionally, the Fighting Irrational Regulatory Enforcement to Avert Retailers' Misfortune Act, or Firearm Act, introduced by Congressman Darrell Issa of California and Senator Joni Ernst of Iowa, would create a safe harbor for FFLs at risk of losing their license due to the zero tolerance policy by giving them 30 days to correct their mistakes before ATF can initiate an enforcement action, prohibits ATF from initiating an enforcement action on the basis of any self-reported violation, defines willful conduct, and allows FFLs to challenge revocations in district court, bypassing ATF's costly and time-consuming administrative process. While I could spend all day up here addressing the whole government attack on our industry and our Second Amendment rights, I hope that I provided you with a snapshot of some of the work we are doing to push back against attacks on our industry and our constitutional rights. The stakes have never been higher. We are now less than 2 months away from the most important election for the future of the Second Amendment, and what happens in November will dictate what the ensuing months will bring us. NSSF's Protect Liberty PAC was launched to advocate for candidates who will preserve and protect the liberty and freedoms and constitutional rights of all Americans, especially the Second Amendment. If you have any questions on who the champions are, this past week we released our 2024 Congressional Report Card. I invite you to take a look if you have not done so already. NSSF encourages all gun owners and hunters who care about the Second Amendment to contribute whatever they can afford to support Protect Liberty PAC's efforts. Protect Liberty PAC can accept unlimited personal or corporate contributions from non-federal contractors. No amount is too little, and every penny helps. Additionally, with approximately 10 million hunters who are unregistered to vote, NSSF encourages everyone here to spread the #GunVote message to as many gun owners as possible to encourage them to register to vote, and on Election Day, don't risk your rights. To learn more about Protect Liberty PAC and GunVote, please visit protectlibertypac.com and gunvote.org. Thank you for your time, and thanks to SAF for having me to speak to you all.
Awesome. Thank you, Sean. Thank you, Sean. Coming up next, the winner of the first ever Golden Bow Tie Award. And that's pretty cool stuff when you consider Alan Gottlieb, the bow tie, the golden bow tie, the whole deal. Joining us now to talk about the role of industry in protecting freedom is Tom Taylor. Tom is Sig Sauer's Executive Vice President of Global Brand Development. He is the real deal. Tom, welcome to the program up today. Thank you. Green clicker will advance as soon as you're ready.
Thank you, Mark. I can't tell you, last night when they honored me with the first Golden Bow Tie Award, it was quite an honor. Something that's such, when you think about great icons, you think about Harry Carey and the mic and the giant glasses, or Michael Jordan and the Jumpman icon. I think everybody knows what the bow tie means, and Alan, and for the staff that surprised him and me with this, it's such an honor to have this on. Hopefully this icon goes on to be something really special in future years for people who help protect and defend our Second Amendment. So thanks to the SAF staff and to all you guys who support this. So that was awesome. So Sean, great message wherever you went today. But apropos that I'm following him and all the great work that the National Shooting Sports Foundation does. And I hope my message today isn't too elementary for this very educated crowd. But there is such a story beneath the story of how our government's coming after the gun industry. And that's a little bit about what I'm going to talk about today. make sure everything's working. So what is the role of industry in protecting freedom? You know, I think that's something that we have to define every day, because we have a business to run, but we have a Second Amendment to protect. And we have to do both, and we have to balance those two things. So I'm going to walk you through just a few thoughts that we have in terms of what Sig Sauer's role is, and it's evolved dramatically in the last 10 years or so with what Sig Sauer's become in the world of gun manufacturers. And so you can see in this picture, this is our headquarters in Newington, New Hampshire, near Portsmouth, right across the street from Portsmouth, as a matter of fact. But I'll show you in a minute the global presence of Sig Sauer around the world, which is, like I said, grown dramatically in the last few years. But you know, what's the role of the gun industry in protecting the Second Amendment? So just to give you a little bit of a background, SIG has become the largest gun manufacturer in the world. You can see on this map, it's probably a little hard to read, but we have presence in New Hampshire, Arkansas, where ammunition facilities are, Oregon, where our optics facilities are. In those locations, we have 16 locations globally, about 13 of those in the United States, 12 of those in the United States. And notably, did you guys all pick up the bookmark outside, or anybody pick up the bookmark from Silencer Shop? If you look on that bookmark, you'll see the M7 rifle. That's the rifle of the U.S. military now. I don't know how many of you guys know. The U.S. Army, Marine Corps, and so forth, their handgun, their rifle, their machine gun, their ammunition, their suppressor, and many of their optics, all their sniper ammunition, all the suppressors, all made by Sig Sauer. So I'm not sure the world knows that yet, but 500,000 handguns already deployed, and we're now in fill-in in that contract from 2017. And then only last year, we won the Next Generation Squad Weapons contract, which is made in Rochester, New Hampshire, one of the little dots on that map. It's our largest facility. This coming week, we'll be launching a facility in Arkansas that's over 350,000 square feet to produce all the new 6.8 hybrid ammunition and 338 Norma Magnum hybrid ammunition for the light machine guns, medium machine guns, and so forth. So the presence in the United States is significant, 4,000 employees, 30% of the workforce are veterans, 10% of the workforce are engineers, which is how you win a military contract in 5 years without having previously made a machine gun. I do like the 1,000+1 rule for high capacity, but anyway, 1.3 million square feet of manufacturing space, and the most advanced manufacturing facilities in the world in the gun industry, and I think it would rival a lot of other industries where precise manufacturing is required. If you expand that and you look at Sig Sauer's global presence, it's significant. Switzerland, England, India. This company is growing. We have at least 3 or 4 other facilities that are being negotiated right now around the world, and a lot of these global military operations, we must manufacture some of their products in country, and so we're taking measures to do that all over the globe. So it is a significant presence. The gun industry exists in America today to help protect and defend our Second Amendment rights. It is our opportunity and our privilege to make firearms and all the accessories that go with those firearms for hunting, self-defense, home protection, all those things, collecting, all those things that are our given right to participate in as civilians. Furthermore, I just went over the U.S. military, and if you look at a soldier that comes out of the military in 3 years, they won't know another brand if they weren't a gun person prior to their going into the military. When they come out, just like everybody had to have a Beretta M9 or a AR-15 or whatever the product was, when they served, a lot of times they come out and they buy that product. And I think that's going to happen, but it's going to be across all their sidearms, their rifles, on all their accessories in the future. So our presence is going to expand, I think, because of that military presence. And then lastly, and very importantly, you look all over the globe, the Canadian military selected our handguns, the Australian military, the Danish military, special forces units all over the world are carrying MCX rifles. Almost any elite unit in the world are likely carrying an MCX. That evolution has happened over the last 5 years, starting with DevGru and the Navy SEALs, as well as Delta and Ranger units are all carrying MCX rifles at the highest levels especially. So I think we play a very large role in this. I just put up a graphic next to give you, I'm not going to read this off, but you can see on your right, sorry, your left, are all the military units, the government units, government agencies, law enforcement around America that we support. And on the other side is international. You can just look at that list of all the places, and of course the list would be too long to put on, because if you look at this global map, we supply arms to over 90 countries around the world. So SIG has got a very global presence. We're the largest exporter. So to Sean's point about the Department of Commerce and the incredible overreach right now that they're perpetuating, we fight that on a regular basis given our presence around the world. And we take, if people think these guns are going into bad places, the amount of work we have to go through to make sure that they're going to the right place through approval from our very own government, it's ludicrous that they have come at us this way, but it's just another way to try to have overreach and try to prevent us from protecting the world, if you will, and I'll get into that a little bit more in a minute. So if you think about it, the gun industry must protect and defend the Second Amendment. If I change gears just a little bit, the balance, we have to balance those business needs I talked about, because we do need to make money. We have owners. If you don't know the makeup of SIG, a lot of people think it's a German company. Well, it has been a German company. J.P. Sauer & Son was founded in 1751 in Germany. Swiss Industrial Group, or SIG, was founded in 1853 as part of a wagon wheel company that bid on a Swiss Army contract, rifle contract. So the roots go way back from SIG Sauer. In 1975, the two companies came together. The only thing left in Germany are our owners. We have German owners, but everything here, our CEO and all of our operations are based here in America in terms of the manufacturing and all the management work that is done for SIG. So it is an American company in terms of the way that works. And what I think we have to do to protect our commerce and our Second Amendment rights, and it's been talked about, we have to help and defend the world gun structure. We need to be involved in that. We have to defend gun rights around the world in allied countries. I mean, where oftentimes you cannot carry a gun, or it's so restrictive. Maybe you can have one gun or whatever it may be, but it's so onerous to either own a gun or not be able to own a gun around the world, and we have to try to help and defend that. We play a big role there. And then we really have to guard against U.S. government export policy deterioration, as Sean talked about, and it just continues to get worse and worse. And then lastly, there's a lot of work from NATO. A lot of you are familiar with Hillary Clinton's agenda with NATO, essentially trying to de-arm citizens around the world, which would also lead to de-arming militaries around the world, because they go together. All of you who buy guns today are obviously helping fund the 5 years of engineering work that went into this Army contract. Never could have done it without our commercial business and the ability to invest in 400 engineers to have the bandwidth to be able to do that. So that document and that Second Amendment that's pictured at the bottom of this page is something that we have to protect in America and similar rights throughout the world. Who does this impact? This is what it looks like. These are the key players in the gun industry in America, and you'll notice some international companies on this list. Beretta, Taurus is out of Brazil, a lot of countries, CZ out of the Czech Republic, and so on. A lot of these companies are America to the core, and a lot of these companies are global companies, but how are they at risk? Well, they're so at risk that many of these companies, even though they still operate globally, have moved facilities to America. They have to. They have to be able to have the ability to build what they need to build and support law enforcement or military in their own ways that they participate in those things throughout the world. So just looking at the pervasiveness of how many companies are impacted and at risk when you think about attacks that are going to come against the gun industry. So are we at risk? When you think about it, for a long time, the discussion's been about legislation. The NRA has done great work, along with a lot of other organizations, on that sort of legislative side of things. Essentially, right now, we're at gridlock from a legislation standpoint. It's very difficult. You saw some politicians here who are doing great work to try to continue to fight the fight with legislation. So that's something that's getting very dicey. If you look at significant gun protection, gun industry protection, back in 2006, President W. Bush was successful in passing the Protection of Lawful Commerce and Arms Act, which essentially was one of the biggest industry protection moves it was, I would say, in the last 25 years to really protect the industry. Because what's going on right now, as you can see, executive orders. We just had a new one from Biden, whatever that means, because we know it's not him, but whatever it means, it's an executive order. So his offices and his people are doing it. Executive overreach. As Sean talked about, ATF, both ATF overreach and executive overreach. They're not allowed to do this, but yet they're still doing it. And so it's amazing that they continue to just dip their fingers in all these things. And what happens if we're faced with another 4 years of this? They're just testing the water in these 4 years. If we think it's not going to get even worse with just, hey, why not? We're the boss, and we're going to keep reaching as far as we possibly can to see what we can accomplish. And let's just hope that we don't have to deal with that come November, but we'll see how that goes, which is a challenge to us to make sure we're doing everything we can to get people out and go out and participate and promote in the gun vote and so forth. But political gridlock, I mentioned already, it's hard to get anything done through our political means right now, and onerous export policies, as Sean went over before. What do we have to think through? There's very few allied countries who have scalable gun production. Nothing in England anymore. You still have the Czech Republic with CZ, you have Beretta in Italy, you have HK in Germany, you have FN in Belgium. But the ability for them to make and export guns is super difficult for them, and it's why most of them have opened operations in the US. And then you can see from this question, they've all set up major manufacturing facilities here. What does the protection of a civilized world look like without U.S. gun production? Make no mistake about it, they're coming after us. They know they can't necessarily shut us down right now with legislation or litigation, but they're coming at us in so many different directions and ways, and I'll get into that a little bit more in just a minute. What does America look like with continued unconstitutional restrictions or even confiscation? And those words, even though she's downplaying it now, make no mistake about it, Kamala Harris and whatever the machine behind Biden and her is, they are coming after our guns, and they would put confiscation on the table immediately once they're not worried about 4 more years and early in their tenure there. So turn the page just a little bit to litigation, the big picture. Sig Sauer has decided to put a tremendous amount of support behind the Second Amendment Foundation. We've decided they are our best tool right now to fight this, with the legislation side being a little bit stagnant. The litigation side, we're having really good wins, and we're having a lot of really good success with that. So we're going to keep pushing that. If you think about it, between Obama and a win in November, 16 years of Democratic leadership in America. I'm afraid at the end of 4 years, our country is going to be hard to recognize. Let's say it rolls over in another 4 or 8 years. We won't recognize America in 10 years if we can't stop this. And so I think that's some way they're going to be coming after the gun industry. And if they can't do it because of the protections our Second Amendment gives us, they're going to come after the gun industry in various ways. Right now we have a favorable court system, but I think you're seeing hundreds of judges being named by the Biden administration, the Obama administration, and whatever that administration might be in the future if it is so elected. The courts that are helping us win on this litigation side, that balance of power is going to change. And so we have to be very cognizant and careful about that. So more specifically, litigation against the gun industry, and I use an image here. It's like, the old hot coffee at McDonald's. Guy spills hot coffee on himself and sues McDonald's. It's hot coffee. What did you expect? And so the gun industry, in a lot of ways, if without reading all these things, President Bush put the Protection of Lawful Commerce and Arms Act in place. That was to short fuse all the lawsuits that municipalities were suing gun companies for murder. And so, it was just like, let's sue the car manufacturers or the baseball manufacturers if their instrument is used in a death. It's the same thing. So President Bush shut down those 32 municipal lawsuits. We were winning them, but it was bankrupting the industry, even to the degree that the NSSF back in around 2000 had emptied its entire multi-million-dollar war chest, kind of break glass in case of emergency funds. It was gone. So NSF was out of money, the gun industry was running out of money, and it was going to bankrupt the industry had President Bush, to his credit, not stepped in and fixed that. So those things, if you think it's not possible, back around 2000, the gun industry was in a world of hurt financially, and we would not have survived, I don't think, in the same way as we are today without President Bush putting that in place. So before I wrap up, I want to talk about just a couple more things. Some of those things that we're having to fight against are frivolous lawsuits. Anybody read stories about P320s that go up by themselves? So we are 16-0 in court. We have another 50 cases that we're going to have to defend. We decided we're not going to settle after some early settlements before we realized what this was going to turn into. What it turns into is negligent gun handling. If you think that our guns aren't being tested beyond belief in terms of, and I'll wrap up, I know we're running out of time here, but if you think our guns aren't tested beyond belief by the US military, by the Australian military, the Canadian military, and all these people, law enforcement agencies, we just won the Texas State Police and Texas Rangers going all SIG, handguns, pistol optics, red dot optics. If there was some way that our guns could go out by themselves, we'd find it. The reason we're winning these lawsuits is because no one's ever been able to replicate a gun going off by itself, and no one's ever even offered a theory as to how this can happen. What's happening is unsafe gun handling by, sort of say it, generally law enforcement who are ill-trained in most cases around the country. The only loss that we've had, the 16 cases, 1 jury trial and 15 dismissals, the only loss we had, they backed off from my gun went off by itself, and they sued us in a very favorable court that our gun went off easier than a gun without a tab trigger. Well, if you know anything about a gun, a tab trigger is not about trigger safety, it's about drop safety. And so they're going to continue to come at us. They're finding lower burdens of proof, and we've spent tens of millions of dollars protecting ourselves against these lawsuits. So there's a lot of things, and the other way they're going to come at us, we do a lot of advertising promoting the fact that we've won these military contracts, because I think it gives you all confidence to know that this is what our military uses, and these same guns are the guns being made for civilians and other forces and civilians throughout the world. So we know our Congress has already had a congressional hearing. We did not get pulled into that one, but we are going to. Other companies like Smith & Wesson and so forth, they kind of stayed away from us because of the military contract, but they are going to come after us for our marketing practices. So we absolutely know that's coming. And we're going to double down on that. I want to roll a video real quick and show you a little bit of our mindset behind how we're going to market our products with confidence that it's used by the U.S. military. And take a look at this video to show you another way that we want to promote and protect our Second Amendment and sell guns at the same time.
As Americans, we have always despised tyranny. Our freedoms, cast on an altar of sacrifice, were born from a desire to unite. Those freedoms have been challenged before, yet they have stood the test of time. Today, our freedom is once again in question, and its future is not promised. To those who may deny and restrict those freedoms, we say only this: shall not be infringed.
So we are not going to back down. We're trying to be prudent and smart, but we're not going to back down from this because these are our rights. It's our right to make guns for civilians. It's our right to make guns for militaries in the U.S. all over the world. And it's our right to promote it this way to protect our Second Amendment. And that's the way that we're balancing this. And the last thing I'll say to you is, as I put the image up here of Paul Harvey, I think looking at the hair and scalp and such around the room like me, we all know who Paul Harvey is, and he was famous for saying the rest of the story. I remember listening to Paul Harvey in my dad's Galaxy 500 when I was a kid and a young teenager driving around with my dad, and always challenged the rest of the story. And we got to get out and vote. We got to understand that these laws may not be only intended to restrict our personal rights and freedoms that we have with the Second Amendment, but make no mistake about it, they are coming after the gun industry. So thank you for your time. We appreciate you all being here and being so focused on this effort. So thank you very much.
So that's the real deal. How many people in the room have ever been to the SIG Academy? Okay, so you know. I would highly encourage you, if you've never had an opportunity to go up there. Personally, I'm very proud to have been partnered with SIG, and you see what they're all about. They are the real deal. And make no mistake, if you go up there, you got to go to the River House and get the chowder. It's the best you've ever had. That much I can promise you. Charlie, could you hand me the sheet, please? How many people in here own or have shot suppressed weapons? Suppressed weapons? Aren't they great? Yeah, you live in California, okay. You got to travel to do that. I love shooting suppressed weapons. I do not own a suppressor. I'm asked that all the time. I've been very, very hard on the ATF on my national radio show for years. Personally, I think they suck and they're a bunch of punk thugs, and I make that very clear. And I really don't want to tangle with them over the suppressors. It's not worth it for me. But I have lots of friends that have them. So to talk about silencers and the Second Amendment, Chris Boeck, who's the general counsel of Silencer Shop, great company, Knox Williams, president and executive director of American Suppressor Association, and Owen Miller, the vice president of American Suppressor Association. Guys, come on up. You've each got a mic, and you have 30 minutes. I'm just going to turn it over to you. Guys, own it. Okay? Clock's in front of you. You guys have a great time. Mark, what a pleasure to meet you. Pleasure. Thanks for being here, guys. Enjoy.
I kind of wish we had some like WWE walk-up music for that and just dun 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 dun. Yeah, my name is Knox Williams, longtime listener, first-time caller. But he actually stole my thunder. He asked one of the questions that I was going to open up with, which is, how many of y'all have shot suppressed before? So it's a lot of y'all in the room. And a follow-up question to that is, who can tell me the difference between a silencer and a suppressor? All right, I heard a unicorn, I heard they don't exist, and I heard the same thing. And whoever said the same thing is spot on. Silencer, suppressor, muffler, moderator can, call it whatever you want. It really doesn't matter. At the end of the day, we're arguing about semantics. It is a device that makes a dangerously loud noise from a gunshot less dangerously loud. It also makes shooting a lot more fun. There's a ton of benefits to them. But at the end of the day, don't get tripped up over the semantics because we are talking about the same thing. I'll tell you what they're not. They are not James Bond, right? People that tell us that, you know, they know what a silencer or suppressor sounds like because they've seen it in the movies. You know, it's about like saying, well, I know what dinosaurs are like because I've seen Jurassic Park, right? It doesn't make any sense. Hollywood is not somewhere that we should go to look to be the arbiter of truth or where we derive our facts from, but so many people do. To the point, in fact, where the Trump administration earlier this spring commissioned a small study to see where suppressors were polling, and they found that 80% of the respondents had a negative impact or a negative opinion on suppressors because they've never been exposed to them. Now, we've done a good job of exposing the gun community and the gun world to suppressors over the past 15 or so years, but Americans at large still hold a disfavorable opinion on suppressors. So really, what is it that we're talking about for anybody in here that's never seen one, that's never heard one, that's never shot with one? It's a device, generally a cylindrical tube that you affix to the end of your firearm that basically operates like a muffler for a gun. In fact, the gentleman that invented it back in 1908, 1909, also was one of the early inventors of the car muffler, right? He's just a dude that hated loud noises, and God bless him for it because I share that sentiment. There's a tremendous amount of benefits to using a suppressor. Chief among them is going to be hearing protection, and we're going to dive into that. And many of these actually stem from those same benefits. All right, by show of hands, who in here has ever shot a gun without hearing protection? All right, one more follow-up question. Who in this room has hearing aids? It's a lot of the crowd, right? We don't often think about protecting our hearing, which is one of our 5 senses, when we think about things like home defense. But any single shot exposure to a gunshot can and will lead to permanent hearing damage. And if you don't believe me, take it from the experts. According to Dr. William Clark, the lead audiologist at the University of Washington School of Medicine, this is a direct quote from a peer-reviewed study that he put out. The most serious threat to hearing comes from recreational hunting or target shooting. Home defense is no exception to that. You don't get a pass just because you're shooting someone in your home trying to protect yourself and your family. According to the National Hearing Conservation Association, persons wearing conventional hearing protection are not without risk of noise-induced hearing loss when using firearms. Therefore, the National Hearing Conservation Association supports the use of firearm noise suppressors as a form of an engineering noise control to reduce hazardous firearm noise exposures. Now let me go back. When you're in a deer stand, when you're out hunting, when you're in your home, doesn't matter what you're doing. You can be on the range, you can be anywhere. If you're not taking active steps to protect your hearing, you will permanently damage your hearing. And once it's gone, it does not come back. But that's a lot of doom and gloom. What else makes suppressors great? Yeah, they're quiet, they're fun. And what else? What are some of y'all's favorite parts about suppressors? Recoil reduction, bingo. Recoil reduction is huge, especially when we're talking about introducing new shooters to the shooting sports. And when you think about it, when you pull the trigger on a gun, you're basically using that barrel to contain or to project a projectile, but it's a controlled explosion that's happening within a couple feet of your face. That is very unnatural. So how many of y'all have ever accidentally dry fired? You think you've got one racked up, you go to pull the trigger, and it clicks. What happens most of the time, at least to me? You flinch. Yeah, you flinch because you're anticipating that recoil and you're anticipating that loud concussive noise. Well, suppressors reduce both of those tremendously. And by doing that, it allows people to get more comfortable with shooting and focus more on the fundamentals like proper sight alignment, proper trigger pull, making sure that your fundamental mechanics are way more sound. And it makes you a better shooter. And honestly, for us, it spoils us, right? We don't shoot without a suppressor unless we legally cannot shoot with a suppressor like here in California, which is unfortunate. Another side benefit to it is reduction in noise complaints. Shooting ranges across the country, especially outdoor shooting ranges, are being absolutely inundated with noise complaints. And suppressors are one of the only ways that you can actually reduce the noise exposure, extend shooting hours for ranges, for places where people like to hunt. It really is a tremendous, tremendous tool overall to improve not just the shooting sports themselves, the exercising of the Second Amendment, but also to be good neighbors, which is something that we as a community need to prioritize. Because at the end of the day, there are more people in this country that don't regularly shoot than do. And for us, we've got to make sure that we are putting our best foot forward, and we believe that suppressors are one of those tools that can really help do that. When you talk about hearing protection, you really should be pro-choice, right? Not to get too political on this one, but suppressors are one of the tools in the toolbox that can help mitigate noise-induced hearing loss and tinnitus, which is the ringing in your ears, as are earplugs and earmuffs. Everything has its own inherent pro and con, suppressors being the only tool that actually reduces it at the source. And I could spend an hour talking about the differences between the various types of hearing protection. I'm not going to bore you with that because we've got a lot more to talk about, a lot more interesting, juicy stuff as it pertains to the Second Amendment. But bear in mind that they are all tools that should be used together in much the same way that you buckle up your seatbelt when you get in a car, even though it has an airbag. A layered approach provides far more protection than an individual approach on its own. And with that, I'm going to pass it over to Chris Bowick.
Hello. Yeah, let's talk about the Second Amendment for just a bit here. And before we get to the slide, I want to step back and just recognize that right now we are living through a Second Amendment renaissance. What we've seen from Heller in 2008, where the right was decided to be an individual right owned by or possessed by individual citizens without regard to their interaction with militia, to 2010, McDonald extending that to the states and saying not only can the federal government not infringe on your Second Amendment rights, but the states can't either. And then, of course, 2022, we had the landmark groundbreaking decision in Bruin, which I'm sure we'll hear a lot about today, where the Supreme Court changed the very test that courts have to look at when trying to decide whether or not a statute is constitutional or not. Before Bruin, we had this balancing test, a means-end scrutiny test, where the courts would balance how much the government didn't want you to have the firearm with how much people do want the firearm. and it essentially was manipulable. The courts could reach whatever conclusion they wanted just by putting their fingers on the scale. In 2022, Bruin said that's not the test. You can't have that be the test. So now we have the Bruin test, which is the item, is the conduct or activity protected by the Second Amendment? If yes, then you go on to the second part, which is there a history and tradition of restricting your Second Amendment rights that can be shown at the time of the founding of the Second Amendment? And if not, it's an unconstitutional statute. It's a game-changing decision, and we're living through that right now. The momentum that was building up from Heller through McDonald to Bruin accelerated. It accelerated with Bruin, and we're seeing at this point the edges and the boundaries of what is the new shape of the Second Amendment being tested. So Heller, McDonald, and Bruin, they gave new shape to the Second Amendment, new definition to it. What we're seeing now are the courts looking at the edges of that shape. And one of the questions that they have to deal with is what rights, what corollary auxiliary rights are necessary for the fundamental right of being able to keep and bear arms to be meaningful? What additional rights are necessary? Up on the screen here, you can see a few examples. The right to purchase a firearm is a necessary right. It's an auxiliary right, but without it, the ability to keep and bear is essentially meaningless if you can't buy it. And we're seeing some cases where cities have tried to rezone through zoning ordinances so that you can't put a dealership, a firearm dealer anywhere in the city. You've got to drive outside of the county, outside of the state even, to buy a firearm. And the courts have said, no, you can't do that because access to a firearm, the ability to purchase it, that's necessary for the Second Amendment to be meaningful. Ammunition. If you don't have bullets, if you don't have ammunition, what does it matter if you can keep and bear a firearm you can't shoot, right? So there are definitely things on the edge that are not just on the edge and superfluous, they're meaningful, right? What I want to talk about today is the tools that are necessary and the activities that are necessary to be able to make keeping and bearing arms meaningful. So one of the things that a responsible gun owner will do is go to the range, become proficient with their firearm. If you don't know how to use your firearm, if you've shot it once when you bought it from the shop and then you put it in the safe and you haven't shot it for 10 years, it's not going to be nearly as useful to you. It's not going to be nearly as safe when you use it, right? So becoming proficient is important. That's why we've seen some cases where courts have said you can't outlaw the firing range. That's an important part of the Second Amendment, is the existence of firing ranges so people can become proficient with the firearms that they possess, right? This is another corollary right that is buttressing the Second Amendment. Silencers are like that as well. If you want to go to the range regularly and become proficient and practice, not just once, not just twice, but regularly, periodically, go back and refresh your memory, keep those skills honed, that takes a toll on your hearing, even with earmuffs. So you can't really do that and become proficient over time without having silencers, without having access to dual hearing protection. So Silencer Shop and the American Suppressor Association are funding a lawsuit in federal court in Illinois. It's Anderson versus Raoul, and we have aspirations to bring similar lawsuits in California and New Jersey, but we are challenging the state's ban on suppressors. And our argument is simple. Silencers are protected by the Second Amendment, and there is no history or tradition in regulating these types of devices, these types of safety and efficiency devices for firearms. And you might say, well, silencers didn't exist back in the founding times, but there were actually corollary items such as the flash guard they used to have on muzzles or muskets on the flash pan, where the initial charge that ignites the powder within the barrel, that initial charge is a fairly bright, powerful flash, and they would fix the pan in a way that it would redirect some of that away from the shooter and away from the people that are right next to the shooter. It was essentially a historical flash guard, and there was no statute that prohibited that. They were regularly available, and there are no statutes in the history of the United States that have prohibited that type of equipment, that type of safety equipment, until very modern times. So the state has pushed back with a couple arguments. Number one, they say silencers don't shoot bullets, guns shoot bullets. So silencers are not bearable arms. What a ridiculous argument. If you take any piece, any single piece of the firearm and ask, does it shoot a bullet? The answer is no. Even the trigger doesn't shoot a bullet without the rest of the system. Firearms operate as a system, as a platform. The silencer is just one part of that platform. The other argument they make is that even if maybe it's incorporated into the firearm, it's still not intrinsically necessary for self-defense. And that's also kind of ridiculous. One of the things that Knox talked about early on is the idea of using it in self-defense. Put yourself for a moment in the uncomfortable position. You're in your home, you've got your family, it's dark, the lights are out, everyone's asleep. You hear somebody come in, you've got to potentially use your firearm. You reach for your firearm, this is your home defense weapon, whatever you've selected to be your primary home defense weapon. Are you also reaching for your earmuffs? Probably not, right? And even if you were, even if you had access to your earmuffs, would you want to wear them in that particular context? So you can't communicate as well with your spouse, you can't see or you can't hear where your children might be, you can't hear where the intruder is coming. You want to be able to be aware of your surroundings. Having a silencer that is already attached to your firearm, you pick it up, it's already there, you don't have to think about it, you don't have to do anything, it's already on there. It allows you to communicate with your spouse, with your family, and that's before the first shot. If you have to take a shot, your ears are going to be ringing, your night blindness or your night vision is going to be completely gone. The silencers mitigate that. They allow you to be able to continue to hear after that first shot, continue to see after that first shot. So you can tell where your children are. Are they coming down the hall? Where is the person who's not supposed to be in your home? Where is he right now? So it's a critical component of home self-defense in that scenario. Same is true when you're hunting. Do you want to be wearing your headphones for 2-3 hours while you're waiting for that perfect shot? Or do you want to be able to enjoy your natural surroundings and talk with your hunting buddies or listen for other hunters who might be coming through the brush so that you know where they are and you're aware and it's safe? These are the opportunities that silencers have to make firearm use and ownership safe and effective. And we talked about recoil reduction, the ability to control your shots. All of these things are connected with exercising your core Second Amendment right to use firearms safely. So we're excited, we're optimistic about this case. We are currently waiting to see how some of the other related cases in Illinois come out with regard to assault weapons and high-capacity magazines. So we're waiting to see how that turns out, but we're optimistic and we're ready to bring these cases here in California as well.
So like Chris said, we're incredibly excited by the proposition of litigation. And much like the Second Amendment Foundation, we hit a point organizationally where we realized our state level efforts to try and make suppressors legal in all 50 states were running up against an anti-gun roadblock, where the likelihood of us actually affecting change became effectively zero. Over the years, we've identified two primary state level objectives. The first is to legalize their use to own and possess, and then their use in the field while hunting. And those are two very separate issues that oftentimes, can be regulated by very different laws or regulations. But at the core of our organization within the American Suppressor Association, this is what we set out to do when we formed back in 2011. We actually formed the organization because I live in Georgia. I wanted to be able to hunt with a suppressor, and you couldn't do it at the time. And I just didn't think that was good enough. We approached some of the NGOs in the Second Amendment space and said, hey, will you help us? And they said, it's too extreme. And we said, roger that, we're going to do it anyways. And we have since created very good working relationships with those organizations and partnerships that have lasted over a decade. But over the years, we've done a lot of work all around the country trying to push pro-suppressor reform at the state level. 35 different states that we have set foot in, that we have pushed, sponsored, drafted, helped promote, whether it's for ownership or for hunting. And we've got a pretty good track record of it. Back in 2011, this is the map of legalities. You could own a suppressor in 39 states. you could hunt with a suppressor for any game animal in 22 states, and then you had Louisiana and I believe Montana, where you could hunt certain animals that were non-game animals, but certainly not everything. Fast forward to today, you can own a suppressor in 42 states. We helped Iowa, Minnesota, and Vermont all legalize suppressor ownership. You can hunt with a suppressor in 41. So we helped 19 states change their laws when it comes to suppressors and their use while hunting for an issue that was too extreme. It turns out it's not. It turns out it's common sense, and it turns out that this is one of the few issues within the Second Amendment fight that has true objective data on our side. Obviously we support the Second Amendment wholeheartedly, fervently. We are among the groups that are at the vanguard of the fight, and we believe in it. But we are lucky in that we have scientific data that can support that A, suppressors make shooting safer, and B, they don't actually silence anything. It makes it just a less dangerous experience and a lot more fun. But anyways, part of what we are so excited about with the litigation is the opportunity to break that logjam, to make these things legal in all 50 states. California, Hawaii, Illinois, New York, New Jersey, all these anti-gun bastions, we can crack through that. And we believe that litigation is the path to success there. To that end, we can't thank Silencer Shop enough for contributing. These guys put in $350,000 to help us get that lawsuit filed in Illinois. Ask the Second Amendment Foundation, litigation is not cheap. We've got about $1.25 million that we're trying to raise so that we can file similar lawsuits in New Jersey and California. And our ultimate goal is to petition it up to the Supreme Court and have them rule that suppressors are in fact covered by the Second Amendment. If we are successful with that, they will be legal in all 50 states, and no state government nor the federal government would ever be able to ban them, which would be an absolute game changer. All that's for nothing if you can't actually buy a suppressor, though. So I'm going to hand this little clicker back to my good friend Chris, and he's going to tell you what that looks like.
Okay, real quick, let's talk about what it takes to get a suppressor. How do you go about buying one? You're going to have to file a Form 4 unless you're a law enforcement agency or have a firearms license. If you're a regular individual and you want to buy one, you have to file what's called a Form 4. It requires fingerprints, photograph, and a few demographic information questions, which you can provide to Silencer Shop. One of the things that we will offer is the ability to gather all of the information together. Let me skip forward here. We've got thousands of dealers. I think we're at 6,000 currently, roughly, nationwide, powered by Silencer Shop dealers. We've got thousands of kiosks across the country, and you only have to visit a kiosk one time. Put your fingerprints in there, then it's stored electronically. It's fantastic because at that point you can go back to your couch and do everything else from your own home. You gather your information. We have a compliance team at Silencer Shop that will review it and make sure that everything is there and in the format that we know ATF likes it. We work with your selected dealer. You have to select a local dealer in your state to pick up the firearm from, pick up the silencer from. And we will work with that dealer, help them get through the certification process. And we've got software that automates it, and we've got software that lets you log in through the ATF's website and certify from your own home. You can even do it on your phone at this point. So certification from your couch is a thing. And now I'd argue is the best time to buy a suppressor. And I know as a silencer salesperson I'm supposed to say that, but it is ridiculous how much easier it is today than it was a few years ago. There's two big contributing factors. One is that eForms is up and running through ATF system, so that allows you to do all of your submission remotely on your couch, on your phone. The second is that sometime this year, in 2024, ASA, working closely with ATF, got them to change their policies, change their procedures, and implement some common sense process changes that went, I'm going to put this up here, caused the wait times for suppressors to drop from historic averages of around 6 months, 8 months, 10 months. Sometimes it was over a year for ATF to approve your form, down to, I think it shows 9 days on there, and that's not even accurate. As of today, it's about 3 days. There you go. I'll tell one quick story. One of my good friends who works with us, he's one of our lobbyists, and he's a great guy, great father. He's taking his daughter hunting for the first time today, and he told me they had a 308. I said, has she ever shot a 308? That's, you know, and he said, yeah, she can do it. I said, let us set you up with a silencer. So we got him a silencer, and this was last week. And he thought, there's no way we're going to be able to get it approved in time. 20 hours. He got it approved in 20 hours, less than a day. So he was able to get it sighted in. She took her first deer this morning. He texted me. She's so excited. And beautiful picture. So, now is the time to do it. We've got new technology. We've got 3D printed silencers. They're doing things with gas mitigation that has never been possible before. So it's a really interesting time to be in this industry.
Guys, and I got to brag on the guy to my left right here. If you don't know his name, you should, because if you're interested in buying a suppressor, he is one of the main reasons why you can get it faster. His name's Owen Miller. We've been working together for 7, 8 years, 10 years, I don't know, a lot of years. And it was his relationships with the ATF that really helped us bridge that gap. There were a lot of things that had to fall into place. The stars had to kind of align, but Owen was one of those integral stars. So for the fast transfer times, if there's one person outside of ATF that is responsible for that, it's this guy right here.
Thank you. And that brings, thanks. That brings me to my part in the presentation. So thank you, Knox, for that recognition. It was an honor and a pleasure to do it. I'll give you a little bit of background on myself. So I bought my first suppressor in about 2000, 2001 timeframe. Had a chance introduction at a shooting event to suppressors. I lived in Washington State, which if anyone here, I know some of the staff folks are from Washington. We had a weird mismatch in state law where you could own a suppressor in Washington, but you couldn't use it there. And that was for about 10 or 11 years after I bought my suppressor. Every time I wanted to use it, we had to go to Oregon. And so in 2000, looking back at some of the data, when I bought my first suppressor, there were about 85,000 suppressors registered in the US. So from 1934, when they first entered the NFA realm, to 2000, so 66 years if my math is right, 85,000 suppressors. In 2011, when the ASA was founded, that number had climbed to 285,000. So in about 10 years, we added about 200,000 more to the registry. This month, the registry will cross 4 million suppressors. So yeah, ATF.
How's that for common use?
Yeah, exactly. How's that for common use? So suppressors have grown in popularity immensely in the last few years. ATF went from receiving 7,000 or 8,000 total applications of all types, tax-paid transfers for suppressors, tax-exempt transfers for machine guns. They were getting about 5,000 to 7,000 of those a year. They now receive about 20,000 tax-paid Form 4s a week at ATF. And they're able to do the processing in 9 days still. So that is what we as an organization pushed for many, many years, was to bring them into the 21st century in terms of processing, and we're very pleased to see it happening and to work with partners like Silencer Shop to see the tremendous growth that's taken place in the suppressor industry. So that's all I have.
Yeah, I think it shows that we have 2 minutes and 23 seconds on the clock. So are there any questions before we wrap this one up? Yes, sir.
Maybe briefly discuss the idea of suppressors and those urban shot detection systems.
Talking about ShotSpotter? Yeah, where David Chipman was on the board. For those of y'all who aren't familiar with David Chipman, he was the thankfully unsuccessful nominee to be the ATF director, who was just an absolute anti-gun zealot and was the lead lobbyist for the Giffords Group. ShotSpotter is basically microphone arrays that they put out in urban areas that cost tens of millions of dollars and really don't work. But back in 2017, when the Hearing Protection Act, which is the legislation that we drafted, was hot and heavy and working its way through Congress. The Washington Post actually did a fact check article on suppressors and like the reality versus kind of the political talking points that the anti-gunners were putting out. And they interviewed David Clark, who was the CEO of ShotSpotter, and said, hey, can ShotSpotter detect suppressors? And he, on record, said, yes, our technology can detect suppressed gunshots. So we have tried over the years multiple times to reach out to them to see kind of, hey, can we test this stuff? Can we work with y'all? And like, absolute crickets, as one would expect with a guy like David Chipman on the board. But according to them on record, it is something that can be heard. Don't know. So there's been several municipalities that have been dropping them, most notably the city of Chicago recently dropped them. And that was one of their biggest clients. But I honestly don't know the answer to that. Yes, sir.
Good. I know you guys have a lot of questions, but we have to stay on time. We've only got 30 seconds. So if it's okay, I'm going to ask people to corner you guys out here, and you're going to get hammered because I have questions too for you. So we're going to have to fight our way through, but great stuff. I appreciate it. Guys, if you have questions for them during the breaks, please reach out for them. You'll see them floating around, okay?
Thank you.
Thanks, guys.
There you go.
Thank you, guys. Appreciate the crap out of it. I do have a lot of questions for you guys. Here. You can just set them right back on the table. Thank you so much. I have questions for you guys. Cool. Thank you, guys. Yeah, like everybody else, I have a ton of questions for them as well, too. All right, guys. Threats from within, assessing the risk and creating a response plan. Sarah Albrecht, founder and executive director of Hold My Guns. Sarah, shouldn't that be Hold My Beer? I'll take guns and beer. Sarah, thank you. Welcome. Have fun.
Thank you.
Clock is ticking when you start.
All right. Good morning, everyone. Doesn't it feel like liberty in here? Yes. As soon as I got to the Gun Rights Policy Conference, I knew that I was at home and I was with like-minded people. And in a moment, we're going to be talking about assessing risk and creating a response plan. But before we do that, and this is important, I want you to hold on to this feeling of what liberty feels like. It is refreshing. It is not an escape from the world. It is a reminder of what it should feel like. This is our baseline right here at GRPC. Like you, one of the concerns on my mind right now are the recent executive orders, which are filled with egregious infringements. Did anyone see those coming in, the executive orders? When I called my husband Tom to let him know that I had arrived safely in California, he gave me some encouragement, and he said, Sarah, imagine if these executive orders came out and there was no such thing as Hold My Guns. Imagine that these red flag laws and federal funding for them were in place, but people did not have a plan to store their firearms voluntarily. He reminded me that through principled leadership and equipping people to practice self-governance, that Hold My Guns has effectively neutered red flag laws. Thank you. And I was so grateful for his encouragement. He reminded me that our collective mission, and I mean the mission of everybody in the room, all the different organizations that are represented here, is to meet the needs of our community in a way that does not infringe on rights. We are all dedicated to this collective calling. Do not let anyone tell you otherwise. The firearms community is a protective factor. Protective factors are the strengths, resources, and support in individuals, families, and communities that help people cope with stress, reduce the impact of risk factors, and contribute to positive outcomes. He said, Sarah, imagine if these, well, I'm sorry, I printed it twice here. All right, before I move forward, I want to draw your attention to the personal response plan that's in your welcome packet. Do you guys see that? Some of you have them. They're handing them out at the front desk. And if you look at the bottom of the second page, there's a QR code, and you can learn more about the mission of Hold My Guns. It's not really the point of my talk today, but it's on here, and we have a booth right out through these doors, and I'd love to see you afterwards to answer your questions about it. Go to that QR code and send me your email information and we'll stay in touch. But I do want to say that I founded Hold My Guns in 2018 when our family lost an 18-year-old friend to suicide by firearm. My teenagers, who are now adults, grew up in shooting sports. We have a distinguished expert, 2 experts, and 2 sharpshooters. And when their friend died, they came to me and they said, "We love liberty, we enjoy firearms, but we really miss our friend. And how can we help people in our own community who are going through a crisis?" And when your kids ask you a question like this, you find a solution. And what I realized was in Pennsylvania, as is the case in many other states, that it's considered an illegal transfer to simply give a firearm to a friend to hold. And that's assuming that everyone has a friend or family member who can legally and logistically store firearms in times of need. And I can tell you that there are many people who don't have someone in their life like that. But I thought back to the concept of protective factors, and I realized that our community is equipped to help. And so I decided to reach out to Joshua Prince. Many of you guys know him. He's a phenomenal attorney in our firearms community, in our Second Amendment community that stands for rights and does so in an amazing way. And I shared with him the idea to create a voluntary firearm storage program through partnering FFLs. This was back in 2018. It had never been done before. I worked with Prince to develop a process for custodial storage that protects the liability of gun shops while at the same time protects the privacy and rights of gun owners using this service. Since then, Hold My Guns has grown to 9 FFL partners in 8 states, and our work is considered the gold standard for voluntary off-site firearm storage. We don't ask why the firearms are being stored, but I can say that our program supports gun owners for many different reasons. Anything from deployment to a long-term work obligation to helping people through a difficult divorce and even a mental health crisis in the home, even if it's not the gun owner but another household member. And the mental health crisis, the latter reason, is the focus of the rest of my talk today. As a range safety officer, I have heard 2 phrases over and over again used to motivate students to train for defensive gun use situations. And I'll bet that these phrases are ones that you're familiar with too. You ready? You can help me fill these in, okay? Nobody is coming to save you. Nobody's coming to save you, right? Yes, that too. How about this one? You better get this one right. I am my own first responder. So with this frosty mindset in place, how can you be your own first responder when the threat is not a criminal in a parking lot, but it is the mental health of yourself or someone you love? The majority of all firearms-related deaths are suicides. And according to CDC statistics in 2021, 54% of all firearms-related deaths in the United States were suicides. Now, these statistics, of course, are weaponized to promote red flag laws and gun control. And therefore, it is so critical that we learn to address the threats from within so that we can reduce these numbers and we can be effective to save lives, protect property, and preserve rights. And this starts with you, and it starts with me as well. But this can be very painful, which is why people don't like doing it. When it comes to practicing situational awareness in our own home, we have a blind spot. We don't want to admit that the problems in our life are as bad as they really are. We kind of have some cognitive dissonance about it. And a moment ago, I talked about protective factors. Now let's talk about some risk factors, conditions or traits that increase the chances of negative outcomes, and in this case, including suicides. When we stop and think about the things going on in our home, relationships and conflicts maybe, health issues, grief after the loss of a loved one, the demoralization from dealing with an administration that doesn't seem to care about our rights, divorce, kids falling through the cracks during COVID, maybe struggling with a drinking problem, PTSD, loss of a job, being not able to make ends meet. These are just a few things that are risk factors. But yet, as we listen to this list, all of these risk factors are somewhat common, aren't they? I'm sure that you or someone you know have experienced at least one of these things once in your lifetime. For many people experiencing these difficult situations that contribute to these negative outcomes, the protective factors, including the support of our firearms community and voluntary storage through Hold My Guns, can outweigh the risk factors. There is hope. You can have a laundry list of risk factors and one or two good protective factors that will help you keep choosing life each day. And so how do we determine how bad these risk factors are and how much they're affecting our lives? That's where assessment comes in. And not only in our lives, but in the lives of the people in our homes and the lives in our circle of friends, maybe people who we are at the range with each day. And as we get to know them, we hear about these things. Threat assessment requires one key thing, and that's my main point. This is the best way to assess risk and how bad it is, and that there is a baseline for what is normal. When I'm working as an RSO, there is a baseline on the range. The baseline is what? It's safe handling of firearms. People who are there are generally in a good mood. They want to be there. They're excited to be practicing. They're excited to be hanging out with their friends. But what happens when the baseline changes on the range as a firearms instructor or range safety officer? You see someone who seems to be struggling, and you immediately walk over because there's been a change of baseline, and you offer to assist. Can I help you load your firearm? Do I need to help you clear a jam? So, the baseline in this room is someone who loves liberty and someone who's interested in actually being here. We appreciated that feeling at the beginning of my talk. But if we saw someone who came in protesting gun rights, we know that there was a change to the baseline. Applying this defensive concept of situational awareness to personal situations is key. We can be aware when there is a change of baseline when we hear verbal cues like negative self-talk or how people around us are talking about themselves. And that is an indicator that we need to refer to that personal response plan. Phrases like, "It should have been me and not my partner who died," or "I feel like giving up," or "No one would miss me if I were gone." These are indicators that the level of risk has gone up. Changes in baseline can also be situational awareness, I want to say situational awareness, it rolls off the tongue, situational in nature, such as the loss of a loved one, losing one's job, losing one's pet, or receiving a difficult medical diagnosis. In our community, we pride ourselves for being prepared and having it all together, but sometimes circumstances can blindside us. Someone who has a strong mind might not outwardly complain or leave verbal cues, but we might look to the situational cues as an opportunity to reach out. Unlike those who think that gun control is the answer to everything, practicing self-governance in our community means being purposeful, to be compassionate, and to provide care that does not compromise rights. It is helping to increase the protective factors in the situation. What does that look like practically? It means proactively reaching out to a friend and saying, "I heard that your wife passed away suddenly. Our family is so sad to hear this, and we want to invite you over for dinner." Noticing behavioral clues are another example of how to assess risk. Examples of changes in baseline by noting behaviors like giving away prized possessions, drinking more, insomnia, irritability, the avoidance of people or things that are normally comforting. Again, these are opportunities to refer back to your personal response plan to know how to respond. But the best tool that we have to assess the change of baseline is when we reflect on how we feel when things are actually going well. And filling out a personal response plan proactively, not waiting for a crisis to hit, is the best way to ensure that your values are not compromised even if you're experiencing a crisis. So step by step, write down your values, the indicators that you might need to seek comfort measures and protective factors. A personal safety plan puts you in the driver's seat and not along for the ride. It gives you personal agency. You would not give your keys to someone who you didn't trust, right? And so having your trusted list of resources ensures that you have congruency of care even in the middle of a crisis. And that is how you're your own first responder when the threat is coming from within, by taking a principled, proactive approach to create a plan that you know is going to be followed. Having a personal response plan is the secret weapon to making sure that your values and agency are honored. You'll notice that there's a section in there for firearms and other lethal means. I encourage you to write down a plan for what to do with your firearms. Maybe you'll never even need it. But if you ever do, please consider looking up a Hold My Gun storage location. As we all arrived at the conference, it's on the heels of these pervasive executive orders. But the reality is that when we follow a personal safety plan or personal response plan, it really doesn't matter who's in the White House, because when we practice self-governance, we become ungovernable and our rights are preserved. Thank you. Afterwards,
Thank you, Sarah.
Yep, afterwards
stuff.
I invite you to come out and visit me in the hall at the Hold My Guns booth, and also check out our new sponsors, Boss Lock. They're running a great special for GRPC. Thank you.
Thank you, Sarah. Wonderful stuff. That was awesome. Thank you very much. Guys, I know we're about 10 to 12, maybe 15 minutes behind schedule. We'll pick that up during lunch. Real quick, public service announcement. This was left over at AmCon. If anybody's missing a cover shirt, anything like that, you can pick it up here at the table. And they wanted me to remind you that the actual lanyards, if you want them, are out there at that table, okay? This man, I don't need any paperwork to introduce this man. Massad Ayub is a dear friend of mine, long-term friend of mine, and gave me, I have to admit, one of the funniest moments I've ever had on my radio show. If anybody's ever heard the beer mug segment on my show with Massad Ayub from 2011, it was absolutely hilarious, and it's a classic every year. Massad is here to tell us about how to appeal to emotions in the argument for the Second Amendment. The godfather of self-defense himself, author of In the Gravest Extreme, Massad Ayub. Thank you, Massad, for being here. We appreciate it.
Oh, good morning, team. When I hear an introduction like that, I always want to go like this. You know, it's too deep for the boots, but at least I can save the watch. Sociologists have said that our fight, the gun control debate, if you will, is tied with the abortion issue as the most polarized debate in our nation. One rule of polarized debates seems to be the 10-80-10 rule. There's going to be 10% of the public and the voters who are solidly on one side, they're locked in concrete and they're not going to change, and 10% on the other with the opposing view who are just as unchangeable. But in the middle, 80% of people who may or may not be leaning in one direction or another, but are still open to arguments and open to logic. Historically, in this particular debate, we who support the right to choose to be armed to protect life, unlike the other debate, we get to be pro-life and pro-choice. Historically, logic has been on our side, and we've won a great many victories with that. The other side falls back on emotion simply because they don't have the logic, they don't have the legal principles on their side. Despite that dichotomy, I don't believe logic and emotion are necessarily mutually exclusive. If you look at, going all the way back to when Time magazine began to make gun control a big issue, I remember they would print the pictures of every victim after every single one of these horrendous mass murder atrocities. We need to bring forth the faces of the survivors. How many of you in this room have ever been in a situation where you needed a gun for self-defense? Not necessarily to shoot someone, but needed the gun to protect yourself from a human or an animal. Okay, the faces of those who raised their hands need to be seen and their voices need to be heard. Raise your hands if any of you in here, if any of your parents or grandparents ever needed to use a gun for self-defense, if only to ward off the criminal at gunpoint. Okay. Remind people you would not be here to talk to them if those parents or grandparents had not been the armed citizens that they were. If the other side wants to play the emotional game, we can enter that game, and we have a pretty strong hand of cards to play. For every time they can show a mass murder, and because they need to blame someone, they blame the gun owners and the empty symbolism of their gun control, we can bring forth the survivors and the progeny of those survivors who would not have been born if those people had not been armed. Let's look, for example, July 20, 2012, the atrocity at the Aurora movie theater. That crazy SOB had, we think, deliberately picked out the one theater that had a gun-free zone sign. And forgive me, but whenever I see gun-free zone, I see hunting preserve for psychopathic murderers. Walked in heavily armed, started shooting. He left a dozen dead and almost 60 injured. And as soon as he confronted the first armed person, the first responding officer, he dropped everything and surrendered like the coward that he was. Everyone remembers that, don't you? That was Barack Obama's key. Okay, here's my chance to make my big push for gun control. And the gunfire from that Aurora theater echoes today in the arguments that all of us face. The next time you hear that argument, remind them that in that same city, Aurora, Colorado, 3 months before that atrocity, another monster showed up, this time at a church, drew a gun, opened fire. He had time to claim a single victim. He murdered the pastor's mother. That was his last chance to pull a trigger because an armed parishioner drew their legally carried gun and shot him dead on the spot. They don't tell you about that one, do they? I don't like to use these SOBs' names and give them credit even when they're dead. I'll give you this one so you can look it up, because people will tell you it never happened and you want to be able to show them the link. The monster's name was Kiaron Parker, K-I-A-R-R-O-N, Parker, common spelling. An ex-con, a prohibited person with a gun, stopped by an armed citizen. And God knows how many lives that armed citizen saved that day. Actually, he was an off-duty cop. Whenever I was an off-duty cop, I considered myself an armed citizen. The only difference between the armed citizen and the off-duty cop is one is carrying on a piece of tin and the other is carrying on a piece of celluloid. And if you want to stay in Colorado, go half a decade before that, in the year 2007. One of these monsters opened fire in the New Life Church parking lot in Colorado Springs. Shot his first few victims, burst through the door with an AR-15, and he was met by an armed citizen, a former cop, now a private citizen. Her name is Jeannie Assam, and she ran toward him with a Beretta 92 pistol in both hands, shooting, filled him with so many 9mm hollow points he went to the ground with just enough life force left to put the gun in his own mouth and finish his own job. And George Bush, the President of the United States at that time, credited her with having saved countless lives. And let's go back to 2012, this time in Connecticut, the atrocity at the Sandy Hook Elementary School. Today, we have the armed teachers movement. You'll see out here in the hall the display from the FASTER group, who have been exemplars of training school faculty, volunteer teachers who are discreetly armed, trained to a police shooting skill level, and who make the point of telling the public this school system is armed. You will not know who the armed teachers are, neither will the children for that matter. But if you enter this place with deadly weapons to harm these innocent children, we'll kill you. Have you noticed there have been no school shootings in the state of Ohio since the FASTER program began? The other side counts the deaths and they dance in the blood, and they ignore the survivors. They ignore the fact that every study of DGUs, defensive gun usages by armed citizens, more than 90% of the time it ends without a shot fired when the predator realizes, oh poo, or words to that effect, I am about to die from a sudden and acute failure of the victim selection process. and I am leaving now. Those don't get counted, but they're counted in the study a few years ago by Professor William English that determined decisively there are an estimated 1.67 million defensive gun usages in this nation every single year. Those are figures. The figures are on our side. The public needs to see the faces. We need to have testimony in front of legislators, in front of television cameras, from those who are alive because they or their parents or another loved one carried a gun lawfully and used it for its protective purpose. And as we reach out to those 80% in the middle, one thing I've found, if you can show the undecided person that they have already made a decision very similar to the one you're urging them to consider, you're on your way toward winning that argument. And the argument that I found to be extremely effective in that is this. I consider the defensive firearm to be a direct analog to a fire extinguisher. Each of them is an emergency life-saving rescue tool. It's intended for the first responder, the individual at the scene, to immediately take action and preserve innocent life, to hold off death and injury until the trained professionals with the heavy equipment can get there to take over. Now, let's go back in time a little bit. To look at me, you can see how old I am. I was born in the year 1948. Back then, people didn't have fire extinguishers. I remember one of my strongest memories as a little boy is walking past the fire extinguisher in the kitchen that was bigger than I was. You young people in here will need to Google it. Those of you my age, I see enough white hair out here, you guys look like a box of Q-tips from up here. It was a big copper or brass cylinder, stood about this big with a hose. You had to take it down to the fire station once a year to get it recharged. I remember the first time I went with my dad, how the people at the village fire station were patting him on the back because he was the only guy who kept one of these at home in the neighborhood, except for the firefighters themselves. Today, is there any one of you in here that doesn't have a fire extinguisher in your home? How many have them in your cars? Yeah, because society figured out the timeline. Okay? That fire blooms on the kitchen stove. You've got to get to the phone. You've got to call 911. The dispatcher has to transfer it to the fire department. They've got to suit up, get in the vehicles, and get there. Response times for emergency services vary wildly, whether it's police, fire, or EMS, emergency medical service. But the single most commonly quoted figure we hear is nationwide, an 11-minute average. And by the end of 11 minutes, if nobody's done something about it at the scene, the entire house is involved and everyone still inside is dead from thermal burns or smoke inhalation. And society figured out when that fire blooms on the kitchen stove, if you could just grab the fire extinguisher right there, kill it in its nest, the only loss is a few $100 in smoke damage and maybe a new stove. Audience participation, raise your hands if you know CPR. Virtually all of us. Now, back when I was born, if my parents had gone to the family doctor and said, "Doctor, show us how to do closed-chest cardiac massage," which is what they called it back then, doctor would have looked at them like they were nuts and said, "You want to learn that? Go to medical school. That's something we do for a patient in extremis." And society figured out when that heart stops beating and that person falls to the floor, within 5 minutes, irreversible brain death begins. 5 minutes to irreversible brain death, 11 minutes to the ambulance arrival, carry the one, and society figured out. And today you're considered socially irresponsible if you don't know CPR, if you don't know the Heimlich maneuver and basic stop the bleed. Ask yourselves, what is the difference? The defensive firearm is a direct analog to an automatic electronic defibrillator that many of us keep in our homes now, and the fire extinguisher, emergency life-saving rescue equipment for the first responder. And the people who are in the middle are going to think, wait a minute, I've got one of those fire extinguishers. And the people who are telling me to vote for gun control are saying, well, gee, they'd only want a gun if they wanted to kill somebody. By that standard, do I have a fire extinguisher because I want my house to catch fire? Do I know CPR because I want my grandmother to have a heart attack? Wait a damn minute, somebody's lying to me. And one thing you'll find in any debate, when the other side lies, do not despair, rejoice. They've given you the tool to defeat them. All you've got to do is prove the lie. Anyone in here been on jury duty, done jury duty? Those who've done jury duty, I'm going to ask you to stand up, please. I'm going to ask you a yes or no question. You know, in court, when they ask you a yes or no question on cross-examination, you're being set up, and I'm not going to set you up. I'm going to ask you to sing out hard the word yes or the word no. When you found one side lied to you, did you believe another damn word out of their mouths? No. Thank you. No further questions. And that's how it works. We have the logic, we have the law. Attorneys learn in trial tactics. If the law is on your side, pound on the law. The facts are on your side, pound on the facts. And if neither the law nor the facts are on your side, pound on the table and pound on every witness the other side brings up. The law and the facts are on our side. That's why the other side uses only emotion, only the pound on the table. We have the cards. We are the ones who are carrying those guns to protect lives. And not just our own. They'll say, ooh, you carry that gun to protect yourself. You'd kill somebody else. You must be the most important person on earth. No. We carry these guns because every one of us in here has more to survive for than our own hedonic pleasure. How many of you, raise your hand if as you sit here now, you have a key to your home on your physical person? Raise your hand if as you sit here now you have some piece of government-issued ID on you with your street address, not a P.O. box. All right, you realize if you allow someone to overpower and murder you, they know where your family lives, they have the key to your house now, and you cannot warn your family that they are coming. That's one of the reasons we carry guns. How many parents do we have in here? Did you ever have a kid? Raise your hand if your kid ever said to you, I didn't ask to be born. Well, they didn't. They're telling you the truth. We carry these guns because we, who brought these children, our children into the world, have an absolute duty to them to stay alive, to shepherd them through this unforgiving place as long as we can. Those of you in here are married or in bonded relationships. You carry that gun because you have a covenant with another human being. You're going to grow old together and take care of each other. You young people in here, you have that gun to spare your parents the unnatural grief of burying a child. Let the other side know. And most people say, trust your guts. I always told my kids, no, look in Grey's Anatomy, your guts are full of shit. Listen to your guts, run it by your brain, and remember a final lesson, because I've just run out of time, in between the guts and the brain is here. Sometimes you have to touch their heart to make them open their minds. Thank you.
The brilliance of Massad Ayub. Thank you, Mas. Absolutely unbelievable. The godfather of self-defense. Thank you, Mas. All right, lunchtime. We're running about 15 minutes behind. I would ask everybody to get their lunch. And Representative Darrell Issa will be here shortly after the lunch break. So enjoy your break, and if you could be back here in about 45 minutes would be great. We're going to listen to him speak, and of course, we've got the luncheon coming up as well. So grab your lunch, come back in, eat, enjoy the festivities, then we'll continue with Representative Darrell Issa and another fireside chat. Awards luncheon will be in about 15 minutes, so you'll want to grab your food and come on back for the awards luncheon.
Hello. Oh, this works. Perfect. I am looking for Chuck Michelle, Holly Sullivan, Jared Yanis, Masad Ayub, Tom Taylor, and Mike Schwartz. Can can you please report to the principal's office? And may I see Kwong Win, please? right. This one, yes, this one works. Good afternoon, everybody. Welcome to lunch. I hope you have all enjoyed the morning here at GRPC and found that the presentations were educational. Right now, what I'm going to do is introduce the individuals sitting up here at the head table. And just to give you a little precursor of how this is going to run, after I'm doing the introduction, give you a little bit more time for lunch. I'll get my ugly mug out of the way, and I'll come back up and introduce our next speaker, Mr. Fund. He will talk for a little bit, and then we will kick into our awards ceremony and then move into the afternoon session. So with that, we will start at the end of the table. We have Mr. Mike Schwartz from San Diego County Gun Owners. Next to him is Tom Taylor, the Executive Vice President over at Sig Sauer for Global Brand Development and a SAF board member. Mr. Jared Yanis, the host of Guns and Gadgets on YouTube. If you are not subscribed, make sure you like and subscribe the channel. Next, and ring the bell, of course, yes. It's been a while since I've done those. Next to him is Holly Sullivan. She is a Citizens Committee for the Right to Keep and Bear Arms board member and the president of the Connecticut Citizens Defense League, pardon me. A man who needs no introduction, but he's going to get one anyway, Mr. Alan Gottlieb, the founder of the Second Amendment Foundation and the chairman of the Citizens Committee for the Right to Keep and Bear Arms. Next to him is John Fund, the National Affairs columnist for National Review. To his right, Quang Nguyen. I knew I got it right. State Representative of the Arizona House of Representatives. To his right, Masad Ayub, the President of the Second Amendment Foundation. And rounding out the head table, our friend Chuck Michelle from the California Rifle and Pistol Association. So please enjoy lunch. I will be back in a couple minutes to introduce our speaker. Bye.
All right, Mark, you ready to introduce him? They said you were doing it.
Who am I introducing?
John Fund.
John Fund.
You were pimping his book, apparently?
What's that?
You were John Fund. Yeah, Alan asked me. Asked me to ask you to do that. So.
I thought it was
No.
Ladies and gentlemen, I hope you're enjoying your lunch. We're going to keep the party rolling, keep the ball rolling here for just a few minutes before we get into the awards banquet. It's my honor to introduce to you now John Fund, author of Our Broken Elections, How the Left Changed the Way You Vote. And the topic is the 2024 elections. You ain't seen nothing yet. John also is a national affairs columnist for the National Review magazine, and John will be signing his book at the registration table afterwards. So make sure to pick up a copy. Here it is, so you know what you're looking for. John Fund, welcome, my friend.
Well, Alan Gottlieb reminds me that last year when I was with you, I gave you a 100% guarantee that Joe Biden would not be the Democratic presidential candidate. Did I deliver? The bad news is he's not the Democratic presidential candidate. Look, it was pretty obvious what was happening in the Democratic Party because the White House staff was playing hide the president. I mean, they had done everything to hide him from the American people. So finally the donors got together in last April and said, look, if you want us to give money to you in the campaign, we have to see evidence that you're not gaga. You have to do a debate early. That is why Biden proposed a debate in June, 3 months before any other debate had ever been held in a presidential election. The problem, of course, is that Donald Trump took the bait and agreed to it. Both candidates made mistakes. The early debate was a disaster for Biden, and it was a lost opportunity for Trump because if he was still running against Joe Biden, you wouldn't need to have me on the panel. We'd know how the election was turning out. Having said that, the election is going to be very, very competitive. So competitive that I'm not going to make a prediction because let me read to you, well, I can make it privately afterwards if you want to talk to me privately, but this is being recorded. Nate Cohn, one of the leading pollsters in the country, a liberal but an honest one, says, imagine for a moment the latest New York Times poll in every key state. Imagine if they were right on the mark. They won't be, but here's the result you would get in the Electoral College. Harris 269, Trump 269. In terms of the electoral count, it would be the closest modern presidential election. We've had a lot of close elections before. As Hillary Clinton can attest, a modest but clear lead is not a guarantee of victory. But here, neither Kamala Harris nor Donald Trump can claim even that. So we have a very, very close race. I want to address the state of play regarding all of the things that we don't know about Kamala that I hope the American people know in the next 5 weeks. But I'm not going to hold my breath. I am from California. I'm from San Francisco. I have personally known Kamala Harris for a quarter century. And let me tell you, reports that she is rock stupid are actually incorrect. I wouldn't say that she's a rocket scientist. In fact, the best description I ever had of her was by one of her close friends who said, you could walk through her deepest thoughts and not get your ankles wet. But she is not stupid. You don't rise to the pinnacle of American politics by being stupid. What she is insecure. She's insecure, which is why she always has this tentative nervousness, this desire to never go beyond the dotted lines of the talking points. She always, always is cautious. In fact, the only surprising thing she has said in the entire campaign is when she revealed she was a gun owner. Could have fooled me, but apparently she really is. I suspect, though, that that didn't have any effect at all, because just this week she announced her support for Joe Biden's initiative on stopping emerging weapons threats and a task force to do that. So I think we know what's going to happen under a Kamala administration if it takes shape, and especially if there's a Democratic Congress that goes with it. Now, as for Kamala's past, she's probably had the most meteoric rise of any candidate. After all, she didn't have to run through the primary. She didn't have to endure oppo research from fellow Democrats running against her. What do we know about Kamala that the average American doesn't? Well, for one thing, we have people who can remember Kamala because they helped her. Willie Brown, for example, the powerful Speaker of the California Assembly. I talked to Ed Rollins the other day, who worked in the California legislature with Willie, who was Ronald Reagan's campaign manager in 1984. And Willie Brown told him, yes, I met Kamala. She was 28 years old. She was a public prosecutor. I helped her out. He appointed her to 2 state commissions that only met twice a month. And the salary in inflation-adjusted dollars for each of them was $200,000 a year. That's a total of $400,000. She cleared over $1 million from those commissions while she served on them. And Willie Brown said, well, she was an airhead then, she's still an airhead, and I can prove that because she's no longer listening to me. Here's another thing about Kamala. How many of you saw that famous non-answer to a question about the middle class where she says, I love the middle class. I grew up in a place where everybody had a broad, leafy lawn, and they loved taking care of their lawn. And I said to myself, excuse me, I grew up outside Berkeley, California. I know what the houses in downtown Berkeley look like, where she lived. There's no lawn there. There's a postage stamp with a small little fence and maybe a Victorian house. What is she talking about? You got the prize. You're the first person I've ever spoken in front of who knows that in advance. The dirty little secret of Kamala Harris is she grew up in Canada. Her parents divorced at a very young age, and her mother took a fellowship at McGill University in Montreal, French Canada, and she moved there when she was 9 years old. She not only went through school, all the way through high school, she graduated from Westmont High School in Montreal, Canada. Her first 2 years of college were in Canada. She always talks about, well, I went to an historically black college. Yes, she went to Howard University as a transfer student for 2 years. That was the first time she'd come back to the United States. Then she moved to the Bay Area. I have to tell you, of all the presidential candidates that have ever run for office, I'm not trying to impugn her patriotism. I'm not trying to, certainly not impugn her birth certificate. She was born in America. She is an American. But in terms of an actual connection with America's founding values, its principles, its zeitgeist, she went from French Canada to the triangle, the isosceles triangle of San Francisco, Berkeley, and Oakland that I grew up in. There is no more unrepresentative part of America on the planet, if you're talking about American values, than the San Francisco Bay Area. And she spent her entire career in that hothouse environment being radicalized. And she is a radical. Now, one of the things that I want to bring up as to why this is so much of a problem is this. We have, in this country, an enormous social stigma and social pressure attached to people speaking their own mind. It won't shock you that a new poll by a think tank in Massachusetts, which is actually centrist, the Preguntum think tank, has come out with the following observation. They took an enormous sample of the American people, 20,000. The typical sample is 1,000. So this is a 20,000 sample of the American people, and they took this and they ran it through and they asked people, do you feel as if you can say what you think in front of other people? 58% of Americans say no. In fact, 61% say they actively don't say what they think if they're talking to other people, including people they know. Well, this presents an interesting question, because then the think tank went back and asked a series of questions on 65 issues. And what they found is there is a gap between what people will publicly say is their point of view and what they will privately think. Now, the gap in authoritarian governments is vast. In America, it's not vast. But on some issues, it's a chasm. For example, and I'll get back to what this means for Kamala very quickly. If they're asked, do you trust the government to tell the truth? 36% of Democrats and 14% of Republicans will publicly say they trust the government. In reality, they tell the pollsters, only 5% of Democrats and 2% of Republicans agree with that statement privately. Is there too much government control in America? 59% of Americans think there is, but only 50% say so publicly. Democrats are far more likely to conceal the fact that they are concerned about those issues. Trust in the media. Only 25% of Americans trust the media. That's what they say. In reality, only 7% of Americans trust the media. School choice, you go on and on. Then you go on to guns. 26% of Americans publicly support outlawing guns. 22% agree with it in private. Now here's the interesting thing, and Alan Gottlieb and I have been talking about this. Younger Americans, Generation Z, that's people under the age of 30, they are more supportive of gun rights than the preceding generation, the millennials. In fact, they have found in the poll that Generation Z feels compelled to suppress their private disagreement and publicly agree with banning gun ownership, while many millennials, those over 30, feel compelled to do the opposite and hide their true support for making guns illegal. There are all kinds of theories which we can go into as to why this is. My point is, in the next rising generation, support for gun ownership and gun rights is going up, not down, and this will have profound effects for you in the coming years. You not only have to hold on to what you have to make sure that you recruit the cavalry over the horizon that's coming and make sure they not only support these rights, but actually get involved with groups like Alan Gottlieb and the Second Amendment Foundation. Now, one warning that I'll leave you with. If people ask me, what worries you most about the election? It's this. Do you remember with COVID in 2020, there was a tsunami of absentee and mail-in ballots that flooded the system? It made it so chaotic, you couldn't tell where the incompetence ended and the fraud began. And all of those states, Georgia, Arizona, Pennsylvania, Wisconsin, were so close, we can't even tell who won, frankly. What we do know is this. This year, there are going to be fewer mail-in ballots, but there's still going to be an enormous number, probably a third to 40%. Here's the problem. The National Secretaries of State, which is bipartisan, half Democrat and half Republican, last week issued an emergency code red letter to the U.S. Postal Service director saying, if you don't do something about the declining postal standards in this country with the post office, if you don't do that, we're going to be in big trouble. Because they gave two examples. In Utah, there was a primary in June, a congressional primary, Republican. 1,098 people filled out a mail-in ballot and sent it in well in time to reach the authorities. But the Postal Service has changed its delivery standards. They took those 1,098 ballots, which were election-related, and they shipped them to their transfer center in Las Vegas, the neighboring state of Nevada. By the time they came back, it was too late to count them. The primary was decided by 177 votes. Kansas had a primary in August. The Secretary of State has written to the Postal Service saying, we had 2% of ballots that were sent out, sent back in, and they never arrived in time or never arrived at all. He says, we have elections all the time decided by less than 2% of the vote. In fact, 2016, 2020, both were decided by that amount. That's a problem. I fear that we're not going to have election day in November. We're going to have election month, just like 2020, where people are going to litigate and fight and argue and further polarize this country. The election result will be murky because it will be as close as I started out my talk by telling you in these swing states. And that's a danger. What can we do? Well, for one thing, I think there have to be immediate oversight hearings in Congress on this. There has to be pressure on the Postal Service to actually make election mail a priority. And frankly, unless your friends and you are going to mail your ballots in early, I would go to the polls. Don't wait for the mail, because let's just put it this way. The mail, the Secretary of State of Kansas says the mail used to be faster with the Pony Express in Kansas than it is today. In conclusion, I believe we are at an inflection point in which if we win, we have an enormous opportunity to not only keep the gains we have and the rights we have, but to move the needle forward, to move the needle in our direction. If we lose, let's just say our opponents don't like us. They have two words for us, and they're not happy birthday. And I think we should recognize what our stance has to be between now and November, and especially after November. Ronald Reagan is the subject of a new film that came out starring Dennis Quaid. How many of you have seen it? Did you like it? I was proud to be a consultant on that film. Go and have your friends and neighbors see it. See it before Election Day. It will inspire them to vote. Ronald Reagan has a great line in that film. And the line is, when asked by his Secretary of State, what's our foreign policy vis-a-vis the Soviet Union? Reagan says, it's very simple. It's very clear. We win, they lose. That has to be our motto and our guidepost now between here and Election Day. We have to win, and they have to lose, and then we'll show them, to use another Reagan line, they ain't seen nothing yet. Thank you. There's no time for questions, but I'm happy to chat with you individually. I'll be sitting out there at the registration table after the talk. I'll be copies of my book on the election and how the left has changed the way we vote, and I'm happy to sign it for you, but you don't have to buy a book to talk to me. I'm happy to meet you and shake your hand and answer your questions. Thank you.
Thank you, John. Before we move into the award ceremony, I also did want to recognize two new board members that are with us for the Citizens Committee, Mr. John Petrolino, and for the Second Amendment Foundation, Kenyon Gleason is somewhere in the room here, I believe. So I just wanted to recognize new board members that were elected recently. And with that, we're going to move into the awards ceremony. Alan Gottlieb will be here to present the awards for the Second Amendment Foundation as well as the Citizens Committee. Sir? Right here, and Mr. Emerson will be helping you.
Thank you. My cue cards. I'm going to start by saying this is probably my favorite part of the Gun Rights Policy Conference, because there's an awful lot of people do an awful lot of work defending our gun rights all year long that never ever get recognized, and in many, many cases, never earn a penny for all their hard work and volunteer efforts that they put in. And without them, we really wouldn't have a gun rights movement or gun rights successes. So it's my favorite part of the thing is to honor some of these people on our behalf. And I'll start off with the Citizens Committee Awards. Our first award goes to the Legislator of the Year, and it's for their recognition of their work in supporting gun rights in the legislative arena. And that's why this is a Citizens Committee Award, not an SAF award. And this year I'd like to give it to Representative Barbie Cox from South Carolina, who was supposed to be here today, but unfortunately the hurricane wreaked havoc on his home. And I hope he and his family are going to be doing okay, and we'll make sure that he gets the award. Bobby is an up-and-coming national gun rights leader, not just in the state of South Carolina, and I'm hoping one day we see him as a United States Senator. So, Bobby, our prayers are with you and your family right now. The next award is also going to somebody who isn't here today because of a couple deaths in their immediate family that happened in the last couple of weeks. But this is the Lifetime Achievement Award. And in this case, it's going to a writer who, through his amazing, millions of distinguished words and deeds for Breitbart.com, breaking significant news stories involving our right to keep and bear arms, this award goes to A.W.R. Hawkins. Boy, this is heavy. He's probably glad he's not here because taking this home in your luggage would really be tough. The next award from the Citizens Committee for the Right to Keep and Bear Arms is our 2024 Grassroots Activist of the Year. And this was an easy award to give away this year to a person who has done an amazing work on the ground, locally, on the grassroots level, supporting our Second Amendment rights. And it's going to go to Michael Schwartz, the founder of the San Diego Gun Owners PAC. Hopefully Michael is in the room. Yes. Thank you. I'd like Michael to say a few words.
This is your award. This is your award. There are so many members of San Diego County Gun Owners in the room today. Thank you. Thank you.
Excuse me, Michael. Here's the box. We don't only give an award from the Citizens Committee for the Grassroots Activist of the Year, we also give one to the Grassroots Organization of the Year. And this is always a hard call because there's usually 2 or 3 major statewide groups that do yeoman's work in their areas. Usually they're, unfortunately for us, in blue states where they have to really defend their rights very heavily and do an admirable job of it. It's difficult because it's a tough choice sometimes. And so this year it's going to go to the to the Gun Owners Action League from Massachusetts. And we have somebody in the room, I hope, from Goal. Kellyanne, would you please come up and say a few words? And Goal, like a couple of, like Illinois State Rifle Association, the California Rifle and Pistol Association, the states are under heavy attack, and without groups like that, boy, our rights would disappear instantaneously. Kellyanne?
Thank you. Thank you so much. This is an honor to be here, and Gun Owners Action League has been in business for 50 years. And I have the pleasure of working with them this past year, and I've been working with them actually with the organizations that I volunteer with for the last 6, 7 years. So it's an honor to see everybody fighting so hard right now in Massachusetts, because we are fighting hard. We've been attacked and we're being attacked, and it's been an honor to be able to be a voice for those that can't and for those that don't know how yet. So together, this is amazing. So thank you so much. This is for everybody that's fighting hard everywhere. Thank you.
The next Citizens Committee Award goes to our affiliate of the year. And this year it's going to go to the California Rifle and Pistol Association. So Chuck, Michelle, would you come up and say a few words and accept your award?
Well, this is great recognition for the CRPA. We've done an awful lot of work. CRPA is a totally different organization than it was 5, 6, 7 years ago, and it's really grown phenomenally, and the staff of the CRPA is the reason why. I'm happy to lead the group, but they're the team that really made this possible. So thank you very much. It's a great honor.
The next one goes from these now Second Amendment Foundation awards, and this one is our Defender of Liberty Award, and it's going to go to John Crump, who's a journalist, writes for multiple outlets and for gun rights, and Virginia State Director for Gun Owners of America. John, are you in the room? I guess he's not here. We'll make sure he gets his award later. Thank you. We also have another Defender of Liberty Award. I guess we have a couple of them. This one's going to go to Rebecca Shimon from the Kansas House of Representatives. We spoke to you earlier. And you're going to be able to get up here. Rebecca, thank you for all your hard work.
First and foremost, I just want to thank everyone who is here because you guys are all involved. It is a priority to each and every one of you and everyone watching online to defend our liberty. This day and age, we don't see that as often as we should. You guys are all champions. I appreciate you, and every one of you makes what I do that much easier. Thank you.
The next Defender of Liberty Award, I don't know if I should really give this person, because while he does a great job defending gun rights and is a fan of a lot of us here in the room, he wastes an awful lot of my staff time because my staff time spends all their time online watching his show. But this one is going to go to Jared Yanis, the host of Guns and Gadgets. Jared.
Thank you. Sorry I make everybody watch my stuff, but it means a lot because without people taking the information I put out and actually putting it to work and bothering politicians, we're in a worse spot than we're in, and I'm just a clown who talks to a camera in a spare room of his house. So thank you all for your support. I have pledged everything I can do to help you guys and gals going forward, and I mean it from the bottom of my heart. Thank you. America owes you a debt. Thank you very much.
Thank you. This one is a pleasure to give out. It's another Defender of Liberty Award, and it's going to go to Rob Dorr, Senior Vice President of Government Affairs for the Minnesota Gun Owners Caucus. Rob. I can tell by your applause that this is probably one of your favorite parts of the conference as well. Thank you.
I got to speak now. All right. Well, thank you guys very much. I very much appreciate you, everybody at the Second Amendment Foundation, Citizens Committee. You guys have been great partners in litigation, and that's really the path forward right now, especially in states like Minnesota. We are holding it off, and my partner in crime, Brian Strasser, our chair, will be talking about that a little bit about that tomorrow. But the the courts are where we are winning, and the courts are where we're going to have lasting impact. And there's no greater organizations involved in that fight than the people here today. So thank you all very much.
Wow, I didn't realize it was that short. The next award is our Bill of Rights Award. And it's going to go to an attorney who's done a lot of work defending Second Amendment rights that doesn't get as much recognition for what he's done for all of us as he really deserves. And this Defender of Liberty Award goes to attorney Alan Beck. And Alan, he was here earlier. Well, we'll make sure he gets it. Sometimes what happens is we never tell these awardees they're getting an award, so they don't know, and so they're here, they're out having their break or talking with somebody or working on a legal case, and they're not here to actually accept it. This next one award, if I can make my fingers work, is our Scholar of the Year Award. And that's actually an attorney who's going to get it for a lot of the research he has done that's helped a lot of us in court cases he's worked on, and a lot of court cases other attorneys have worked on as well. And the Scholar of the Year Award goes to Konstantinos Moros. Is he in our room? Yes. And I will tell you, there are a lot of people in the legal community that really have appreciated the work that he's done, that they've been able to use in a lot of briefs that they have filed.
Well, thanks. You can tell this wasn't planned because I got rid of my jacket. I untucked my shirt. I definitely did not know about this. But I got to say thank you, especially to Chuck, because he humors me in letting me go off on adventures when I should probably be doing more straight billable work. So thank you, Chuck, for that. And thanks to everyone at the CRPA and my colleagues who probably deserve this a lot more than I do. They're just smart enough to not be on Twitter and talking about this publicly a lot. So thank you. It's an honor. Thanks for the Second Amendment Foundation and Mr. Gottlieb for hosting.
Well, Alan Beck is now, I understand, in the room. So Alan, will you please come up and accept your Bill of Rights Award?
Thank you very much for giving this award, Alan, and thank you again for having this event every year. I always look forward to coming to it and be around other fellow Second Amendment advocates.
And the last award to be given away at lunchtime here is to our Journalist of the Year. And this is going to go to John Petrolino, who obviously has a lot of fans in the room. John, would you please come up? And I'd like to also thank John for being willing to serve as one of our new directors for the Citizens Committee for the Right to Keep and Bear Arms on our national board. John.
Thank you, Alan. Thank you, everyone. This is really a great honor to have, and I'd be remiss to not thank all of you here at SAF for your support, because really, if it wasn't for all of you and many people that give me tips the friends, the support. I wouldn't be able to do what I do, and also to my family. Without them giving me up to allow to devote some of my time to the cause, I wouldn't be able to do this. And then finally, my editors, in particular, Cam Edwards and Freddie Reel, really great people, as well as the State Association in New Jersey and all of my supporters out there. Thank you all.
And that closes our awards presentation and our luncheon. We're running a little bit behind, so your break could be a little bit shorter. So I apologize for that, but hurry up and take your break and come on back because we have a heavy agenda coming up. Thank you.
Check, check. Everybody, I'd like to have everybody back at 1:15, please, so we can stay on time. Representative Darrell Issa will be here, and we'll follow that up with a fireside chat. Thank you.
Test.
Check, check. Check, check, check,
I
check.
don't think you've ever met Kevin. No. Yeah, I think it'd be good, you know, just like,
Check.
yeah, it's pretty job in it, you know. Thank you, buddy. Alan said there might be a problem.
Check, 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 check. These are both hot.
Yeah, I need you to remain on mic 4, and I'll leave that hot. But it was left hot. I can think Adam turned it on while ago.
Okay.
Yeah, it's okay.
This one's 4 here. without
Yes.
the 4.
Yeah. There you go.
And this one too is hot too.
Yep.
I need one for me and one for Darrell Issa.
Yep. And I'll get that hot as soon as it hits the stage. But I'm leaving yours hot 100% of the time for you to turn on and off. These are locked on. You can't turn them off. So I have to mute them at the board and unmute them so you guys don't pick up table conversation on the stream and everything else.
I'll take 2 and I'll give Darrell Issa 4. Fair enough.
You
want me to
keep
take
4 always. I don't care which one of these go to the stage. I'll catch it once they're on the stage.
Well, honestly, he could take these back. Lace is the only other person.
We're done at this point. So he's got which one?
He's got 2 and I've got this one.
Got it. 2 and 4.
That way we just eliminate all good.
Yeah. No worries. Like I said, I need to leave one hot for him because he's popping up at the table on me. I don't even know where he's going. So. 2 and 4. Yeah, leave that for him.
So what he wants to do is, Darrell is I would rather go direct to the fireside 4 times first. So that's what we're going to do. That's great.
He's going to give this little talk. We're going to interrupt them in the fireside. Not interrupt, but you're going to.
Don't want me off base. You're good? We're good? We're good. All right, you're messing with my head. What's left of it?
I am on focus. There's no joking, Jennifer.
Hey,
Do not.
you should be proud of me. I've gone to bed at 8 o'clock every night.
Well, Advil.
Isn't that great? Think I would disagree with you guys?
Done it right.
I made that mistake 4 years ago. I wouldn't agree with you. Oh, it's terrible when it happens. When it happens, it's awful. We only need 2 chairs up for this one. We're good. I'm on that Ozempic.
Is there any other garbage I need to take from here? It is part of my job as well. All right, let's go.
And it just makes me not want to eat, and then after I do eat, I feel like crap.
Thank you.
Right? He is. Can you believe it?
Juan keeps stealing my stuff. Like a little kid. Leave it alone.
I love it. In fact, I'm not. I know it's sugar, and there's more sugar in it, but I take just a little 8-ounce, and it has helped my joints and my hands like you would not believe. Now here's why I went through. I had surgery on my finger. Look at this. See what the surgery did? Feel that? Feel that knot right there? But my finger won't go up anymore. I can't even wear a wedding ring because it's so swollen from the surgery. On my wrist and my elbow for surgery. I couldn't do it. It works. It works. It has helped. But it's very flavorful, so that's why I do it. Number 4 is. We're good. And we have him until, Jennifer, let me just confirm with you. We have him until, how long do we have him? 2 o'clock, is this accurate? Because I know this is off. We have him until 2:16. Okay, excellent. All right, so I'm going to introduce him, let him speak. And then after he speaks, before the fireside, I'll intro you. You'll give him the word, we'll go to the fireside. Exactly. All right, we're good. We're good. All right, we're good. Yes, yes. I just had a fantastic conversation. And I really love conversation. Yeah, and you know what that is. I will. Yeah, I'd say what's even from a hosting standpoint, that right there is gold. Because they see that, it's the intimidation training factor. It's the touch right in their face. And then when you go over, it works great. Did you hear that one time? The only time I almost lost control, and I didn't know that those guys started to do less things. I'm like, no, that's Charlie. Watch how it's done. Watch how it's done. That's okay. We let him do this. We had enough time to do that. But those guys decided to take Ladies and gentlemen, if you could bring yourself back to the ballroom, we'll get started with Representative Darrell Issa. If you would bring yourself back to the ballroom and be seated, please. One more quick call. If we could have everybody back in their chairs, we'll get started with Representative Darrell Issa. If everybody would take a seat, we'll get started. We have a fantastic next hour lined up for everybody. Welcome back in, everybody. We're going to continue now with our next speaker, and this is going to be a good one. Representative Darrell Issa will speak to you briefly, and then we're going to meet over here for a fireside chat. It's going to be a great conversation, I can promise you that. So with no further ado, I'd like to take this opportunity to introduce to you the U.S. House of Representatives, District 48 here in California, the chairman of the House Judiciary Committee himself, Representative Darrell Issa. Thank you for being here.
Can you believe gun rights exist within this room? It's probably the only room in California where you have gun rights. No, thank you all for being here, and it is an honor to be part of the federal government that does believe that we looked at 17 amendments to the Constitution, we've passed 12 of them, and the one that is most important is the Second Amendment. First Amendment sounds like it's more important because it came first, but if citizens didn't have rights, how in fact would they have the right to free speech? That's always been the question of which should have been first. Should have been right to bear arms should have been first, and then the right to talk about it should have been second. But that right is under attack. We're nearing 233 years since ratification. In those 233 years, we went from assuming that nobody even had anything to say about bearing arms to go hunting. Nobody had anything to say about bearing arms to protect one's home. That was assumed by our founders. It's the reason that the word militia was included in there. It's the reason that Jefferson and others spoke eloquently about how important the Second Amendment was and how important it was to restrain the growth of government and its natural taking from the rights of the people. But in those 233 years, we've seen that assumption go away by one after another administrations, not the least of which is our current vice president. She does not, notwithstanding the fact that she says she's got a gun somewhere, it will not surprise me if it shoots water. Just want you to know. Well, she said she's going to kill you, but you know, you can drown. The reality is that she has spent her entire career here in California attacking the Second Amendment. California, if tested, most of their laws would fail the test. The very fact that if you want to have, and there's, how many people here, if I can see, are Californians and have a concealed weapons permit? Okay, you're about half the people that have it. Now, clearly, you're not all San Diegans, but you know what you go through. It is designed, unless you are former law enforcement or current law enforcement, it's designed to actually wear you down to where you go, it's not worth it. That's not an accident. Laws designed to make weapons not usable, not practical, not affordable, are in fact the laws that Californians see every day, and the laws that if, and I'm being very overtly political for a moment, if we allow Vice President Harris to become President Harris, we will see attempts on again. We will see federal taxes increase, but most importantly, we will see what we've seen for almost 4 years now, which is using ATF and other agencies to specifically go after the people who facilitate your ability to have a weapon, and even go after gun owners who simply are, in fact, buying or selling, usually historic pieces or something. They're gun collectors. They are the newest ones being attacked. As far as this administration is concerned, you can have just one weapon and go to sell it, and they'll consider you a gun dealer, because the way they've interpreted it is in a way that was never intended under existing rules or laws. So those are just some of the areas that are being attacked. Now, I love Q&A, and so we're going to go to that as quickly as possible. But in this season, what I want to say to all of you is, I'm proud of the U.S. Supreme Court and the vast majority of federal judges, because they have, in fact, done more to protect your rights than the body I belong to. Because the House and the Senate flips back and forth and cannot possibly always be your protector. And so even though we're in the majority today, even though Congressman Chairman Jim Jordan and all the rest of the team have your back, you have to remember that diligence of making sure that the courts, from the lower courts all the way to the Supreme Court, continue to have people who have read, understand, and believe in the Constitution. So I tell people that because I don't have much use for the Senate, except to make sure they ratify judges that in fact believe in that Constitution as it was originally intended. If we don't, we are nowhere at all. Now I'm going to close with the last partisan comment I'm going to make. And that is, most people don't know that Vice President Harris has something in common with Thomas Jefferson. Descendant of. Now it turns out when Thomas Jefferson was vice president, he went to Monticello and he wasn't even in Washington for more than a year. He didn't like being vice president, had nothing to do with the administration of John Adams, didn't like the man, wasn't even in the same party. So now we hear that Vice President Harris is the same way. She's had nothing to do with that Joe Biden. So the first part of what I told you is the absolute truth, and you can believe it, and you can look it up about Thomas Jefferson. I have my doubts about Vice President Harris. And with that, can we get up here and have that promised fireside chat? Please light the fire.
We absolutely can. But before I do that, I want to bring Alan Gottlieb up, founder of the Second Amendment Foundation, who has some words for you. And then he'll hand you off the mic.
Congressman, we had just had an awards luncheon, and we gave out awards, so we saved this one to give out for you to be here.
They didn't want to give me lunch, is what they're saying, just so you know.
Yep. Anyway, this is from the Citizens Committee for the Right to Keep and Bear Arms, which we the foundation's sister group that does is the C4 that does our lobbying. This is the Gun Rights Defender of the Year Award, presented to Representative Darrell Issa for all the hard work he's done protecting our gun rights, particularly in the House Judiciary Committee. Thank you very much. Can we get a few pictures?
By the way, anyone comes to Washington, you're going to find this one in my office.
We're looking forward to this, and I know you're going to get some great information. Fireside chats are fun. Mr. Representative, welcome to the Gun Rights Policy Conference. It's great to have you here. As you and I were talking in the hall, just briefly, I've used an analogy on the radio for a number of years about what we've seen, and I'm going to bring us up through the Obama administration into Biden and what a Harris administration would look like. And as you recall, Barack Obama took, or said he took, as many executive actions as he could. I personally believe, and I take him at his word, that if he could have taken more executive action on guns, he would have. Joe Biden, on the other hand, his vice president at the time, seemed to agree with Obama at the time, becomes president, and is just now announcing yesterday he's taking even further executive action on guns. So I look at this as a stairway. If we're looking at a stair step, Obama took that first step up that stairway. Biden took the second step, but Obama said he couldn't. Harris has already promised us that she's going to use executive action above and beyond what Joe Biden has done. Where's the landing, and where are the top of the stairs with the Harris administration should it unfold?
The answer really is that unless the court, and this is why I started with talking about the importance of the court, if you don't have to change laws, if a president can veto the attempt most of the time of the House and Senate, even if they pass something, because getting 2/3 is very difficult, then their actions are unchecked. And specifically, the alcohol, tobacco, and firearms, their ability to say, this is what the law means, including shutting down federally licensed gun dealers, shutting down the ability to get ammo. These are real, and executive action can do that. Or even the ability to have, and this is one of the major attacks this administration has tried to do, that if Harris gets her chance, she will do. They want to take the registrations, which by law have always been in the hands of the licensed federal gun dealer. Your registration, yes, you do get registered, but the fact is, it stays with the gun dealer. They've always wanted it in a central database where it's any cop can hit a button and know exactly who a serial number is owned by, or vice versa. When they want to go into a house, even if for some reason it's without a warrant, they want to know how many guns do you own. And that is currently not available to them unless the gun dealer has gone out of business. They want to change that. They've tried multiple times. If the court doesn't stop them, and in that case they might not be able to because it's very administrative, that is one of the things that they intend to stair-step.
Let's talk about the courts briefly. We're at a point right now where Biden is about ready, federal appointments to the bench, to overtake Trump's. Let's talk Supreme Court, keeping that in mind, because that's going to change the lower court structure in this country as far as Second Amendment is concerned. That, as you know, you're sitting here with the one organization that's fighting across the country and winning these battles in courtrooms. We're looking at 2, possibly 3 Supreme Court seats over the next 4 years. Thomas being one of them. And
Clarence
Thomas.
Thomas is waiting for a Republican president. He probably cannot outwait 8 years of Harris. He's just age-wise too old.
So we could be looking at, well, let's take, again, a theoretical situation. The courts are flipped on the lower courts. Now we've got a terrible situation where the Supreme Court is in the hands of President Harris. What happens legislatively? What can you do in Congress? And let's assume the House flips. What do we do? What does that, paint that picture for us? What does that look like for us as gun owners?
If we were to lose the House and the Senate and Harris were to be president, any law they pass or any administrative act they did could only be taken to the courts. And ultimately, if you lose at the lower court, which is what this administration has done a good job of putting a lot of Article III, district court judges, then your only chance is to win on appeal. But appeal's a funny thing, because once the court has made their decision, the deference to the lower court puts a thumb on the scale to where to overcome it is extremely hard. And ultimately, if they win, they only have to win once. So if they win at the lower court, the odds are that the deference will favor them. But even if they lose, they can be reversed by an appellate court like the Ninth Circuit. And if the Ninth Circuit, which is very liberal, and you only have to get 3 bad judges there, if they affirm something, at least in about 1/3 of America's homes, it's law, even if the Supreme Court doesn't take it up. That's what we're dealing with every day. And I don't want to tell you that you've had a bad rap. The fact is, for the most part, the courts have been very good for us. And they have repeatedly, especially with like the District of Columbia and California, struck down unreasonable acts. But let's remember, organizations like this and others have spent millions and millions of dollars, and they bleed us financially in order to get back a right that was enshrined in the Constitution. That's the other part of it is, quite frankly, they can throw fire into the theater, so to speak, and we've got to put it out time and time again, but you never really get rid of them. So yes, our greatest fear is to lose the court, but at any time, if the administration can continue using administrative power, they can take away your rights in pieces.
When it comes to executive action, you remind me, I want to go to the ATF on here too, because you mentioned the ATF and we talked about the ATF outside briefly. But executive action, what do you believe? Harris has told us within her first 100 days, if Congress doesn't act, she's going to regarding quote unquote assault weapons bans. Any idea what she's referring to? Would she actually attempt an executive action on an assault weapons ban? Would she be able to do that? Because they've shown no propensity to follow the Constitution. They've ignored Bruin, they've ignored Heller, they've ignored McDonald. What's going to stop her?
Nothing. The fact is, if she wants to do it, then the weapons will become unavailable for 6 months, 9 months, a year, 2 years. Because to get a stay on their executive order would be hard, especially if they use safety or other items. And by the way, the assault on the American manufacturer of weapons and the near bankruptcy that they keep doing to Remington and others is just as big a threat. And so when they say executive action, a lot of times presidents and others are a little sneakier than an actual executive order. What they do is they bring in members of the cabinet and they say, put as much pressure on as you can. And so it trickles down to the agencies related to import, the agencies related to export, even organizations like the EPA. How many of you are familiar, I keep making this a two-way conversation, at how in the last decade under Democrat administrations, time and time again, things like lead, copper, all the elements of basic bullets have become EPA's #1 target, especially at the manufacturer's level. You're exactly right. So think about it. If you can make the rounds cost more and more, you limit people's ability to own. If you can actually shut down American makers, you not only limit that, but you limit our ability to have a defense industry. That's going on as we speak. There's a company that has out in Coachella Valley is trying to get into production to make 155 howitzers. We are right now out of them. On a monthly basis, we just keep up with them, and that includes buying them from South Korea. That factory is being slow-rolled, and they're having nothing but one after another challenges to get up and make something. And you realize none of us are buying 155 rounds, I'm pretty sure. I wouldn't mind having a couple, but you know. But the fact is, that kind of attack is exactly the kind of attack the administration can do. And so I agree with you that executive action is what we think of as they write an order. Remember, the most of the executive action is actually the bureaucracy there in the so-called swamp going after the very people you rely on to supply you with reliable weapons and reliable ammunition.
Let's take that to an ATF, and we segue to the ATF on that. Because they're using a multi-pronged approach. We know we've been fighting this battle for many years. We know this is a long-term goal. This is a long-term agenda. They're in this for the long haul. They've got Bloomberg money behind them. We have people like this, people like me, people like you fighting on our behalf. We have $25 donations. Yet we win in the courts now because of the makeup of the courts. That can change. And I want people to be scared about some of the answers that they hear from you. Right now, the ATF is weaponized, to say the least. Would you agree with that?
They are weaponized to de-weaponize us.
Okay, so this might be an uncomfortable question. I don't know. You can choose how to answer it however you would. What does that say about the individual ATF agent that is doing the bidding of a government that he knows when he is clearly working for a weaponized agency? And let me throw this number at you. Their revocations of FFLs, as you know, are up over 650%. That number is climbing. There are some indications that it's slowing somewhat, probably because of the upcoming election, but we don't know the reason why yet. What does that say about the individual officer and who's doing the bidding here of the swamp, as we call it?
Well, as you know, I led the investigation of Fast and Furious in the Obama administration. What I discovered there is the vast majority of those agents just want to take guns away from people that aren't supposed to have them, and they believe and build relationships with the actual retail gun dealers. Having said that, it's an agency that from the top down is making it clear what they want to do, and they only need a few people who will execute. And the people executing are the ones that want to move up. So just like the FBI, you don't have to weaponize every agent. You weaponize 10%, and those 10% are climbers who want to get to the higher levels, and you control an agency. And it's one of the reasons that the turnover at the ATF has been increasing. Good law enforcement officers there are going to other agencies.
Well, I would hope that they do. Honestly, with the defund the police movement, with what we saw from 2020 on, there are police agencies around this country that are screaming for good officers, that I would hope the ATF would see a deluge of their officers leave. I'd like to see that happen, but to what extent, I don't know.
Well,
it's occurring now.
Here's one of the challenges as somebody who has a 100% Second Amendment voting record. I want the ATF to exist to do the job they're supposed to do, because we all know that guns can be trafficked. We all know that we want to have safe communities. And we all know that the legal gun business is what's under attack. Well, in fact, the people that have been, the 10 million that have been let in here, some of them are very well armed and committing crimes every day. And the left will point to the very people they let in that are MS-13 that are in fact killing, and there's no way to take those guns away from them. And yet that's part of the ATF's mandate. It's why Fast and Furious was so bad, was they knowingly let the cartels get over 2,000 weapons. And only an organization willing to have people die to prove their point would allow 2,000 weapons, mostly assault, but some of them were 50 caliber sniper rifles and so on that downed helicopters in Mexico. That's the terrible thing. And look, I can say the same. We do want an FBI. We do want the ATF. But we've got to have them work for the people. And today, the Department of Injustice is absolutely working to your detriment, especially if you ideologically are identified as a conservative or pro-life or a Catholic or any of the other obvious terrorist groups that we've heard over our lifetime.
During a Trump administration, hopefully a Trump administration, can that be fixed? Can the deep state, we all know why they're going after Donald Trump. The deep state is actively going after Donald Trump. There's no such thing as a coincidence anymore. Can Donald Trump fix what's happening within the FBI and within the ATF? Do you have confidence in that?
Mark, that's the most important thing to ask and answer. And I'll tell you, it's very simple, but it's very complex. It's exactly like steering a very large ship. A good captain can get you going in the right direction, but he can't do it on a dime. So in Trump's first 4 years, we made a lot of good moves to one direction. In many cases, we're as far off course as we were before Donald Trump came in. So yes, he can steer us in the right direction. And this time, we're better prepared. He knows more. The administration he's going to bring in will do it better and faster. But we have to have more than 4 years. It's one of the reasons that whether it's J.D. Vance or Glenn Youngkin or a host of other good people who could come afterwards, we as conservatives are going to have to recognize that Trump will be a transition back toward a course that we believe in. He won't get us all the way back. He won't fully drain the swamp. He will make a lot more progress this Congress than not. And just so you know, I've had, I don't want to call them arguments, but I've had debates with the president. And debating the president is never quite the same as debating any of you. Because, he's a scratch golfer, sometimes under par, just ask him. And he's always right, but he's willing to listen. When I told him that he made 2 mistakes, I was down in Mar-a-Lago, I told him he made 2 mistakes in his first administration that he could not make in his second thing. He said, 2 mistakes? What were they? I couldn't have. What were they? Who did it? I said, first of all, you told people to vote late and wait till Election Day. That cost you those 50,000 votes, 42,000 votes you lost by, according to the polls. You have to be careful how you tell them you lost. But I told them if we had had early voting in Arizona, we could have won because we would have been focused on people who hadn't voted instead of being focused on everyone. And all over the country, we had that situation. And he now has changed, and you'll notice he's saying vote early. He's helping us win the election for him and for our candidates. And then I said, the second one's painful, Mr. President. If you want to drain the swamp, there's no such thing as a big pump. You need 100,000 pumps. Now, I don't know where you're going to get 100,000 pumps, but I can tell you this. You have 10,000 appointments, and every one of them is a pump. Every person that you appoint, confirmed or non-confirmed position, is if they ideologically believe and want to help, they are part of draining the swamp. We can never again say, I'm going to run the government lean the way I ran my business. Because in your business, everybody wanted to be part of the success of the business. That's not true of the thousands, tens, hundreds of thousands of bureaucrats that if you don't get those positions filled with people who believe in what you're doing, they're running the show. And he said, I've heard that before. Well, we believe that that's the other part of it because the organizations that are pre-screening are hearing back regularly that the administration is interested, they're looking at it, they're making lists. That's going to matter. Now, just so you know that I don't talk to the president every day, I found out it was Mike Pompeo that told him that. And he listens to Mike, who will probably be our next Secretary of Defense. So those things will make the next administration a little more capable of turning the USS Ronald Reagan a little quicker.
I don't want to ask for a prediction on this, but you mentioned if this is a years-long generational shift we're talking about here, isn't it?
Yes.
It's not something that's going to happen overnight.
It's not going to happen overnight, and we have to have one-term presidents change only enough to be unchanged by the next.
He said he was going to be a dictator from day one. What makes us believe he's going to be one-term president? I mean, I heard the Democrats say that anyway.
You know, what's the amazing thing is the Democrats typically say what they do, but they say we do it.
And they're good at it too, aren't they?
They're very good at it. If you want to know what they're going to do, just hear what they say we do.
Let's talk Protection of Lawful Commerce and Arms Act. Very important, protective for the gun industry. We had Tom Taylor, the Executive Vice President of SIG Sauer here, speaking at great length about the danger that the industry itself faces from the Democrats. They'd sue us out of business. You mentioned Remington. Terrible decision by the 4 insurance companies to settle on that because it opened up the door for other companies across the country. We've got other partners at Daniel Defense facing it because of Uvalde, and there are many, many others out there. Their goal is to destroy the PLCAA, to wipe out the firearms industry. We know that to be the case. So my question is, and I don't know that there's really an answer to it, who is directing this? Is this coming from, is there a secret meeting in the Oval Office from Biden that says, do this, or whoever is pulling his puppet strings that is saying, do this, do this, do this? Who's calling these shots?
Well, the answer is people from the Obama team that have been embedded at the Department of Justice are doing most of it. Look, the Oval Office is empty except for the First Lady. Come on, I'm for women's rights. You all saw she did a better job of ordering the cabinet around than he ever did. No, but I'm very serious. The amazing thing about why Biden has been as successful as he's been is it's Obama's third term. The people that were parachuted in there, including the national security team and the names you see, they're all Obama people. And that's the power of this administration. It's also the reason that when I talk about needing more than one term, that's the proof of it. What the Obama people learned, including when President Obama came out here to campaign against me because I pissed him off a lot, they learned how to do things that are hidden. They learned how to do things that were harder for us to undo. They also learned how to slow roll discovery. You know, we've sent subpoenas out, and this Congress is coming to an end, this presidency is coming to an end, and most of what we started doing when we took control 2 years ago didn't get done because they've begun very, very good at slowing us up. And it's one of the things that Congressman Jordan and myself and others are looking at for the next Congress. If President Trump is there as we expect, we're not going to need to do it. But if not, we are going to be dealing differently with the administration. We are no longer going to be, if you will, going through A, B, C, because we found out they figured out how to run out the clock on that. And particularly on discovery. Most of you probably don't know this, but the Freedom of Information Act is your tool to find out things about the administration. Today, we sometimes get FOIA responses faster to give us information than our subpoenas. That makes no sense at all. So one of the things that you'll see in the next Congress, including under President Trump, is an expedited review so that we never again issue a subpoena and then have them run out the clock. And we need that because if we don't know, certainly they're not going to want you to know.
You mentioned, I'm just going to throw this out there, but you mentioned the reason the administration's been so successful. I'm paying $11 for eggs. Okay. I'm paying $4 for gas in Georgia. Out here in California, it's far higher. So when it comes to the economy, when it comes to gun rights, when it comes to the constant fight that we're in with this administration, where have they been that successful? In what regard have they been that successful?
Well, certainly they've run up the cost. They've run down the supply.
Intentional.
Right. They've run down the supply. And, you know, for all practical purposes, I mean, California, I'll just use that for example. California has the chutzpah to say that the only people that can buy a modern 9mm, a current design, are law enforcement. And their basis for it is that the new ones aren't safe enough because they don't comply with the new law where, you know, it's got to read your fingerprint, read your mind, and so on. You didn't know about the read your mind, that's coming.
He's telegraphing to us, ladies and gentlemen. He knows more than we do.
But it's bizarre. I go to Nevada and I go to a gun show and I see all these guns that I can have delivered to Virginia, or but I can't have them delivered to California. That's pretty much sucks. The thing about a Harris presidency is she knows exactly what she wants to do to the nation. It's what California has done to gun owners.
I'm glad you mentioned that. Let's kind of segue to confiscation, because Kamala Harris has made it very clear that she is a gun owner, and if you come in her house in the middle of the night, she's going to shoot you. She made that very clear. She said that. So I'm going to take her at her word.
I'm going with squirt gun.
Squirt gun? I'm going with Secret Service, not her gun. So far, we've seen no indication of what gun she has. She's refusing to answer any of those questions for obvious reasons. You can decide for yourself whether she is or not. I believe that she is a gun owner. She probably is. And frankly, she has a right to be a gun owner. She should be a gun owner. But she wants to take my guns away from me. Let's go to the confiscation. I have played on my show countless tapes of her talking about taking my guns and forced buybacks, and I've played them in a montage, dozens of them. But not anymore. The ultimate goal for her, and I want people to hear this, when given the opportunity, she's going to come for my guns, is she not?
Her values have not changed.
There it is.
If her values have not changed, believe her. And her values are she's coming for your guns. And if she says anything different, it's just a campaign stunt. This, you know, it's one of the oldest tricks in the book is, well, that was just a campaign promise. It doesn't matter. The only person I ever saw that kept a campaign promise was President Trump.
Yeah, that's a great point. Thank you for bringing that up. The media will never tell us that. You know, you and I did mention this in the hallway. She's made it clear. She said during the debate, again, I'm being a little facetious here because we have to. Again, we're trying to prove a point. And I know this group understands that, but I want you people to take this home with you and make this very clear. When Kamala Harris said, no one's coming to take your guns, I'm a gun owner, stop with the lies. Who is believing her? No, you know what? Let me go a little further.
Well, I guess moderate swing voters, because the reality is none of you believe it. But see, you're probably not Harris's target audience. You notice I used target there, right off the bat. She knows her audience, and that's what she was doing in the debate. It's why she could wink with one eye and say, my values haven't changed. Her base heard that. And then the moderate swing voter heard, oh yeah, she's no threat. She's going to be fine. No, she isn't. She's going to do exactly what they're already doing in an administration that she has been in for 4 years. Vice presidents cannot be fired by the president. They can differ with the president. They can show some independence. There is no sign of that, just the opposite. She's been delighted with what they've done. She's been there all along. Remember, she was the last person in the room before when they decided the plan on how to leave Afghanistan. See how that worked out.
Mm-hmm. She seems proud of that.
And by the way, you want to talk about taking away weapons, that was, $82 billion worth that got taken away, but, they're sitting in Afghanistan.
Yeah, it's remarkable. This is kind of a broad brush question that I really hadn't planned. How did we get here? How did the country get to a point? I'm 62 years old. I'll be 63 on May 5th.
You're looking pretty good.
Thank you very much.
Facelift, eh?
That's what it is. It's a hair dye I use. What do you call it for men?
Grecian formula or whatever?
That was my grandpa used that. It'd be green if that
Oh, okay.
Because his was, and I knew he used that. I attribute things to, I'm a media critic for 20 years in the media myself. I trust nothing from the mainstream media, and mainstream legacy media, whatever you want to call it, the ABCs, NBCs that we watch so that we can all CBS, MSDNC, CNN, and the rest of it. And I think most people in this room understand that as well, all people in this room to speak for them. But when you combine that power of that media with instant information today, with the power of social media in a 24-hour news cycle, I believe this is doing tremendous damage to the psyche of the nation. And I don't know that we can ever put that genie back in the bottle. And the Republicans had better figure out how to start using that to the advantage that the Democrats have figured that out. Is this fixable? I don't know if it's fixable. I don't know that there's an answer to that question. But we're in very dangerous times in this country.
We are in dangerous times, and and this may be as a member of the Judiciary Committee, I have seldom seen that more information is the goal of the left. I've always seen that what they want to do is have more of their information, that's fine, but they want to stifle what you see and hear. So I think the saving of we're not putting the genie back in the bottle on things being alternates to conventional and historic radio, TV, and print. Social media and other internet access, it's here to stay. The question is, will we let the left define what the truth is and then eliminate what you'd like to read? Because what you want to read is hate speech. What you want to read is misinformation and disinformation. What you want to read should be taken down, and that's their goal. So we go back to that Second Amendment protecting the First Amendment. The First Amendment, in no uncertain terms, says free speech will not be abridged by the government. And that means that the government shouldn't directly do it. It also means the government cannot lean on Facebook or, in the old days, Twitter or any of these other social media platforms, which they've done. And they've done it again and again. And it's the one thing that was difficult for Trump, because he and his administration had to undo some of that. And to be candid, some of it didn't get undone during his administration. We only discovered and proved it. I mean, we've literally had Zuckerberg admitting that he interfered with the election because he was ordered to, and he regrets it. Now, he didn't regret it because he had an epiphany and he became Elon Musk's best buddy and they're all libertarians. He regrets it because it embarrasses him that he was part of stifling accurate free speech. So the answer is your Congress and your courts have to believe in free speech as much as our founders. Only through that will we protect the rest of our rights.
Well, it's powerful stuff. I'm going to switch over to Trump real quick. I believe Donald Trump's going to win the election. I've gone as far as saying I believe Donald Trump's going to win with 312 electoral votes. Now, I called the 2016 election.
We're never going to get tired of winning. It's going to be so big. 312 at least. We're going to so big.
It's going to be the biggest thing. That was very good, by the way. Very good. Don't pay any attention to him, right? He's wrong. He's just trying to inspire people to be inspired who aspire to inspire other people. That's simple, right? So aside from that, I believe Trump.
You got to be a little careful because you slip into that with the president. He doesn't always think it's funny.
Glad you have the opportunity to do that. I believe he wins the election. I'm going to assume everything's fair.
Well, he won it the last time. It's just that
He did.
there were a few complications in making it happen.
Pennsylvania and Fulton County, Georgia, where I'm at too, or I'm not in Fulton County, but I'm close enough to it to be considered.
By the way, this isn't Second Amendment, but I think it's important. I voted on not certifying Pennsylvania and Arizona, and had we had each of the states offered to us that had violated the Constitution, they had sent out universal ballots or in some other way made those changes that very much favored the other party, and done so outside of the absolute clear words of the Constitution, I'd vote that way again. And I hope every American understands that the people who voted that way voted exactly the way they were supposed to. And sometimes the whole January 6th argument becomes, well, you were trying to overturn an election. No, I sued our governor here in this state. He went back to the legislature after he had issued an executive order, and he got the legislature in this state to give him that universal ballot. And we dropped the case because he had done what was constitutionally allowed, even if I disagree with it. Those other states didn't. And that's something that we should all remember, is that when the Constitution says only the legislature can decide the time, place, and manner, it's there for a reason. And so in this election, when I say Trump would have won, I thoroughly believe that had those states not violated the Constitution, Trump would have prevailed. Yeah. And that's an important thing because why did they violate the Constitution? It was COVID. It was COVID and the left. And you mentioned Michael Bloomberg earlier. Michael Bloomberg not only spends hundreds of millions of dollars a year, but he uses tax loopholes because he uses charity money to do it. He's got 501c3s where he looks like he's giving to charity. He doesn't pay any taxes on it, and that's the money he uses to take away your guns.
And it's funding the every towns and the rest of them. So back to Trump for just a second. Let's assume he wins. Let's assume I'm right. I might be a little bit overly optimistic on the electoral count. Let's assume I'm right. He made mistakes regarding, he was criticized by Second Amendment groups, the bump stock ban, et cetera. Now, all that's been overturned in court. We're winning those cases. Has Trump, and I say this because I had a conversation with Dr. John Lott moments after he spoke with Trump before the Montana rally a few weeks ago. And he said he felt Trump had an epiphany just because of the questions he was asking John prior to that rally, that he later used some of John's answers at that rally, which I thought was kind of neat, so did John. Has he learned his lesson in a second term? He's out making comments now that he needs all gun owners to vote. Has there been a change? Do we have even more of a friend in Trump now from a gun rights standpoint?
One thing about President Trump that I learned early on when he was calling me up, asking me 4 questions and expecting them to be answered in 1 minute. He looks for very quick answers. He never quits questioning anything. And I think it's a good thing, and it's one of the best traits about him is, yes, he has his values, and they are real. But he still says, what about this, what about this, what about that? And it's an amazing item because what happens is he continues learning. So yes, President Trump can make mistakes. We all can. I remember early on, this is unrelated, but it's a good example. You know how he talked about NATO not paying their fair share because NATO didn't pay their fair share. They didn't pay what they had agreed to pay, which was 2% of GDP. But he used to also include Japan. And I remember calling him up one day, and this is back when he directly answered his phone. Now I have to text and wait for the call. But I called him up, and I said, he wasn't president then. I said, Donald, you can't be saying that. Our Marines there in Japan, they pay for everything. Yes, it's our Marines, but it costs us less to have Marines in Japan than it costs to have at Camp Pendleton. You got to remember, they're paying every penny allowed under their Constitution because We told him to have a constitution that says you don't have a military. You kind of expect that. Oh, okay. He learned, he stopped saying it, and by the way, during the Trump administration, Japan, under his leadership, began to become a partner in protecting our assets. They've expanded the military capability. They now have an agreement with the Philippines to help them. They are beginning to be part of our ability to fight against China. So where we have all of NATO in Europe, Trump went from bad-mouthing Japan, because he'd been doing it since like 1990, to recognizing it, and his administration made those changes that are making our ability to confront China a reality. In his second term, he's going to do that. In the same way, his understanding that bump stock was, that was just a gimmick to take away little by little your rights.
Green lighted by the NRA in that too. They gave him a green light to do that. We get that.
Okay, but he does learn, and he does continue to learn. And I know you never talk about abortion anywhere where it's not brought up, but I'm in California. Our law in California was signed by Ronald Reagan. Okay, Ronald Reagan, when he got to be president, knew he had gone too far, that California was not where it should have been. And during his entire time, he was promoting respect for human life. So our greatest leaders also do things that later on they do better. And I believe Donald Trump is one of the greatest leaders we've ever had, because he never stops asking, he never stops thinking, and he's not willing to admit a mistake, but he's willing to change.
He has his faults, but I agree with you 100%. He absolutely is.
Come on, wait a second. Every married man here understands, okay? Okay, your job is to admit your mistake and change. The other way around, be glad if you get a change. Just saying.
Tell us from a legislative standpoint, if you would. I know the clock is winding down. We've still got 10 and a half minutes, but from a legislative standpoint, let's make an assumption that Donald Trump wins the presidency. Let's make an assumption that the Republicans hold the House, and let's make the assumption that the Senate flips, which is a very real possibility. All of that is a very real possibility in today's environment. Legislatively, what can we as gun owners expect to protect our rights? Maybe to strengthen the PLCAA, maybe to strengthen laws against frivolous lawsuits coming after the firearms industry, even outside of that. What can we expect? Will there be national reciprocity? Some of that's been outweighed because we have 30 states constitutional carry now. But can we expect to see some of that pro-gun legislation move through the House and Senate to help us shore up our gun rights in the future against another possible Harris administration?
I think you can expect to see the House lead, pass significant reforms. Those reforms most of them would die in the Senate, because we're not going to have the 60 votes. But when it comes to reining in administration, including the ATF, where we can use procedures that get us just 51 votes in the Senate, you can see changes. And look, administratively changing the very mandates of the ATF and the constraints on them, that's doable. On top of that, I'm not Dutch, but I remember as a child hearing about the little Dutch boy putting his fingers in the dike. Under a Trump administration, his actions, his rulemaking, his interpretations, we will be there to make sure that nobody confronts and undoes it. And by the time he leaves office, we will have made those reforms, and those reforms should stick. There's one more thing that's going for us. The Chevron doctrine was just overturned.
That's great news. That's great news. Chevron deference, of course.
Chevron favored the left, and it favored the left because they like more government, more regulation, and Chevron said, well, we have to assume the administration acted in good faith when they piled on more than what the law said. It is rather rare, if ever, that an administration, Republican administration, will either pile on more than was there, and certainly you can't strip beneath what a law says to do. So the fact is, under the elimination of Chevron, we're going to see the administration say, this was excess, we're going to redo the rule, and it's going to stick. because they're not going to be able to then lift it back up. So there will be hundreds, probably thousands of existing administrative things, including overreach in the gun control world, especially as to federally licensed firearm dealers, where those changes will be reformed under Trump and they will not be overturned in the court because of the change in Chevron. It's going to be a huge advantage to us. The other thing is we control the purse string. And quite frankly, agencies that are not doing their job but spending all the money will be lowered in funding. And agencies that are willing to do their job will get their full budget. And that is going to be the most powerful thing that a House and a Senate under Trump, because Trump's going to say he wants them to do he wants ATF to do the part we expect, which is get the guns from bad people, from real criminal organizations, to follow the trafficking of weapons. That's fine. But stay the hell out of looking for one wrong piece of paperwork and then taking away a second, third, fourth generation gun dealer his entire livelihood on a technicality, or making the paperwork changes so that even with a company that computerizes it, you still can't keep up with the filing fast enough. Yep. Those changes we're going to see very quickly in the Trump administration.
So you feel confident that both legislatively and through Trump, we're going to feel better, we're going to feel safer for the next, hard to predict, I mean, how many years, I don't know the answer to the question, but
well,
I know that we feel, but I want people to feel better about what happens after a Trump administration.
Well, first of all, I don't deal good in the feelings. That's for Democrats. They're into the feel good. You will be safer, your rights will be safer, and we will make sure your rights are safer against changes. Even in the first 4 years of the next administration, we will make those changes very hard to overturn, so you will be safer. And the other side will not feel good.
You know, it's interesting because the Democrats have shown a propensity to ignore whatever court decisions they don't like. And we could name countless times. Donald Trump shores up the Supreme Court again. Thomas resigns. We know that will happen in a Trump administration confidently. Trump replaces him with somebody equal or better, if possible.
It's hard to do better than the late Anthony Scalia or Clarence Thomas. Those are once-in-a-generation justices.
They absolutely are, but we feel confident he'd put somebody in there that would at least match what they were trying to do from a judicial standpoint, right? All right, so we feel better there. We've got a shored-up Supreme Court. The left doesn't care anymore. They don't care. A next administration comes in, they're still going to have to deal with a conservative Supreme Court. They don't care. Look at what they're doing to Bruin in states like California. Look at what your governor here is doing to Bruin. They're skirting it every time they can. New York, they're still doing it. Massachusetts, still doing it. Jersey, still doing it. Throwing it in the face of the Supreme Court. What happens there? That's a very dangerous place for us to be if there's no respect for the rule of law in this country anymore.
Basically, there's a flaw in the Constitution, and I don't mean it to badmouth the Constitution, but there is a flaw, which is all power, including all power of the courts, belongs to one man. Could be a woman someday, but not this time. And that one man is the president, because the Attorney General serves at the pleasure of the president. No one can be indicted except through the actions of those people appointed by the president, which is a delegation. Congress cannot indict. The courts cannot act sua sponte, to use one cool word I learned. A case has to come to the court. The court cannot grab a case. So the reality is, the only way that we can make you safe in a world in which a president doesn't care about the Constitution, doesn't care about the clear intent, is to find ways to give you rights to go to the courts. And then if you have the rights to go to the court, you can get justice. And then we have to make sure that the court gives justice. And one thing that you're going to see, the bill is already passed the Senate. It will pass the House after this election. We're going to add 600 new judges. 63 new judges to the 600 and some judges we have. It's about a 10% increase in the court. I can tell you that our intent is to do that so that in addition to the normal replacement, there will be 63 additional judges that the president over the next few years will be able to appoint. And Chairman Jim Jordan and myself, it's my bill, but we work together on it along with Todd Young out of Indiana. We're prepared to improve the lower court, the appellate courts, and with the president, the right president, maintain a conservative court. That's where we're prepared to do. We're also prepared to give more laws that give you rights to seek redress, which is important because you can't count on this one problem in the Constitution, which is, you know, I'll give you an example. When I held Eric Holder in contempt, Congress voted, the law said the U.S. Attorney for the District of Columbia was to bring those charges. You know what he did? He took his orders from, the joke was, Eric Holder on behalf of the president, and he didn't bring the charges. The problem was we never created in the law the ability for us to go and bring the charges. We did get a compelling order and we got the discovery, but we didn't get what we should have gotten, which was real action. Those changes are going to happen, but right now the most important thing we can do is make sure that you have the right to bring actions. And I will say this, organizations that are willing to help fund people and companies that have been individually harmed by executive action are critical. So any of you who give to those organizations, I can't lobby for them, but I will tell you the very existence of those organizations that often do the court work or write the amicus briefs are extremely important, and I know you've worked with them all for years.
Yeah. What's your, probably my final question is this, and what is your advice to us as leaders in the gun rights community between now and November 5th? What would you, if we had a magic brush, what would you ask us to paint on that canvas?
I think the most important thing is to simply have like-minded people that you meet anywhere, but particularly in those swing states, understand that Harris and her core values absolutely are to the detriment of our Constitution. Absolutely, she will take away your guns both figuratively and literally. And that's about the most important thing. We're down to 38 days. In 38 days, well, in 19 or 20 days, enough people will start voting that you'll be talking to people and they'll tell you how they voted. We have to make those calls. If you've got a website or you've got a Facebook account, put something down on it that says, I'm scared, I know why I'm voting for Donald Trump. That will make a difference. And look, gun owners are people. And sometimes when you say, I'm a gun owner and that's why I'm voting for Trump, we get lost in the fact that your neighbor just knows you as a responsible individual. They know you as a good father. Tell people you're voting for Trump because you believe in people's rights being maintained, because whether sometimes he's a handful, but at the end of the day, his policies are good for a free America, a prosperous America, and by the way, an America that protects liberty here and around the world. And that's the Trump I'm voting for. That's the Trump I just came back from campaigning for and I'm going out to campaign again for. And that's one of the greatest honors of my life, is to be able to support candidates. The next greatest honor is every once in a while I get to come to my hometown and meet with people who believe in the Second Amendment strong enough to come from all over the country. So I saw the clock run out. I'm running out the clock, but I want to thank you all for being here.
David Muir is not in the room. Rachel Maddow is not in the room. Joy Reid is not in the room. From the chairman of the House Judiciary Committee at this stage, does Donald Trump win this election?
I don't know how to tell you this, but Mark's wrong. He's not going to get 300 plus. He's going to get 277 plus. He will be our next president.
Boom. That's all I wanted to hear. Thank you, sir. Great stuff. I appreciate it. I don't know.
I like the cigar.
Ladies and gentlemen, if you could come back to your seats, we've got more presentation. This was an unscheduled break. Ladies and gentlemen, if you could come back to your seats, this is an unscheduled break. Thank you. Ladies and gentlemen, if you could come back to your seats, this was an unscheduled break. We'll start the program at 24 after. Thank you. Ladies and gentlemen, welcome back. We're going to continue now with a video, The Necessity of Involvement, Consequences of the 2024 Elections, from Chris Cox, founder and president of Capital 6 Advisors. And you know Chris is the former executive director of the NRA-ILA. Go for it, guys.
I want to start by saying thank you for being here today. A group of patriots joining together to discuss freedom and how to protect it, that's about as wholesome and American as it gets. I also want to thank SAF for giving me an opportunity to share some thoughts. I wish I could be there in person, but I'm pretty sure the jackass governor still has a hit out on me. Gavin Newsom's worked hard to destroy that amazing state, but he's had a lot of help, and I'll get to her a little later. I know Gavin's not there, but I'm glad you're joined by some great champions. Tom Taylor has been in the industry and the Second Amendment community for decades. I've witnessed firsthand his commitment to freedom and the unapologetic approach he brings to the cause. Kenyon Gleason is another champion. Kenyon understands this freedom is defended not only in legislatures, but also in courtrooms, in the court of public opinion. Congressman Darrell Issa proves there are still sane people in California. His constituents are lucky to have him, and we're lucky because we need him in Congress. I've known and worked with Lauryn Hill and Bobby Cox and Rebecca and Knox and Chuck Michelle for a long time. Like each of you, they're patriots and dedicated to the cause of freedom. And I appreciate my friend Jim Giudice. Jim and the team at Public Square are creating financial solutions to protect the Second Amendment economy. And I want to thank my friend Tom Gresham. We haven't always agreed on how we get there, but we always agreed on where we wanted to go. There are few who speak out in general, and none who have done it longer or better than Tom Gresham. And I'm honored to call Christian Craighead a friend, and I just want to thank him for being a badass and killing a bunch of terrorists. Finally, I want to thank Alan Gottlieb and Adam Kraut. As we celebrate the 50-year anniversary of the Second Amendment Foundation, it's appropriate to say thank you to Alan Gottlieb. Dedicating your life to a cause and pushing through despite personal and professional attacks, it's not easy. Alan's fingerprints are on far more than the historic legal decisions. For 50 years, Alan Gottlieb's been a visionary for the Second Amendment, and we all owe him a debt of gratitude. So Alan, thank you and congratulations on 50 years of defending freedom. And as we look to the next 50 years, I'm comforted in knowing Adam Kraut will be leading the efforts. For those of you who have followed his career, you know that Adam has already made a big impact in the gun world through his educational YouTube series, The Legal Brief. And I know he's committed to making education a core function of SAF, because that's the way we get more people to get involved in helping protect and defend their Second Amendment rights. Adam also brings forward-thinking litigation strategies with him, and he's building a team of experts to make sure that SAF stays as strong legally in the future as it has in the last 50 years. But today I just want to briefly talk about what's at stake. The theme for the conference this year is Empower, Educate, and Defend. I've spent more than half my life in this arena, and if we don't empower and educate, we cannot and will not defend the Second Amendment, because elections have consequences. Every year someone says this is the most important election of our lifetime. This year, I believe that to be true. The Second Amendment and everything we fight for is on the ballot this November. Just think of the consequences of 4 more years of liberal judges being appointed. Joe Biden's already appointed 200. What happens if we have an anti-gun Senate and they change the filibuster rules? Can you think of an agenda they would want to pursue more than their gun ban agenda? What happens if an anti-gun Senate decides to stack the Supreme Court? How long until we see Heller and McDonald and Bruen overturned? What happens if President Kamala Harris has the opportunity to pursue the agenda she's unapologetically supported her entire career? Well, at least until the last few months where she's had to tone it down because of the elections. Her agenda includes gun bans moving forward and gun confiscation for those of us who own guns now. That's what a mandatory buyback program means. Turn them in or go to jail. Her agenda includes regular visits to your home by law enforcement to check in on you and your guns. How will she know who owns firearms? Well, gun registration's on her agenda as well. So how do we fight back? How do we empower and educate and defend? You're here today, so you already know. It starts with getting involved. It starts with registering to vote, and then making sure you get other gun owners to register and turn out as well. If every gun owner was registered and every gun owner voted for pro-gun candidates, do you know who we would elect? Whoever the hell we wanted to. So stay involved. Support the Second Amendment Foundation. Join and donate when you can. Support the corporate partners that support SAF. Support the elected officials who've earned our trust, like Darrell Issa. The short answer to how we empower, educate, and defend is that we do it together. We don't do it for credit. We do it for freedom. We do it in respect for those who have given their lives for the cause of freedom. And we do it for the future generations who deserve to inherit the same freedoms we enjoy today. So thank you for listening. I hope you all have a great conference and a safe trip home to your families, and God bless.
Thank you to Chris Cox, who could not be here. We appreciate it. Now we're going to really stay on track right now. Joining us now on the stage, Rahimi and reining in Rogue Administrative Agencies, Mark Smith, attorney and constitutional scholar. He's a legend here. You also know him as the wildly popular host of the Four Boxes Diner YouTube channel. Mark, welcome up. And I want to point out that he has got complimentary books on hand, and he will be signing them as soon as he's done. Okay? Mark Smith, welcome up. Have that. Timer's right in front of you, 30 minutes.
Major breaking news. I'm just kidding. All right, we got a lot to cover in the next 30 minutes. I hope you're ready to take some good notes, a lot to discuss. Before we get to the details of what I'm going to talk about, I want to let everyone know yet again, what is the Four Boxes Diner? The Four Boxes Diner is named after the four boxes of American liberty. The cartridge box, which refers to the guns. The soap box, which refers to the First Amendment. The ballot box, which refers to the right to vote. And of course, the jury box, which refers to the right to jury trial as well as the rule of law. This was made popular in the 19th century by abolitionist Frederick Douglass, who talked about you cannot be a citizen if you do not have the three boxes, he had three boxes then, of American liberty. You cannot be a citizen, and one of the critical, essential characteristics of being a citizen and not a serf or a slave was the right to bear arms. Now, the diner references casual conversation and not a lecture, but people always ask me, what is the Four Boxes Diner? And that's where it comes from. So today, to get down to substance, there's three things I want to cover. First of all, we're going to talk about the current constellation of the Second Amendment and understanding how the Rahimi decision from earlier this year fits into that constellation of Second Amendment cases, and overall, the Rahimi case was very good for us. We'll talk about that. Then I want to talk briefly about the absurdity, the craziness, the inconsistency of this sort of ridiculous Joe Biden-Kamala Harris ghost gun rule that's being challenged in an oral argument before the U.S. Supreme Court on October 8th. We're going to talk about that. You're going to be shocked with some of the things that we've uncovered there. And then we're going to talk about how we interplay, the interplay between Second Amendment arguments and arguments arising from the Loper-Bright case in the Supreme Court's administrative law, regulatory law precedents. We're going to do it in the context of suppressors to see how they all work together to vindicate our right to keep and bear arms. It'll be very detailed and geeky, so I know you Four Boxes Diner fans will really like that quite a bit. So before I get there, though, there's one critical lesson. If you can only remember one thing from my discussion today, it's I want you to know about someone who, if he were alive, would have received an award from Alan today at the luncheon. And it's an important figure that has largely been lost and should not be lost because he's extremely helpful to the Second Amendment movement, and we can use him in many respects. Because remember, a reason why we should be proud to be Second Amendment supporters and advocates in this great country is because we not only have the law on our side with the Second Amendment itself, we also have the history and public policy. All these arguments, if you're intellectually honest in my view, all work in favor of the right to keep and bear arms. Now, I want to take us back to the year of our Lord, 1764. 1764. Like, why are we going back there, Mark? Well, I'll tell you why. Because there's a man I want to introduce you to, Cesar Beccaria. For anybody who talks to the media, who writes articles, that does scholarship, that does law review, talks in the media, whatever it is, you need to know Cesar Beccaria. He's extremely helpful. Cesar Beccaria was an Italian criminologist who wrote in the Enlightenment era, who was so influential when he wrote a book called On Crimes and Punishment that both Thomas Jefferson and John Adams literally wrote about this man and his thinking as they were negotiating and dealing with the creation of our country and, of course, the Constitution. And why do I say this, and why is this so important for you to know this? Is because some of the most powerful languages in support of the Second Amendment came from this Italian Enlightenment philosopher and criminologist who's largely been lost to history, although I'm trying to bring him back. The first thing he writes about is that just because something can be misused, or just because something can give rise to injury or damage, does not serve as a basis to ban it. Sound familiar? This is what he wrote in the year of our Lord, 1764. This is not an NRA slogan from the 21st century. This is 1764 with a man who was so influential to the founders that his book was available for the people that drafted the Constitution as part of their little library they put together. This is what he writes in 1764, Caesar Beccaria. False is the idea of utility that sacrifices 1,000 real advantages for one imaginary or trifling inconvenience. Listen carefully. That would take fire from men because it burns. Water would be banned because you may drown in water. Thus, that has no remedy for evils except destruction. He goes on to say that the laws that forbid the carrying of arms are laws of such a nature. That's literally his language from 1764. He points out that they disarm those only who are neither inclined or determined to commit crimes. Again, gun bans ban guns from the law-abiding and not from actual criminals. 1764, that idea was articulated by the man that was highly influential in the creation of our Second Amendment. And he goes on to say, as a matter of public policy, in 1764, hundreds of years ago, right? Before sloganeering from the NRA or whatever they want to say, he goes on to say that gun bans only hurt the law-abiding. Here's what he writes. Gun ban laws make things worse for the assaulted and better for the assailants. They serve rather to encourage than to prevent homicides. For an unarmed man may be attacked with greater confidence than an armed man. Caesar Beccaria, 1764. It's very important that you know him. He's very influential. So whenever the anti-gunners like to say things like, this is made up by this radical court or this and that, you have a historical baseline from which to argue intellectually and whatnot about where the founders were coming from. So with that said, let's turn to the 21st century and let's talk about the 5 most important Second Amendment cases you need to know about, the 5 Supreme Court cases that make up today's constellation of Second Amendment jurisprudence. We're going to run through them quickly and then I'm going to explain to you how to understand the recent Rahimi case within that constellation. We all know that in 2008, the Heller decision came out. It basically stood for 3 propositions. The first is that the Second Amendment indeed protects an individual fundamental right that's on par with the right to life and the right to liberty. It also says that you cannot ban a category of arms that are in common use by Americans for lawful purposes. And it goes on to say that you cannot interest balance away, the government cannot interest balance away your rights in the name of some state interest or government interest or public policy benefit. That was Heller in 2008. In 2010, in the McDonald case, of course, they took that basic propositions of law from Heller and applied it against the states and localities to say it was a fundamental right. They used the phrase fundamental right, something on the order of magnitude of 14 to 15 times in the McDonald case, proving that the Supreme Court really, really, really meant it. Then in 2016, for our friends out there in knife rights, this 2016 Caetano case, they made it clear that the word arms, as in the right of the people to keep and bear arms, does not just include firearms. It includes other kinds of arms. Anything that can be used offensively or defensively is an arm. Specifically, they talk about stun guns being a protected arm under the Second Amendment in Caetano 2016. And then, of course, and now we're going to get to a critical teaching moment. Okay, I'm not going to name names here, folks. 2022 Bruin. Now, Bruin does 2 critical things. The most obvious one is they say that the right to bear arms means the right to carry guns in public for self-defense. Fine. Great. That's a no-brainer. The right to keep means to possess. The right to bear means to carry. Okay. Here is the next thing they do, and this is important to understand this distinction. Do not mess this up because the anti-gunners want you to mess this up, but you're not going to mess this up because you will be the smartest person in the room because I will make you such. Bruin was not groundbreaking. Do not say that Bruin was groundbreaking. Bad idea. Bruin was not groundbreaking at all. All Bruin did is it took the Heller methodology of text first, history second, and wrote it out in a paint-by-number approach so that the lower courts that had been ignoring the law from 2008 to 2022 would no longer mess it up. It was not groundbreaking. Heller was reaffirmed. In fact, if you read the Bruin case carefully, it reaffirms and speaks positively about the Heller precedent, and this is very important to our rights. We'll get to that in a minute. It speaks positively and reaffirms Heller somewhere on the order of magnitude of 70 times, okay? So don't ever say Bruin is groundbreaking. We're going to talk about why in just 1 second. It's very important. It's simply a reaffirmation and a spanking of the lower courts that refused to read the Heller decision correctly. That's all Bruin did. It was very important, yes, but it really was not groundbreaking. So with that said, let's turn to Rahimi. Now, Rahimi was decided. This was a catastrophic loss for the anti-gun movement in America. It was a catastrophic loss for Merrick Garland, Kamala Harris, and Joe Biden. And you're saying to me, I don't understand, didn't Mr. Rahimi lose? Yes, he did. But remember, when you look at a court case, there's two critical things that you generally want to look for. One is who won the case. That can be very important, yes. But there's something more important for the Second Amendment movement than who wins the case. It's how the person won or lost the case. The methodology, the interpretation, the approaches, that is what really matters to us, because whatever the Supreme Court says as to how you win or lose a case, the methodology, the way to interpret what the words mean, is something that we in this room will all have to live with for years, if not decades to come. So the methodology and the approach. Now, the reason why this is important is Mr. Rahimi, it's true, lost the case because his record was absolutely terrible. You all know that. His record was terrible. 5 related shootings, including a gunfight associated with a credit card being declined at a fast food restaurant, taking his girlfriend's head and hit it into the dashboard, and when a witness saw it, he shot at the witness. Not a good... Now, why is this a terrible situation, what happened? Because Merrick Garland, if you may recall, rushed this case to the Supreme Court. He refused to grant any kind of real extensions to the public defender's office that represented Mr. Rahimi. He sped up everything to make sure that the very next Second Amendment case before the U.S. Supreme Court was the Rahimi case, because it was such a terrible set of facts with a terrible scumbag guy based on the record, and he thought this was his chance to destroy the Heller-Bruin methodology because bad fake facts make bad law. And they utterly failed. And this is the critical takeaway from Rahimi, which is Rahimi, rather than saying we're going to run away and not do it, it reaffirmed Heller and Bruin. It says, no, this is how you do it going forward, and this is how we apply it to the Rahimi facts, which gives rise to what Rahimi is really about and why it's so good for us. For those of you familiar with the scientific method, there's someone known as Thomas Kuhn, and he's the guy that talks about how the scientific revolution works, and it's a good metaphor for what Rahimi means. Thomas Kuhn wrote that you have the scientific revolution, they figure out how you do the scientific method, you propose the hypothesis, and then you test it out, this thing. Once you establish the methodology of doing the science, everything that comes after that is a routine application of the scientific method. Heller, McDonald, Bruin, and Caetano was essentially the scientific revolution, if you will, the gestalt of those cases with the scientific revolution, if you will, of Second Amendment jurisprudence in America. Everything that follows those cases, those 4 cases, is nothing more than a routine application of the existing scientific method. All you're dealing with now, from Rahimi to the quote-unquote assault weapon bans, propaganda term, the age cases involving 18, 19, and 20-year-olds, the licensing issues, these are nothing more than a routine application of existing law. In other words, and this is why it's so powerful for us, you've now moved the Second Amendment from a groundbreaking set of massive changes, if you will, metaphorically, into the world of just routine application of law. No different than every year we get First Amendment cases, every year we get Fourth Amendment cases, every year we get Fifth Amendment cases, every year we get First Amendment cases. Now every year we're going to get Second Amendment cases. It's going to just be part of the normal routine application of the groundbreaking law that we got, starting from Heller through, of course, Bruin, if you want to put those things kind of together, okay? So that's why this is so good. The Second Amendment has finally moved to a world where it's in the ordinary course of just handling Second Amendment cases like any other constitutional right, and that normalization and mechanization, if you will, of this law is very good for us because it makes it much more difficult to the point where you can't get rid of it. Even the liberals on the court kind of acknowledge that this is the way that text first, burden shifting to the government to do historical tradition analysis, that is the methodology going forward. And the attempt to destroy it with the Rahimi case utterly failed. That's why Rahimi ultimately is a big win for us. And that's how to think about it. Okay, Vanderstock. Vanderstock is going to be argued on October 8th. I think somebody's going to be doing a presentation, so I won't belabor the point beyond to say that this is the case involving this is the ghost gun case, which is, of course, a political propaganda term for what Well, these are just privately made guns, or these are unserialized guns. And what the Biden administration did, of course, is they used an executive order to try to say, we're going to expand the definition of what a frame or receiver is, so that we're not just going to ban essentially frames and receivers, regulate frames and receivers. We're now going to regulate things that can become frames or receivers. Now, I'm going to tell you what they did, and I'm going to tell you the absurdity of the argument. What they did is this, and this is how to think about the Vanderstock case. It's a complicated case, but I'm going to make it really easy for you right here, right now. Up until this new rule of the Biden-Harris administration, the way the ATF dealt with these frames or receivers or partial frames or receivers or whatever you want to call them, the weapons parts kits, was as following. They looked at the object and they said, what is this today? What has been done in the past through the moment in time I'm looking at this to figure out whether or not that is a frame or receiver under the definition of firearm in the gun control act, right? They looked at the past up to the moment and said, what is this object? The sleight of hand that is now taking place with Harris and Biden and this new rule is, instead of saying what happened in the past, backward looking through today, they've now changed it. And now they ask, what can this become looking into the future? Oh yeah, this little kid playing on the playground could theoretically become Tom Brady, right? He could become the president. He could become this, he could become that. So you see what they've done? They went from looking at the frame or receiver, the alleged frame or receiver, and backwards to what it could become. And now they're saying, well, if you do this and you make this and use a screwdriver and you use a Dremel tool and you this, right, then it could become a frame or receiver. Now that's hooey. Now to prove that it's hooey, I'm going to give you two quick examples, and that's this. Number one, tell me if you think this sounds a little internally inconsistent. And they submitted this, mind you, to the United States Supreme Court. Now, you can say what you want about the Supreme Court, but I can assure you they're not dumb. They're some of the smartest people on the planet. Now, we can disagree with them, but they're not dumb. The ATF's position in Vanderstock is literally this. They're saying, oh my God, a few years ago we realized there's this extremely dangerous thing called ghost guns. Ooh, and it's so dangerous. Now we're seeing these ghost guns. They're very dangerous. Gangbangers are using it. Oh my God, it's a new crisis. We have to do something. Okay, fine. So what did they do? And they literally argue this in their briefs. You know what they say they do? So we've decided to do what we've always done in response to the new crisis. That's literally what they're saying. They said, in response to a new problem, we're simply doing what we've always done, which makes no sense. This is what they write in their brief to the U.S. Supreme Court. The final rule responds to that new public safety crisis by reiterating and clarifying ATF's long-standing view that the plain text of the Gun Control Act does not permit such ready evasion. So of course that's entirely makes no sense. You have a new phenomenon and you solve it by doing the same old thing. Now, they're saying this, of course, is because they're trying to persuade the Supreme Court that they did not do a 180-degree turn on how they interpret what a frame or receiver is, which, of course, they did. And to make matters even worse, and I forgot this was on Thursday or Friday, the Solicitor General's office representing Harris and Biden just submitted an extremely embarrassing letter to the Supreme Court admitting that they made a terrible mistake, that something they said in their brief is factually wrong about how they interpret something and how they dealt with one of the weapons parts kits. Extremely embarrassing, because the Solicitor General's office is supposed to be sort of the best lawyers in the country, and the fact that they wrote a letter to the U.S. Supreme Court apologizing for making a mistake in the brief is quite embarrassing, and that just happened. And I suspect the Harris-Biden ATF is going to get destroyed in this case of Vanderstock, and that's going to be some of the reasons why. Okay. Now, am I going too fast? Now I want to talk about the interplay. We've talked about the Second Amendment. We've talked about ATF, Loper-Bright, administrative rules, regulatory precedents, okay? Now we're going to blend them together with an example so you can see how all this works. And I thought about which one to use, and after hearing the suppressor discussion, I thought, you know what, let's use the suppressor as an example, because I think that's a pretty good one here. It teaches a lot about how to interpret the Second Amendment and deal with regulatory problems as well as Second Amendment clear problems. Okay, so let's understand. As a reminder, of course, suppressors are not firearms in and themselves, and they go on firearms and they function. And we're going to talk about why that's somewhat important here. Just as a reminder, we know that the Supreme Court in Heller and Bruin says that an arm is anything that can be used offensively or defensively. So the question becomes is how does a suppressor which attaches to a firearm become an arm under the text of the Second Amendment? The right of the people to keep and bear arms shall not be infringed. How has it become an arm? Okay. A couple different ways. I'm going to do the most obvious way one, and then I'm going to do a second way in a moment. Obviously, a suppressor, when you put it on a firearm, improves the operation of the gun because it makes it safer for the users and the people surrounding the people that are using it because it prevents hearing loss and the like. Now, is there any Supreme Court precedent that we can use to show that suppressors are indeed arms as defined by Supreme Court Second Amendment jurisprudence? Oh, yes, there is. Mark Smith found one. In the Bruin case, this is what they write when they're talking about what is an arm. It says, quote, even though the Second Amendment's definition of arms is fixed according to the historical understanding that general definition covers, ready, modern instruments that facilitate armed self-defense. Can we agree that suppressors help facilitate armed self-defense by making it safer for the user and making it safer for the people in the home around the user? Obviously, the answer is yes. There's no real dispute that that helps facilitate. And if you don't believe Mark Smith and you don't believe Bruin, why don't we just ask Congress, those intellectual giants in Congress, what do they think? And I'm happy to report that under the federal gun control laws, they define silencers, suppressors as firearms. So, it's going to be very hard for the federal government to say they're not firearms when they literally call them firearms in the federal statute. Okay, now, critical other teaching point here is concomitant rights. This is important. People talk about ancillary rights. When you talk about the right to a trigger, the right to a barrel, the right to a scope, the right to a suppressor as an arm, I want you to use the following word going forward. Okay, I don't want you to be sloppy. Can't be sloppy in the Four Boxes Diner. I want you to refer to these things that are not expressly not an express firearm as concomitant rights. The reason why I want you to use this is because this is the word that Justice Gorsuch, Justice Thomas, and Justice Alito use when they talk about rights that are implied within a constitutional right. And, the right to a suppressor, to the extent it's implied in any respect, is a concomitant right, and that's what the Supreme Court calls it, so you should use the same language as the Supreme Court. Now, how does this apply? I've got 8 minutes, and we're making pretty good time here. So how does this set of materials involving the Second Amendment I went over, and now the definition of suppressors being an arm under the text of the Second Amendment, how does all this work, and how do we win? I think it's actually suppressors are a relatively easy case, and I'm going to make it much easier, pretty easy for you. There are 3 types of suppressor laws in America. 3 types, and I'm going to go over all 3, and when you come out of here, you will be able to argue before the Supreme Court why they're all unconstitutional, okay? 3 types of laws that are problematic for suppressors. Number 1, you have states like Illinois that ban them. Ban the possession of suppressors. We'll get to that. Number 2, you have NFA issues associated with their taxes. You have to pay a stamp tax to get a suppressor, a targeted tax on a suppressor. Okay, we'll talk about that. And of course, you have the gun registration, right? You have a registration of guns associated with, hey, Mark owns the suppressor, and now there's a list of a registry of guns, a registry of Mark on the list. Now you have a registry, and is that constitutional? Well, I think you're going to know what the answer is when we're done with this. Let's start with the first one. Can you ban suppressors under the Second Amendment? The answer is obviously no, because once they're arms, as meaning arms in the right of the people to keep and bear arms, and guess what happens? 2 things happens, obviously. Now, if you ban them, you've implicated the right of the people to keep and bear arms, and now the burden shifts to the government. And remember, this is key, the burden shifts to the government. When the burden shifts to the government, they have to show a historical tradition of some firearms regulation. But here's the key. Remember when I told everyone, don't ever, ever, ever say that Bruin is groundbreaking? Why did I tell you that? Why did I say that? The anti-gunners are desperate to make everyone in America, including the judges, forget the existence of Heller. Why? Because Heller already did the text-first historical analysis of the historical tradition of firearms regulation and concluded the only conceivable basis that a firearm could be banned or an arm could be banned in American life at all is an arm that's dangerous and unusual, whatever that means. And the Supreme Court says, whatever that means, here's the one thing we know for certain. If an arm is in common use by Americans for lawful purposes, it cannot be banned. Maybe there's other ways to stop a gun ban, but the one way for certain is this. There's almost 4 million suppressors in the United States. It's in common use. It cannot be banned once it's an arm. And the reason why I don't call Bruin groundbreaking is because they want you to pretend that Heller is not the law of the land, because Heller creates the in common use test, which is extremely good for us. And here's the other key thing to understand about the in common use test that people screw up. Who bears the burden of proof of showing in common use? The government. Why is that? Because the in common use test arises from the historical tradition, which means the burden is shifted. Text first, implicated, burden shifts to the government. The burden shifts to the government to show the historical tradition. And because the in common use test is part of the historical tradition of firearms regulation, guess what? The government bears the burden to show that AR-15s, that suppressors, that arms are not in common use. They cannot possibly do this, which is why the anti-gunners want you to say that Bruin is the groundbreaking new rule, skipping over the fact that Heller was the same sort of methodology, but they want you to pretend it doesn't exist. And that's why I don't see how suppressors can be banned. And let me add one additional argument. This applies for magazines, and I'm going to make a note here. This applies to large capacity magazines and suppressors. Keep in mind that when you ban suppressors or you ban magazines, it is a firearms ban. Repeat after me. You don't have to repeat after me. So, if you ban suppressors or you ban magazines, okay, it is a firearms ban. In addition to everything I just said, in addition to that, it's a firearms ban. Why? Think about it. Think about it for a moment. If you ban a suppressor or a magazine, what have you done? You have banned an entire category of firearms. Talk about magazines first. If you ban magazines that hold more than 10 rounds, you have banned all firearms in that jurisdiction that are capable of firing more than 10 rounds without having to be manually reloaded. That is a ban on an entire classification of firearms. Likewise, suppressors. If you ban suppressors in Illinois, you have banned an entire category of firearms, i.e. firearms that are capable of being fired with suppressed fire. You see how banning these parts, if you will, constitutes a firearms ban, even if you don't want to talk about the concomitant kind of approaches that is black letter constitutional law. So always remember those two things, because the anti-gunners play games with here. It gets a little confusing, a little geeky, but now you know, and now you can win in the Supreme Court better than a lot of lawyers that are on the anti-gun side. Okay, so that's how you deal with bans. I got 3 minutes. We're now going to go over taxes, and we're going to do regulations, and we're going to get this done. Taxes. Only two things you need to know. Whenever you hear about a targeted tax, whether it be an ammo tax or a gun tax or an insurance requirement, it is a tax, a targeted tax. Only two things you need to know to show. And again, with the suppressors, you got to pay money to the right, to the ATF, all that, to get your tax stamp for the NFA item. That's a targeted tax. Under the Minneapolis Star case in 1984, Supreme Court precedent, a targeted tax on ink, unconstitutional. Under Harper versus Board of Elections in the 1960s, a targeted tax in the form of a poll tax of $1.50, unconstitutional. You cite the Harper versus Board of Elections. You cite the Minneapolis Star. Both Supreme Court precedents, it says a targeted tax on a constitutional right is verboten. Once a suppressor is viewed as an arm that's in common use, it's already a protected arm, you tax it in a targeted way, it's unconstitutional targeted tax. Under those two very clear Supreme Court precedents, game over for a tax on suppressors. Registration, okay. I'm not going to get into inside anything other than to say this, that it was very important for Brett Kavanaugh to get on the Supreme Court that he wrote that dissent in Heller 2 in 2011. Not only did he in that Heller 2 decision say that AR-15s and the ban of DC of these semi-automatic weapons, that they were unconstitutional, he said something else has been often getting lost, and that is this. Brett Kavanaugh, as a judge on the D.C. circuit in 2011 in the Heller 2 case, also said that gun registries are unconstitutional. This is what he writes. In any event, this is Kavanaugh in 2011, mind you. In any event, the proper test to apply is Heller's, not Bruin, Heller's history and tradition-based test. Because most of the nation has never required, and even now does not require, registration of all lawfully possessed firearms, DC's strict registration law is not longstanding in the United States. After Heller, not Bruin, after Heller, some licensing requirements remain permissible, and he's talking about commercial issues, which is not relevant to this, but he goes on to say, DC's registration law violates the Second Amendment as construed by the Supreme Court in Heller. So the registration of your suppressor with the federal government is going to be unconstitutional for the reasons articulated by Kavanaugh and Heller too, and I can assure you he's not the only person that thinks that on the U.S. Supreme Court. I've got 30 seconds. I'm just going to say two quick things. One of the things to understand, when I talk on my channel, I do make fun of a lot of anti-gun judges. It's true. But there's another problem. I'm going to call it the patent law problem, and I'll make this quick. The reality on the ground in many of these federal courts is this. The problem we really have is the patent law problem, and what I mean by that is the judges rarely see Second Amendment cases. These are not like contract cases or tort cases. These are cases they rarely see. If they see guns in the courtroom, it's usually like a criminal case not involving the Second Amendment. So therefore, when they first encounter the Second Amendment law, they're learning it for the first time. And when you learn anything from the first time, you're prone to make mistakes. And the anti-gun movement with their briefing often takes advantage of the fact that the judges are unfamiliar with this area of law because it doesn't come up a lot in their courtrooms. That's the first problem. The second problem is the gun technology problem. I've talked to many elite lawyers, and that's the world I travel in, elite lawyers and elite judges, even those that are originalists and supportive of the Second Amendment and all that, and they will tell you they've never fired a firearm. They don't know anything about firearms. It's not that they hate firearms. It's like they went to Princeton, they went to NYU Law School, where I went to, right? They go to Columbia, they go to Harvard, Yale, and they just don't encounter guns. And even if they, so when you start talking about guns with them, they have and a reason why I call it the patent law problem is because a patent case, judges rarely see patent cases, so they don't know what patent law is, so they got to figure out patent law, and then they got to figure out the fight between, let's say, the electrical sockets. Why is one different than the other? And they don't understand the technology either. So again, that is the problem we face in many of these courts. Even if they're trying to get it right, they don't understand the Second Amendment law as well as they should because it's new to them, and they don't understand gun technology, and they can be easily duped as a consequence of that. And that's why the work that you guys do in trying to educate the public and whatnot is so important, because the public includes federal judges. And I will just quote Benjamin Franklin and wrap up with this, because I think this speaks to everyone in the Second Amendment. After the signing of the Declaration of Independence, Benjamin Franklin turned and said to his peers the following: "We must all hang together, or we most assuredly will hang separately." And I want to remind everyone that in the Second Amendment movement, that holds true in my view. That if we don't work together all the way across the board to fight for our rights, not just the Second Amendment rights, but all of our Constitution and all of our rights, then I have a feeling bad things will happen to us and to the rights and to our country that we love and hold so dear. So with that said, I will be signing books out there. They are complimentary, so feel free to stop by, and I appreciate your time, and we'll talk to you all soon.
Thank you, Mark. Ladies and gentlemen, we're on a break. Feel free to come back at 3:15 and go get your book signed by Mark. Ladies and gentlemen, if we could have you return to your seats so we can begin the final stretch of the afternoon session. Ladies and gentlemen, if you could return to your seats, we want to get started with the final stretch of the afternoon session. And you know what? Ladies and gentlemen, if we could have you back in your seats so we can start the afternoon session. Love guys. All right, ladies and gentlemen, if you're in the room, we'd ask you to take a seat. We want to keep going so we can stay on time. Welcome back in. The afternoon session continues right now. Effecting change. How San Diego gun owners has engaged the public to preserve the Second Amendment in California. Michael Schwartz, founder of San Diego County Gun Owners PAC. Michael, welcome. This is Michael's first time appearing at the GRPC. A big welcome, please. Thank you, sir. Timer's on.
Hold on 1 second here. Thank you, everybody. Appreciate you guys. Thank you so much for coming. My name is Michael Schwartz. I'm the executive director for San Diego County Gun Owners, and it's great seeing everybody here.
Michael, hold on 1 second, really quick. We'll be real quick. You get the time back, I promise. So we're going to start over here. I talked to everybody what to do. You know how this works. If you've ever been at a soccer stadium, okay, we'll start over here. Home field advantage, okay?
There it is. Give yourselves a big round of applause for a Second Amendment wave. Thank you so much. So I got to tell you, I wake up every morning and I hope to myself, I say to myself, I hope you do enough today for the Second Amendment. And before I go to sleep at night, I think to myself, how much more needs to be done? And I hope that everybody listening to these speeches, attending this event, listening to what I have to say, I hope all of you commit to one thing, and that's doing just a little bit more than you did last year for the Second Amendment. Now, we have heard a lot from influencers and authors and attorneys, and they are fantastic, and they are winning the fight. And I can't be more proud to be at an event with them, and I can't be more supportive of what they do. But in lawsuits, the reality is either you're the plaintiff or you're the attorney, or there really is nothing for you to do other than write a check, which I encourage you all to please do. So the folks who write, the folks who influence, the folks who sue, they're really number in the dozens, maybe the hundreds. But the folks who are left number in the tens of thousands, maybe even the hundreds of thousands. So what do? Well, we saw a hole in the front line and decided, hey, we want to influence politics here locally in San Diego County. And there are only two tools in politics: people and money. It doesn't matter how bad or good your ideas are. If you have a ton of really good ideas and you have no people and no money behind them, nothing happens. If you have a ton of bad ideas and you have a lot of people and money behind them, you're California. We wanted to have an organization that put people into meaningful positions, doing meaningful activism, and gathering people and money to get the right people elected right here locally. And I want to give you a step-by-step example of one of our biggest and best-known accomplishments. San Diego County, it used to be impossible, near impossible, to get a CCW. Out of a county of 3.5 million people, there were only 1,100 carry permits issued. That is nothing. If we just had the regular, normal, average percentage as the rest of the country, with 3.5 million people, we should have 150,000 permits issued. We had 1,100. Years before Bruin, we were able to put enough political pressure on the sheriff to start issuing permits. And when Bruin came out, we already had well over 10,000 CCWs issued, up from 1,100. And I wanted to give you the steps that we took. What exactly did we do to make that happen? Well, in 2015, we launched. And in my first TV interview, I was asked, okay, what's a local Second Amendment issue? You guys are local, you get people elected on local boards and councils, you're pure Second Amendment, you're nonpartisan, you're single issue, what's a local issue? And I started talking about CCWs. In fact, everywhere I went, people would ask me about CCWs. We weren't designed to get carry permits, we were designed to be pro-Second Amendment, but CCWs, your ability to carry and protect yourself outside of your home, stretched across the county. Everybody, every walk of life wanted to know about it. So we spent that was the end of 2015, 9 years ago next month, in fact. We spent the next couple of years gathering people and gathering money. What we didn't do is we didn't rally, protest, or march. The reason we didn't do that is I rarely see that affect public policy. And we wanted to work within the system to affect public policy. So we criticized the sheriff at the time, his policies, and we did it in a very professional, level-headed manner so that people would listen to us and see them in us and relate. Now, at the time, he was being sued in the Peruta case. And in June of 2016, he actually won. And the Ninth Circuit Court said, you don't have a constitutionally protected right to concealed carry outside of the home. So he wasn't compelled to start issuing. In fact, he had a big win under his belt. But in the meantime, what we were doing is we were criticizing him in the media. Every major newspaper in San Diego, every TV station, every radio program, we went on and told our story that, hey, he could issue if he chose to. He is not being blocked by state law. We went to different organizations that normally supported him and said, hey, if you don't agree with his Second Amendment stance, withhold your support, withhold your endorsement. And the only reason they listened to us is because of the way we presented ourselves and because of the relationships we had formed. Everywhere he spoke, we would send people, not to call him a jerk, not to yell at him, but to wait in line and ask a question and say, what's wrong with me? How come I can't defend myself outside of the home? How come you came here with a security guard armed? How come you're carrying a firearm but you don't trust me? At one event, we actually had a single mom holding her baby, saying, how am I supposed to protect myself? You certainly can. How am I supposed to protect myself? And why won't you trust me to do so? And it started to work. After the court case in the year 2017 in the summer, we did one of the most effective things we did in the whole fight. We got the city of Santee to pass a resolution saying, hey, we pay you to be our law enforcement, we disagree with your permit policy. And it passed unanimously. We authored it, we got it passed because of the relationships we'd formed with the government officials, with the city council. We got one of the city council members, Rob McNellis, who was also a board member of San Diego County Gun Owners, to author an op-ed that appeared in the Union Tribune, the local paper, criticizing the sheriff. That's one elected official criticizing another elected official on an extremely important policy like carrying for self-defense. After we passed that resolution, a lot of people said, well, now what? What do we do now? And I said, no, there's 16 city councils. Let's see how many will pass this, and we'll continue to put political pressure on them. Well, he called me the next week and said, okay, let's talk. And we went and talked. I spoke with his staff, I spoke with him, and we figured out a way. Our stance was just put self-defense on the application as your reason to issue. Well, we didn't quite get that, but what we got was about 12 sentences. So we wanted 2 words, we got 12 sentences. So we spent the next years teaching people for free how to formulate those 12 sentences. How to tell the sheriff, this is my reason for carrying. And he said, look, I still got to comply with state law. They need a reason. Let's at least figure out a way that everyone will have a reason. And during that time, I didn't run into a single person who didn't have a reason. So when the Bruin case passed later, nobody could get a permit post-Bruin who couldn't already get a permit pre-Bruin. Now, Bruin was an extremely important decision, and we're so glad it happened. But we're not going to wait around for other people to do things. We want you folks to get involved and do what I believe is truly the American experiment, which is to be the country of the self-governed. Now, 2 years ago, the sheriff stepped down, and there was an election. And for the first time in the history of San Diego, CCWs were truly an issue when it came to the sheriff. They were clamoring, the candidates were clamoring to try to prove that they were more pro-Second Amendment. And I'm very proud to say that San Diego County Gun Owners did a better job of vetting the candidates than any other organization in town, and we uncovered what a horrible candidate the other guy was. And we went out on a limb, and despite the fact that I think it's safe to say that normally the Republican is normally a better friend to us than the Democrat, but because we're nonpartisan, because we're single issue, and because we stick to our principles, we went with the better candidate, the Democrat, and I believe it was our support that got her elected. I could even show you numbers that show that a huge number of people who voted Republican for the first time in their life, many of them voted for the Democrat for sheriff, and she's been wonderful ever since. So when we started this whole thing in 2015, there were 1,100 permits issued total. She is now issuing about 600 per month, and we are over 22,000 CCWs with about 4,900 waiting in line. It doesn't stop there. When SB 2 passed, they tried to wipe out most, if not all, of the CCW instructors by taking away NRA's certification in order to allow them to be a CCW instructor. And she stood up, one of the very few in California, and said, no, The instructors who are certified will continue to be certified until the DOJ gets their act together. I'm not going to cut off CCWs to my constituents. She told the applicants that if you got your application in before January 1st, you don't have to take the 16-hour class, you only take the 8-hour class. And she stood up for you, the San Diego, you, the gun owner, which was far beyond what we expected. She's put in her own software to make the system more efficient, and she's looking to get more funding so that she can get help and the line won't be so darn long. But that's what we did. And that's one of the many victories we've had. And those are the steps we took. But it all comes down to people and money. And it comes down to people like you who are passionate about the Second Amendment to go find those people and to go raise that money. Before San Diego County gun owners, I was running around to elected officials yelling my head off about the Second Amendment, and they all patted me on the forehead and said, there, that's cute, I get you. With 4,000 plus members and a 6-figure budget, now they have to pay attention to us or they will be replaced. So I encourage you all to get involved. Do a little bit more this year than you did last year. Do the things it takes to be effective. You know, you have families, you have jobs, you have responsibilities, we get that. But find organizations like San Diego County Gun Owners that makes activism easy. If you just come and sign up with us, if you, read our emails and say, hey, I just want to help, a couple hours a month, something like that, it's going to be the most effective time you've spent on Second Amendment. And that's who we are and that's what we do. And I'm very, very proud of the leadership in our organization. I'm very, very proud of the members. Second to none, truly, truly. And I'm very happy that we partner with other Second Amendment organizations and fill the hole in the front line that we saw. We're not doing something or taking away from someone, we're not doing something that they're not doing or taking away from something that they are doing. We're doing something that wasn't being done before. And I believe that we're changing things legally by partnering with organizations to be a part of lawsuits like Firearms Policy Coalition and SAF. Been wonderful to us. We're doing things at the election level by making sure that the right people get elected, and we're changing the culture with 22,000 people who are now carrying a permit, with over 10,000 people who we've taught to shoot for the very first time. That's changing the culture in San Diego, where the gun laws have been so bad for so long that we've lost a generation of gun owners. I'm meeting people that have made it to 40 years old who've never touched a gun before. In most parts of the country, that's weird. With 600 additional permits being issued every month, with people learning how to safely fire a gun, safely handle a gun, with women being able to get their permits so they can defend themselves, we're changing the culture. It's going to be weird to not have experience with a firearm, to not own a firearm, to not be able to defend yourself outside of the home. So thank you all very much, particularly the members. If you do want to get involved, we have a table outside. If you're not a member, please sign up. It's $10 a month or $100 per year. Listen to Gun Owners Radio every Sunday night. Go to gunownersradio.com and help us, support us, get involved, be effective. And thank all the other folks for filing the lawsuits and educating us and doing what they do, and then brag about how much you've done in your spare time to make sure that the Second Amendment won't fade off into the night, not quietly. Thank you all for listening.
Woo-hoo. Thank you, Michael. Awesome stuff. Congratulations, man. Good job, well done. And we continue. Coming up next, who needs that evil assault rifle, right? Who has an assault rifle? Use their term, right? So I was on NBC News TV a few years ago. Two NBC reporters, and I was on an NBC News New York morning show, a couple million viewers. And at the end of the interview, she says to me, one of the talking heads on the couch says, "So do you have one of those assault rifles?" I said, "No, I have 8. And I thought both their heads were going to pop like zits right on their television show. And they both looked at me at the same time in unison and said, what do you need one for, let alone 8? And I very calmly explained to them that each of the guns was different. Each one meant something different. They were from different manufacturers. Some were keepsakes. So, you know, and some defended my home, et cetera. And they just don't get it. So here to talk about this, the fight for America's rifle, the state of assault weapon litigation, is William Bergstrom, litigation counsel for legendary law firm for the SAF, Cooper & Kirk. William, welcome.
Clock's right there. All right. Good afternoon, everyone. Thank you to Second Amendment Foundation for having me here to talk to you about this important topic. I am Will Bergstrom. I'm an attorney at Cooper & Kirk. I've had the privilege of representing SAF on a lot of Second Amendment cases all over the country, several of which dealt with the AR-15 and several of which I'm going to talk to you about today. And we're going to get to the AR-15, but before we do, I want to start by talking about Heller, because I think that Heller is the critical case to understand assault weapon bans and bans on any type of arm, because that's what Heller was about. It was about a ban on a type of arm. And so if we're dealing with a similar case today, that's where we should start. Bruin, Rahimi, McDonald, they all come into play, but Heller is the foundational text. And I'm going to talk to you today about the key passage in Heller for understanding these cases. And before I do, I want to set the stage for this passage. So at this point in the opinion, we're near the end of Heller, and the Supreme Court has already done the textual work. Arms is anything a man carries for offense or wears for defense. All firearms are arms in the text of the Second Amendment. It's also done the historical work, and it's found 2 historical principles or traditions that are relevant to understanding what types of arms are protected by the Second Amendment. And it said, first, there's a tradition going back to the 14th century in England of banning dangerous and unusual arms, or banning the carriage of dangerous and unusual arms. And at the same time, there was a tradition at the founding of people showing up for militia duty with the same firearms they kept in their house for everyday purposes. So we have these 2 traditions. One, dangerous and unusual arms that can be banned, and arms that are in common use for lawful purposes that are per se protected. It's not difficult to see how those fit together, but if you're the Supreme Court in 2008 writing Heller, there's a little bit of a conundrum in this. And that is that the Second Amendment begins with what's called the prefatory clause, the part that says a well-regulated militia being necessary to the security of a free state. And then it finishes with the operative clause, the right of the people to keep and bear arms shall not be infringed. And Heller tells us the prefatory clause explains why the founders thought this right was so important it needed to be in the Bill of Rights. But if you are going to do militia-like activity today, in 2008 when Heller was decided, it's a good chance that you're going to be using a firearm that is not like the common firearms most people have in their house. The military today does not run on the same type of firearms that people own at home. And so this is the problem that's being set up in Heller. And this passage I'm going to read you is Heller anticipating this objection and working through it. Heller says, it may be objected that if weapons that are most useful in military service, M16 rifles and the like, may be banned, then the Second Amendment right is completely detached from the prefatory clause. But as we have said, the conception of the militia at the time of the Second Amendment's ratification was that the body of all citizens capable of military service who would bring the sorts of lawful weapons that they possessed at home to militia duty. It may well be true that no amount of small arms could be useful against modern-day bombers and tanks, but the fact that the modern developments have limited the degree of fit between the prefatory clause and the protected right cannot change our interpretation of the right. Now, I said at the beginning, I think this is the critical passage for understanding bans on AR-15s and other common arms. I also think it's the critical passage that's being misunderstood by courts that are upholding these bans. And I'm going to start with how it's misunderstood. The Fourth Circuit, in the Bianchi case, which we litigated, which you may be familiar with, upheld Maryland's ban on AR-15s. The Seventh Circuit, in the Beavis versus City of Naperville case, upheld the Illinois assault weapon ban and large capacity magazine ban. Again, put air quotes around all those words every time I use them, if I forget to. And in both of them, they relied on this passage I just read you to find these laws constitutional. And I'll read you the Fourth Circuit in Beavis says this. The court there is the Heller court, recognized that weapons that are most useful in military service, such as the M16 rifle and the like, can be banned. The Heller Court placed such weapons of crime and war in explicit contradistinction to the handgun, the quintessential self-defense weapon, which it emphasized was squarely within the ambit of the Second Amendment. Now, I just read you that passage. It doesn't say anything like that. It does not say anywhere that M16 rifles can be banned because they're used in the military. Heller was saying exactly the opposite. It was trying to explain why some firearms can be banned even though they're useful in the military. In other words, utility in the military is never the because for why a firearm is banned, it's the despite. Some firearms that are useful in the military can be banned despite utility. But so that's the first error that these courts are making with this passage, but that's sort of surface level. That's just misreading and misconstruing that passage. There's a deeper error here too, and that is that the reason the Fourth Circuit and the reason the Seventh Circuit found this to be an acceptable resolution of the case is they viewed the Second Amendment through a narrow lens of what they thought its purpose was. So they both said that the purpose is individual self-defense. Now, I've got no dispute that that is a purpose the Second Amendment protects, but it is certainly not the only one, and Heller never said it was the only one. Both the Fourth and the Seventh Circuit treat it as the sole purpose, and everything they do follows from looking at it through this lens. I'll read you another part of the Bianchi decision. The Fourth Circuit said, the AR-15 offers firepower ill-suited and disproportionate to fulfilling the Second Amendment's purpose of armed self-defense. Therefore, just like the M16, the AR-15 is most useful in military service and can be banned. So that's the crux of their reasoning. It's overkill for self-defense. You don't need it for self-defense. It can be banned. But that passage in Heller said exactly the opposite. That passage in Heller said purpose is not driving our analysis. There is instead a thing that is the Second Amendment right. Now, it was included in the Constitution for any number of purposes, but it is itself a thing that we can know. We can know it from the text. We can know it by looking to history and finding purposes, or not, using the wrong word, finding principles that underlie it. But it is not the purpose that drives the interpretation. It is the principle. And that's really why I think Heller is so critical to understanding everything that's come since it, and this passage in Heller specifically. Because as we've probably heard today, the Rahimi decision, of course, makes clear that what you're looking for when you're doing a historical analysis is the principles underlying the Second Amendment. And if I can have a little digression away from AR-15s for a second, I think that the understanding this principle distinction is really critical as advocates for the Second Amendment, because we are charged all the time with the idea that the Bruen decision is completely insane. The New York Times had an article last week you may have seen that collected just sort of complaints from judges, complaints from lawyers, complaints from academics, all saying it's crazy that we have to do this. The Supreme Court's tasking these people with this task. They're not up to it. They're not historians. They don't know how to do this. And the principal distinction that Rahimi makes shows why those complaints are baseless. It is not a job for historians. It's a commonplace task for lawyers to find a principle from historic cases, from historic laws, and apply that principle to a law in front of them today. It's what you do in every other legal case. The way this plays out, for example, again, digressing a little from the AR-15 example, you may have seen the Ninth Circuit decided a case a couple weeks ago, Wolford versus Lopez. This is a sensitive places case, a case about where firearms can be banned. And they were reviewing a California law and a Hawaii law that banned firearms all over the place. And at the end of the opinion, the majority, or the three-judge panel of the Ninth Circuit had found some of the restrictions constitutional, others not constitutional, and it sort of threw up its hands at the end of the opinion and said, look, you might say there's no rhyme or reason to the fact that you can prevent guns from being carried in parks, you can't prevent them from being carried in parking lots. And they said, we agree, there's no rhyme or reason to it. All we're doing is this mechanical, applying Bruen, looking at history, and on some of these issues, California and Hawaii showed us enough laws that are kind of similar to laws banning firearms in parks, and they didn't show us enough laws that are kind of similar to laws banning firearms in parking lots, so that's how the cookie crumbles. But that really reveals not that the Bruen analysis is broken, that there's something wrong with this historical test, but that they didn't do it right. That the underlying problem here is you need to find a principle. You need to find a principle. and then apply it across all of those cases. There should be a logical dividing line between places where firearms can be banned and firearms where they can't be. In the case of the AR-15 now, going back finally to what you all want to hear about, we see the same exact thing. A lot of the analysis, both by litigants on the other side and by courts, is look, the AR-15 is very like the M16. It looks the same. It shoots the same ammunition most of the time. It's got the same muzzle velocity, same effective range, same maximum range. And they say, look, it's all the same. And so if you're doing the same sort of mechanical, is something enough like another thing that I can ban it, that I can analogize laws to it, it's easy to fall into the trap of saying, well, look, the AR-15, yeah, the M16 has select fire, but look, all these other things are the same, and they're pretty much the same. The problem is that the principle underlying the ban, underlying arms bans that Heller has already given us is common use. And if you compare the AR-15 and the M16 along that metric, they're not the same at all. There are tens of millions of AR-15s in the country today in civilian hands. That is not true of select fire rifles. That's not true of machine guns. And so if you look at it through the lens of the principle, this is the advantage of both being right under Rahimi, being right under Bruin, and finding that most of the laws, most of the firearms that we argue about are constitutionally protected in a very straightforward way, you find that the common use principle gives us sort of the guiding light to holding these laws, to finding these laws unconstitutional. And on this topic, before I move on, if you're interested in this issue, if this is an issue you're either litigate or you're an advocate on, I would recommend, Mark Smith was just in here talking, I think he's still out there signing books. He has a good article through the Harvard Journal of Law and Public Policy that we cite a lot of the time that sort of explains the way this common use test can be found in the passage in Heller that I'm talking about and is consistent with Bruin. That's another charge that comes up a lot. Is that, well, look, Bruin tells us to do historical analysis. Don't you have to do a new historical analysis? Let us show a bunch of firearm laws and see whether or not they're like the laws banning the AR-15 today. And the answer is no, we don't. Because the Supreme Court has already done that work. In any other context, if the Supreme Court has decided a case that gives you a principle that decides your case, you wouldn't say we need to check the Supreme Court's homework. You wouldn't tell the Seventh Circuit, no, you need to do your own in-depth analysis. You'd say, no, just apply the test the Supreme Court has given us. And the good news in the context of the AR-15 and in most of the other, all of the other firearms banned in these sort of omnibus firearm bans that places like Illinois and California and Maryland pass, is that common use is a remarkably easy test for us to meet. There is no argument that, well, there is an argument, there's just no good other side to the argument. They argue it anyway. But there is no good argument that the AR-15 is not in common use. We have survey data. The Washington Post's own survey data says tens of millions of these things are in the country. We have manufacturer data. We have import data. All of it points in one direction. And if courts take the common use test seriously, if they get this passage in Heller correct, these cases are remarkably simple to resolve. In the Bianchi decision that I've mentioned several times today was 183 pages all told. And that's the majority, that's 2 concurrences and a dissent. But 183 pages all to sort of sort out whether or not an AR-15 is an arm and is protected by the Second Amendment. Judge Richardson, who wrote an excellent dissent in that case, had, I think, 2 sentences in there that I'll leave you with as, I think, the proper outline for how to think about this. And had he been writing for himself, he may have been able to resolve the entire case in these 2 sentences. Judge Richardson said this: plaintiffs seek to own weapons that are indisputably arms within the plain text of the Second Amendment. That's the text analysis done. While history and tradition support the banning of weapons that are both dangerous and unusual, Maryland's ban cannot pass constitutional muster as it prohibits the possession of arms commonly possessed by law-abiding citizens for lawful purposes. That's the whole story. That's game over in these cases. It has the advantage of being consistent with the passage from Heller I read you. It faithfully sticks to the Bruin's methodology and applies it correctly. It does what Rahimi asks it to do in finding an underlying principle and applying it to the facts of the case at hand. And it has the singular advantage of being a correct interpretation of the Second Amendment. So if you are a supporter or an advocate who finds yourself talking to the media or arguing to courts about these issues, I'd point to Richardson's 2-sentence dissent as the model for these arguments for us. Thank you very much for the time. It was a pleasure talking with you today.
Thank you very much, William. Appreciate it very much. Is Chad Flores in the house? Chad Flores? There you go. All right, coming up next, we're going to keep going. More litigation information. Vanderstock, we're all familiar with that case. Maybe not. You're going to hear about it right now. Curtailing ATF's foray into lawmaking. Chad Flores, litigation counsel for SAF, Flores Law, PC. Chad, thanks, brother. Great. You got it. Thank you. In front of you. The remote.
All right. Do the normal rules of statutory construction apply to guns and even ghost guns? Ooh. Do the Constitution's vagueness doctrines have real teeth? Is there a Second Amendment right to construct a firearm for your personal use at home? These are all questions implicated by the Supreme Court's upcoming case in Vanderstock versus Garland, and that's what we'll talk about today. I'm Chad Flores. I'm a litigator that specializes in constitutional law and appeals. I've done cases for the Second Amendment Foundation for a long time, and I'm pleased to be the lead counsel in Vanderstock for SAF with a great team. I want to commend Alan and Julianne and Adam for running a really top-notch operation. For those of us who are sort of boots on the ground in the courts, yeah, let's give them a hand. Great. I think you all experienced the fruits of their labors, but for those of us who are sort of boots on the ground in the courtrooms litigating these cases, it's a real pleasure to litigate for SAF because there are a lot of people that try to litigate these cases, but they do it in the right way. They're patient. They don't just run into court and sort of Hulk smash to get a headline. The wins that they get are meaningful wins. They're not just Pyrrhic victories, and they had the patience to see the long run. So it's a real pleasure to work on these cases. Here is the question presented in Vanderstock. I think Mark Smith did a great job of teeing up this case. This is technically, at first hand, a statutory question about what the Gun Control Act means when it says firearm. When the Gun Control Act says firearm, does it mean to include not just firearms, but non-firearm kits that could someday become a firearm? When they say firearm, do they mean unfinished, incomplete, inoperable firearms? Those are the basic questions presented in the case, and I think Mark teed it up very well, right? Does the Biden administration overstep the statute by trying to cover far more than an actual firearm in commerce and regulate what really is being trying to regulate it here, which is home gun making, a tradition that we say is long protected by the Second Amendment. Now let me step back a second. My practice is an old school litigation practice. I was raised in a tall building law firm with an old school style where we think law is a craft. You do it right by mastering first principles and sort of out-techniquing the other guys. There aren't tricks and tips and sort of cheats to do these things. We don't like shortcuts. But we're not in court today. We can be a little more creative. So to talk about how we think Vanderstock will play out, we've created a large language model called SCOTUS GPT. We turned to Chat GPT, and I fed the genius robots all of the relevant briefs in Vanderstock, and I fed them all of the relevant writings, the first sort of authorities on these questions, and dumped them in to see what the world's supposedly smartest computer robots think of the case. So that's what we'll look at now and see how they did. These are the actual questions presented, as you see on the screen just a moment ago. Right, those are the actual questions presented. Right, so then we ask the computers, what do you think Vanderstock is about? This is what the computers think Vanderstock is about. They say pretty good, right? It's about a rule defining firearm. Does it cover these kits and partially completed frames? That's a pretty good job. So then we ask the robots, what are the main issues in the case to figure out what's really going on here? And it gave us a list. It's pretty good. It says the first issue is about the scope of regulatory authority. It's about what this term readily converted means. This is one of the technical arguments that we hear about in Vanderstock. There's an argument about the rule of lenity in this case. There's an argument about due process concerns, and they also pick up the Second Amendment. So that's all doing pretty good. What we really had fun with is we decided to create an individual large language model for each of the justices and say, what do they think of Vanderstock? So let's see what the GPT version of the Supreme Court really thinks about this question. Is a firearm just a firearm? Or, as the Biden administration says, does a firearm also include anything that might someday become a firearm, maybe if a certain number of steps occur that we don't really know? So first we asked the computer robot version of Justice Sotomayor, and this does not turn out well for our side, no shocker, right? The computer gives us a summarized version. We actually ran this. We had the GPT generate 30-page opinions, and then we said summarize it with a short bullet point and give us a little flair like Justice Sotomayor might. So you may imagine an oral argument. Justice Sotomayor, talks about safety first, right? And this does not go well, but this is probably no shocker to anyone in this room. So let's look at the GPT version of Justice Kagan. This is what Justice Kagan thinks of this case. Now remember, this is just in isolation about her writings alone. We probably will lose with Justice Kagan. She'll think, it's just common sense. If it kind of looks like a gun and it fires like a gun, it's going to be a gun. This is the reduced version of Justice Kagan, according to the world's greatest technologists. So we're going to lose that vote too. Here's Justice Jackson. The computers think she's got a real quip. If you can build it, it's a gun. I like that Field of Dreams throwback. So you can see the left view of this is kind of a take that says, don't look too closely at what the statute actually says. The view on the left is that we all know guns are bad. We all know these statutes are supposed to cover guns and anything close to guns. Let's just give them a pass and let it go. Now let's look at Chief Justice Roberts. This may surprise you, but the GPTs, having been fed all of the Chief's writings, thinks that we may lose Chief Justice Roberts in this case. That has been a surprise to some before in other cases. He thinks that there are some problems with the statute. It may need some fine-tuning, but on the whole, it may be some sort of mixed result. The computer here is a little confused, like some of us may have been. I think maybe the GPT wanted him to say it's a tax or something like that. So I'm not sure how that happened. So the chief, the robot version of the chief is a little confusing on this one, but right now it's not good. We've got 3 votes against. Maybe the chief is over there. Let's see what the computers think Justice Thomas. Great. The computers know CT. This is great. So we win with Clarence Thomas. He realizes, of course, this is a classic case of bureaucratic overreach, right? There's a difference between an actual firearm and just a block of metal. These are not the same thing. Great. So that's 1 GPT win for the good team. Next, we've got Justice Gorsuch. The computers think that Justice Gorsuch is going to vote for the good guys as well. Justice Gorsuch is a big fan, we think, of the due process vagueness arguments. So SAF's brief in this case advances an argument that says, to the extent there's any doubt about what this statute and regulation means, the court needs to construe that with vagueness concerns in mind. And nobody really knows under this long factor-based test what constitutes a firearm, because the bureaucrats in DC don't even know what constitutes a firearm. The people that actually have to apply this are going to be just as clueless as the rest of us. So the computers probably get this one right. So we think we've got Gorsuch in the bag. So if you're keeping score at home, this is 4 computer votes against us, 2 robots for us. Let's see, here's Justice Kavanaugh. We think the computers think Kavanaugh gets it right, which I think is going to come out very nicely. Kavanaugh is a real technical jurist that we think will come out well on Vanderstock, and so that tends to go well. Justice Barrett, the computers think she's sort of clever, close but no cigar, right? A lump of metal isn't a firearm, so we've got that one as well. And Justice Alito, here's what the computers think of that. So let's try to sum this up, and to save you guys a little bit of time. This is the sort of computer version of the dissenting opinion, right? They say, it looks like a gun, it's close enough, and that's going to get us there on the statute. But the computers predict that there will be a majority opinion striking down the rule with this kind of analysis. Now, one interesting thing that happened when we ran the models is that we ran each justice individually. We said, what will the justices do if you just ask them to decide this alone? And then we ran the models and we said, what do you think the opinion will do? How will it come out? And when we ran it with the opinions, Justice Roberts didn't vote against the administration. He didn't uphold the rule. He voted with the conservatives and voted to strike down the rule. So apparently, what the computers think is that left to his own devices, looking only at his own readings, Chief Justice Roberts would uphold this rule, not strike it down, but that through the deliberative process somehow, on the court, he'll be pulled to the conservative side. Now, maybe that's a glitchy thing that's happening inside of the large language models, or maybe they know something very savvy about how the court processes work. So the oral arguments in the case are on October 8th. A lot of the case hinges on what feels like technicalities, but I think that there will be a lot of analogies looming large about people trying to say that unfinished receivers are like this or like that. So maybe these are sort of models you can use to understand the argument as it goes along and see how the case turns out. So that's what I have to say about Vanderstock, and we are cautiously optimistic that the robots have this one right, at least on the count. Thank you.
Thank you very much. I got to go here. You're talking about ChatGPT. If you would hang up here for just a minute, Chad. You may or may not be aware of this, ladies and gentlemen, but when you mentioned ChatGPT being one of what was the smartest bots in the world?
They say.
Okay, well, let me throw a monkey wrench in that. Back on May 5th of 2023, I was promptly informed by Alan Gottlieb that a journalist had requested information about a lawsuit the Second Amendment Foundation had filed against the Washington State Attorney General. In return, the journalist, third party, received an entire fake lawsuit filed by Alan Gottlieb against me for embezzling over $5 million from the Second Amendment Foundation, ChatGPT. Owners, OpenAI. That didn't bode too well. Lots of accusations in it against me. I promptly sued them, and you're looking at the first human being to ever sue an artificial intelligence chatbot in the history of the world. We have beat them at every twist and turn. Discovery just wraps in 2 days. We beat them, their effort to move to federal court. Everything I'm telling you is public record, so I'm not disclosing anything. We beat them. They tried to get it to federal court, failed, remanded back to state court where they don't want to be. 34-page motion to dismiss the case, promptly denied by the judge. And they will obviously seek motion for summary judgment. They will lose that. And I will prevail in that case against ChatGPT. So I would highly recommend another chatbot.
Bravo. Bravo. Very good.
If anybody's interested, it's public record. The case is Walters v. OpenAI. It's quite fascinating. Thank you, Chad, very much. Jim Dudaci joins us now. How the banking industry and government impede firearms and ammunition purchases. I can't believe the government would try to do that, but they do. Chief Legal Officer and General Counsel for Public Square. Jim, welcome, my friend.
All right. So Mark, thank you. And I know we're getting late in the day, so thank you to everyone that's still hanging with me. And I know late in the day in California also means that a bunch of electric vehicles are going to be plugged in soon. So in case the grid goes down and the lights go off, I don't want to get out of here without saying thank you. Thank you to the Second Amendment Foundation. Thank you to all of you, and thank you to everyone and all of our presenters today that stand shoulder to shoulder to protect this sacred right, the individual right to keep and bear arms. It's a privilege to be here. So my name is Jim Dudaci. I'm the General Counsel and Chief Legal Officer at Public Square, and prior to joining Public Square, I was the General Counsel at Credova, a financial technology company that provides services and has been a longtime supporter of the firearm industry. I'm here to talk to you about the ways that the banking industry and the government seek to impede firearm and ammunition purchases. I could talk about this for hours, and with only 15 minutes, it's impossible for me to cover all of the insidious ways that the anti-gun crowd has worked to bankrupt this industry and destroy the individual right to keep and bear arms. While they cannot repeal the Second Amendment, at least not yet, they want to weaken it at every opportunity. The truth is, their commitment has remained strong, their financial backing robust. They have highly engaged and mobilized billionaires that finance these attacks. They also have multi-billion-dollar allies in the mainstream media and in Hollywood that seek to influence and change culture. When they fail in Congress, they move to the states. When they fail at the states, they seek to abuse the legal system. And if they fail in the US legal system, they'll even finance lawsuits in foreign nations that argue that our Second Amendment rights are the cause of violent criminal activity. Well, I can't cover everything. I will walk through some of the history, some of the attacks hitting highlights, or more accurately described, lowlights, that help us orient where we are and where we're going. In the 1990s, under the Clinton administration, we saw ushered in an unprecedented attack on the firearm industry. This started with targeted harassment of FFLs, including zoning and hours restrictions, and moved into raising of fees and license revocations. And we saw a decrease of FFLs from the early mid-1990s of 250,000 to 50,000 just a decade later. But that was nothing compared to what we saw when it came to attacks on firearm manufacturers themselves. We saw folks that were seeking to sue the firearm manufacturers for criminal use of non-defective products. This almost bankrupted the industry. But thanks to the work of so many folks in this room, people that have been in the fight for decades, in the early 2000s, as we've already discussed, we saw the passing of the PLCAA, which provides very meaningful and significant protection, but the attacks continue. We've seen the continued weaponization of government under the Obama administration during Operation Choke Point. At every turn that Congress or the states seek to protect the Second Amendment, the attacks don't stop. So how do we fight back against these attacks? How do we protect the Second Amendment and the God-given rights that we hold so dear, the economy we operate in, and the industry we love? It starts with identifying the problem. It starts with understanding the tactics of our adversaries, and then building robust solutions and pursuing them unapologetically. And that's exactly what we're doing at Public Square. All right, so bottom line up front. Access to financial services is a critical vulnerability for the firearm industry. In military parlance, a critical vulnerability is a component of a system that is crucial to its functioning and is vulnerable to neutralization or attack. We're experiencing and have experienced for years a multi-pronged attack, maybe more like death by 1,000 cuts, under novel legal theories that are intended to degrade access to financial services, including things like so-called state reasonable control statutes that impose heavy burdens and contain serious ambiguity. All of this creates a significant risk of government investigation and enforcement action, particularly those operating in the financial services industry. There's a tremendous need to partner with financial service providers that share your values and understand the unique and complex regulatory environment in which we operate. You know, it's music to my ears when folks talk about the complexity of the regulatory state and everything that we face. And interestingly, you know, we've tried to smash the highly complex consumer finance regulatory environment together with firearms, which is a lot of fun for lawyers. It certainly keeps us employed. All right, so let's drill down a little bit on government strategies and tactics. This is really that they seek to strangle legal but, quote, disfavored lines of commerce by depriving them of access to the financial system. They do this by trying to bypass traditional industry protections like the PLCAA and manufacture novel legal theories that create causes of action. They deploy the regulatory agencies to suppress the financial services for industry members. I'll say something that I thought was brilliant earlier. I just got to say it again. I love it. Rein in rogue regulators. I think I've heard that a couple times today. Rein in rogue regulators. On top of all of it, there's a media and information campaign that turns up the heat. And then if they face consequences, it comes much later when it's too late for the businesses and industry members that have been impacted. So I'm not going to do a real deep dive on Operation Choke Point. First of all, I know most in this room are very familiar, and Sean Smith of NSSF did a great job earlier, but I do want to point out a couple of things here. So under Operation Choke Point, we had a Department of Justice that was prompting the FDIC, OCC, and the Federal Reserve to choke off these so-called disfavored lines of commerce. They did this through a back-channel information campaign that sought to tarnish reputations and relationships, and it forced law-abiding businesses to be debanked without due process. So let's dig into some of the key tactics just a little bit more. Regulatory coercion through informal guidance. This looks like policy statements, articles, backroom pressure. This looks like conversations, perhaps during examinations, and amplified examination and investigatory scrutiny. Then you have the weaponization of vague reputational risk concerns that are designed to discourage banks from supporting industry members. This is part of a very broad information campaign. Mark Smith, I loved what we talked about earlier and really tried to drill us on the use of language. The language that we use when we talk about this really matters, and we all need to take the time to educate ourselves and be able to speak and articulate why we stand with the Second Amendment and this industry. Fortunately, the FDIC was ultimately forced to admit wrongdoing in 2019, but again, oftentimes too late for the industry members that have already been affected. So let's talk about continuing government overreach. Right now, Operation Choke Point 2.0, Cooper Kirk is doing an amazing job shining a light on that. Again, folks in here are probably very familiar with Maria Vullo out of New York and everything that came out of that case, but I want to draw kind of an important distinction here. It was obvious and apparent that Maria Vullo and the Department of Financial Services in New York were abusing their regulatory authority when they were going after the NRA and like organizations. It was very obvious. We got a 9-0 Supreme Court victory out of it, right? I believe regulators are getting a little bit smarter than that. They won't come out and obviously say it's a problem with a firearm. They won't come out and obviously attack an industry member. What they'll do instead is the death by 1,000 cuts. They'll do it through environmental laws and regulation. They'll do it through working in back channels with social media companies. They will do it through working with other regulators, for instance, in financial services, to try to make it difficult for the very foundation of that system to support folks in this industry. There's been a little bit said about these so-called reasonable control statutes and predicate exceptions that are used to bypass the traditional protections of the PLCAA. These are typically built on violations of state consumer protection laws, or reasonable control statutes use vague language for who exactly is an industry member, trying to broaden that net. And then, of course, as was discussed a little bit earlier, is the new merchant category code. One interesting thing that I'll point out about the MCC issue is, one, when it originally came out in September of 2022, I think everyone will remember that Visa and MasterCard kind of backed off of it when that was really brought to light. Now, of course, we're seeing a split in the states. Some states are outright banning the use of an MCC tied to firearm and ammunition retailers. Some states are actually requiring it, like the beautiful state of California. What's interesting about that, though, is when I was reading some of the conversation that was happening online around the MCC issue, one of the first comments you would almost always see in the message boards was someone would say, "I'm just going to use cash, brick and mortar from now on." That would be devastating for this industry, and we can't allow that to happen. So what's the way ahead? The way ahead is understanding the financial infrastructure to identify points of vulnerability and responding accordingly. We all need to actually understand the plumbing of the financial services industry. Sponsor banks, payment processors, everything that goes into it. We need to understand it on a very deep and fundamental level, and we need to build a system that is robust in the face of government and regulatory pressure. Vendor diligence matters. There's been a tremendous amount of focus today on the wonderful work that our constitutional lawyers are doing fighting for this right in the court. We've talked about Supreme Court cases. We've talked about the incredible work that SAF is doing and NSSF. Contract law matters too. When you're engaging with a third-party vendor or service provider, you need to pay attention to the details. Don't take their word for it. Review their acceptable use policies. Review their prohibited conduct list. Because all of these things, hearkening back to Operation Choke Point 2.0, when they were seeking to force the banks to build in switches so that they could immediately terminate someone's account and immediately stop services, similar things can happen with technology service providers, and you need to pay attention. Don't take their word for it. If you see language in there that would give them a light switch that can turn you off just because you happen to be in the firearm industry, you need to make sure that gets out of the contract. We protect the industry by protecting consumers. Everyone needs to lock shields and get in the fight and work together. This community has done an incredible job fighting in the courts, fighting in Congress, and fighting in the state legislatures. What we're trying to do at Public Square is really bring the power of the private sector into that fight so that people have viable alternative options where they can actually spend their dollars and partner with services that have the same values. So I have just a few minutes left, and I want to end on a little bit of a personal note. So I'm father to 3 beautiful young kids. I think they're actually watching from home right now in Virginia. And I'm blessed to be married to a woman who loves liberty just as much as I do. It was said at this conference that this is a sacred right, that freedom is never more than one generation away. Anybody that understands human history understands that individual liberty is a spark compared to the darkness and the mire and the oppression of the individual that we have typically endured. And it is our duty in the current generation to ensure that's passed on to the next. At Public Square, we are a values-based organization, and we and I personally believe that our God-given individual rights that are enshrined and protected by the US Constitution are non-negotiable. I want to challenge you. Thank you. So I want to leave you with a couple of challenges. When we ask the question, okay, so how do we do this? What do we do? I've mentioned a couple of things, but I want to challenge you individually. Teach, train, and mentor the next generation. Teach them that individual liberty is not the historical norm. It is the historical exception, and help them understand just how sacred it is. Train. Train people. If you're a firearm owner, take folks to the range. Train them and teach them how to safely use arms. If you're a hunter, take people out to the field. Help them learn how to hunt. Help them enjoy it. Help them do it in a safe manner. We heard just a moment ago, people and money. You know how you create people that are passionate about the Second Amendment? You take the steps to introduce them to responsible firearm ownership and all the wonderful things that come with it. And be courageous to live out your values, right? So learn how to articulate the cause of liberty and then be courageous about it. Don't sit on the sidelines. No one at this conference is. But it's all the millions of folks around this country that need to see people like you standing up and making a powerful articulation in defense of liberty and the right to bear arms. And they need to see it, and they need to see it consistently. Because the media has engaged in a campaign that tries to put the firearm industry on the same level as the pornography industry, that tries to make guns the new cigarettes. And we cannot let that happen. And lastly, spend your dollars accordingly. People and money. We must support organizations like SAF. We must support organizations like NSSF. And in the private sector, we must spend our dollars with American-owned businesses who share our values. We have the ability to make those decisions, and sometimes they're a little bit more difficult, but they're vital. So thank you all very much for letting me speak today. And if you want to learn any more about what we're doing at Public Square, I'll be out and about, and I'm happy to talk. Thank you.
Thank you, Jim. Great stuff. That work okay for you? PowerPoint? No problems? Okay, great deal. Is Kenyon in the house? Ah, there he is. Kenyon Gleason joining us right now. NASGW, if you're familiar with the organization, it's a great one. He's the president of the National Association of Sporting Goods Wholesalers, and the conference is next week. It's a great one, too. Kenyon, welcome, brother. Great to have you. Clock's on.
Hey, thanks for having me. Super excited about being here, and I've learned a lot today, so nice job, Adam and Alan, everybody, for putting together a fantastic conference. I hope you're still awake. It's getting long in the day, right? So I'll hopefully get your blood going a little bit with a few of the things I'm going to talk about, but also just because I'm kind of loud. So as noted, Kenyon Gleason, NASGW. So we are the middlemen in the sales channel, and our distributors handle about 65% of all firearms that are sold in America. So it's a pretty significant chunk of the product that moves through the market. And you've heard a lot today about lawsuits and all kinds of things. Certainly we're monitoring all of that and keep track of all that. In fact, in the Vanderstock case, we did file an amicus brief to talk about the impacts that would have on the sales channel. Jim, the work that Public Square is doing, phenomenal, and they're actually going to be a partner of ours at our event here in a couple weeks. We do our annual sales meetings in Kansas City here in a couple weeks. So we are now 50 years into doing a hunting show, they used to call it. Now it's called the Expo, but we get together with the manufacturers, the distributors, the rep groups, all get together and do their sales buys for the next year. So that's who we are, what we do. Today I want to talk to you a little bit about the regulatory environment and sort of the really damaging impacts it's had on us as an organization, and certainly many of our members more specifically. But first, we're at war. I know you all sitting here sort of intuitively know that, but I'm talking about a little bit deeper war here for the soul of our country. We have a lot of things happening, not just around the gun arena, but around sort of how we move forward and how we protect freedom, not just the Second Amendment, but all our freedoms. And I think, rather than being superfluous and dealing with all kinds of the very specific things you've already been hearing about today, I want to sort of tee this up and set the stage for where I think our biggest concern is in this industry, and kind of show you why I believe that to be true. So I think we're behind in the culture war, not because we're not capable, but because we tend to be very moral people who don't like to fight, who want to just go home and be left alone. And what happens in that regard is that it leaves behind all those who are ruthless in their pursuit for power. So, I want to talk a little bit about the federal agencies, federal employees. 438 federal agencies, almost 3 million federal employees. Who knows what they do? I don't know what they do. Most people probably don't. Divided into 4 different categories: cabinets, independent executive agencies, regulatory agencies, some of the ones that are very impactful to us, obviously ATF, and then government corporations, or like the Postal Service, public broadcasting, those sorts of things. So, yeah, who has an idea? Not many people. I will tell you, and this is the disturbing part of sort of what happens in Washington. The Hatch Act was passed many, many years ago, designed to sort of keep federal elections out of the workplace, right? Like, we don't want to have people talking about politics in the workplace. Well, the union that represents approximately 1/3 of America's federal workforce spends a lot of money every year advocating for their particular candidates. And then they have their own separate PAC that they run, and they spend millions of dollars advocating for their selection of who should be the next leader of the United States of America. And they train their members, this is from their website, how to become activists in the workplace, which is completely antithetical to what the Hatch Act says they can do. Now, of course, they find ways to get around that without mentioning specific persons. They talk about policies and all of those sorts of things, but rest assured, they are pushing ideas out among the people to try to make sure that they have their way. So you're saying maybe to yourself, what do I care? Well, the battlefield, it's my opinion, is not what you think it is. I think that it's much more subversive and much more insidious. This is the campaign donations that the aforementioned union has done in the year 2020, most recently 2022. You can see the blue trend, dating back over time. They spend most of their money on Democratic politicians. No shock, they're representing a large cadre of Democrats. This is the presidential election in 2020, and Trump got a few dollars. I think that might have been before people really realized what his intentions were with draining the swamp. It'll be interesting to see what happens in this election as to how this chart comes out, but I don't imagine that's very surprising to you necessarily. But the AGFE, of course, has already come out in support of Kamala Harris. The IRS union has come out in support of Kamala Harris. And so pretty much all of the federal bureaucracy has announced their intentions of who they're going to vote for. Probably, again, not a huge surprise to you. Elon Musk, interestingly enough, just over the last few days, has been exceptionally critical and very strident in his comments about regulatory reform and how the regulatory environment is choking business in America. It's crippling his space program, and I do argue that it is crippling the gun industry. Sorry, I missed a slide there, but that's the presidential election. So if you take a little broader picture from 2020, this is all dollars from federal employees that were in the election. And, you know, overwhelmingly, those dollars went to Democrats. So again, no 2024 numbers yet. We're getting those soon. A board full of shiny objects. Why would I show you a board full of shiny objects? Well, it's like the whole squirrel reference, right? We're all distracted by the latest, the greatest, the newest, the fanciest, the prettiest thing. This is actually a syndrome, a psychological disorder. And it's a concept of distraction. And it's used, in many cases, intentionally to distract. So I'm not necessarily being literal per se here in our industry, though I do like a new shiny gun. I like lots of new shiny guns. But in this case, I'm talking about their messaging and the PAR campaigns they're doing as the metaphor for the shiny objects. So we talk about overturning the Second Amendment. We talk about banning assault weapons. We talk about gun confiscation. All of these things. Critical, important, hugely, a huge factor in how we grow and develop as an organization, right? As an industry. But let me ask you, who here thinks the Second Amendment is actually in danger of being repealed? Anyone? No. Because it's not. They can't win on that issue. It would take 2/3 of the House and 2/3 of the Senate to get a repeal on the ballot. It would take 2/3 of all the states to get a constitutional convention put together, and then 3/4 of them would have to agree that they wanted to get rid of the Second Amendment. It's just not going to happen. You're more likely to be struck by lightning than ever to have the Second Amendment actually overturned. So, again, not very bloody likely. So how do they get around this? Confusion, hiding their true and real intent. It's not so much the what, it's the how. That's how they're going to get it. These are ancient tactics. This stuff's been around for centuries. Sun Tzu was like this huge military tactician, and they're using this playbook, the people who don't like us. And if you really want to get into an interesting playbook, read The Rules for Radicals written by Saul Alinsky. That'll give you the framework of how they put all of their stuff together. So we'd like to believe that anti-gun folks are less intellectually gifted than we are, but that's absolutely not true. Here's why. This is how they're beating us. It's not on those big things that all hit the media. They're beating us on lawfare. You heard about that today. Regulations, rules, taxes, fees, fines. Restricting access to capital, Jim just talked about, restricting trade, insurance, logistics, inspections, tracking and tracing. These are the weapons that they're using against us. It's subversive, it's behind the scenes, it's insidious, and it's hard to defend against. And if you're in business, you feel coerced to do what you're being asked to do by your federal government. They are, after all, in charge, and they know what's good for us, right? So if you can't win directly, you convince 438 agencies and a majority of the people who work there, who are on your side, to implement rules. Since we started in Congress, since we started passing laws, we've only ever passed 30,000 approximately statutes in all of our time. You can do that many rules and regulations in about 6 to 10 years. And they do. The Supreme Court's Chevron doctrine and the Loper-Bright case, that is going to be critical in terms of trying to get this all beyond us. And I think that's going to be dramatic in terms of helping us make that happen. But it's hard to really kind of put it all into perspective until you talk about how they're being successful. Just in the logistics arena alone, I get a call probably every few weeks about a new carrier that's leaving the business and no longer transporting firearms. We have 2, 3, if you count the Postal Service, companies that deliver parcels. A huge component of being able to do business in our industry, right? If FedEx or UPS decided tomorrow they're done, that would decimate our ability to move our products. Decimate it overnight. Now you have to try to find other logistics carriers to try to move those products. Payment processing, same thing. I've had calls from companies that were just shut off immediately, overnight, no warning. Now all of a sudden you can't do e-commerce because they stopped doing your transactions. Banking, Jim covered that really well, so I don't really know that I need to cover that expressly other than to say I know of companies who not only have banks shut down their corporate accounts, but taken away their personal accounts as a result as well. So it goes deeper than just the company itself. Credit card transactions, the monitoring of what you are buying, obviously we talked a little bit about that here as well. ATF inspections, I'm actually encouraged. I think the ATF is pulling back on this, maybe. Knock on acrylic. Hopefully they'll do that. But the one strike you're out policy has been very detrimental. 150-ish FFLs have been impacted by it. They're now suing us for liability issues, marketing, as Tom Taylor mentioned earlier, selling things in the wrong state. State of Washington in particular has been very heavy-handed in that. And this one sort of hit really close to home for me because we've had many insurance companies walk away from our members. And so as a fix to that, we tried to gather together a coalition of members to build an insurance captive. And we had a good coalition of people. We had great risk loss ratio numbers. All the things looked wonderful. We shopped that captive, that insurance program, to over 100 insurance companies. And none of them, not one, would take it. Not because we weren't a good risk on paper, but because we were a bad PR risk. And that's all it came down to. It's insidious and it's devastating to our industry. And that's how they're winning. If you can't get insurance to protect you, how do you stay in business? So that's what we're dealing with. Again, just sort of a summary there of all of those things. So when we talk about the deep state, does it exist? You tell me. So what do? Well, we fight back, right? We get involved politically, as you all are. But more importantly, I want to encourage you and your family to get involved in the actual business of government. Get into the bureaucracy. Become a leader in those positions. Throw yourself out there to take a job where regulations and rules and things are decided so that you can be in the room when the language all comes together. And of course, we're going to have to be persistent, mindlessly persistent. And despite everything that your head tells you, and probably even your heart tells you, throw all that away and go get involved. Go vote, drag a neighbor, drag a friend, get them registered, go vote, and then be involved and active yourself in participating in our government process. So it's bad out there, but we've found ways that we can overcome a lot of those challenges, and we're going to continue to work vociferously to make sure that we can keep fighting the good fight for all of you. So we can't do it without your help, though, and look forward to finding new ways to challenge some of these things together. Thank you for having me.
Thank you, Kenyon. Appreciate it very much. Thank you, Kenyon. Appreciate it very much. NASGW is valuable. We need them, and they need our support. Ladies and gentlemen, we're getting close to winding down, believe it or not. Can't believe it. Public housing authorities and the denial of Second Amendment rights. Edward Palcic joins us, litigation counsel for the Second Amendment Foundation, Bachner PLLC. Welcome, Edward.
Thank you so much. Yes, my name's Edward Palcic. I'm litigation counsel to SAF. Very briefly, before I delve into a really offbeat topic that I'm 100% sure you have not heard about before, I want to thank SAF for its unwavering support for the project that we're working on. The project that I'm about to talk to you about, I want to thank Adam Kraut and Bill Sack for their unwavering support of this litigation and everything we've been working on. I want to thank my law partner, Serge Krimness. I want to thank my associate, Meredith Lloyd. Their tireless work on this project makes it possible. I want to thank our lead plaintiff, Robert Hunter. I want to thank our other plaintiffs, Doug Marin and Elmer Irwin. These are the people that make this project possible. So I want to start with two questions for you. The first question is, do you think that your constitutional rights are based on your income? Do you think that your constitutional rights are based on the size of your bank account? Okay. Do you think that the government can ban firearms in your home? Okay. So I didn't really hear anyone agreeing with those things. Unfortunately, there are public housing authorities that disagree with these basic propositions, including the Cortland Housing Authority in upstate New York. They, for a long time, did believe, and I'm sure still believe, that your income and your bank account size is a factor with respect to your right to bear arms, with respect to your ability to exercise your fundamental constitutional right to keep and bear arms. And for the longest time, and again, I'm sure they still believe it, even though they've been forced into a position otherwise, they also believe that they can create categorical, complete, total bans on firearms in homes. This is what they believe, and this is not fiction. This is actually nonfiction, okay? And what the Cortland Housing Authority did, they inserted a lease provision. They are a public housing authority in upstate New York. They inserted a lease provision which said, quite simply, no firearms in sum and substance. You are a public housing tenant, and you may not have firearms on the premises or in your unit. So if we step back and think about this, this is their home. This is where Robert Hunter, our lead plaintiff, this is where Doug Marin, Elmer Irwin, this is where they live. Would anyone disagree with that? This is their home. So the Heller implications here are obviously quite clear. And when you zoom out, this becomes an incredibly disturbing case, and I'm going to tell you a little bit more about why it's so disturbing beyond the surface. So let's step back for a second. When we think about your usual gun grabbers, as my friend Mark Smith just said earlier and is fond of calling them anti-gunners, you think about Democrats at the federal level. You think about Democrats at the state level. You think about really live issues right now, such as quote-unquote assault weapon bans. You think about sensitive places bans. But a lot of gun control actually happens at the local level. It's happening on sort of this micro level, and it's really forgotten, and it doesn't get as much attention. But it's a really big deal. We have 3,300 public housing authorities in the United States. And under their jurisdiction, we have 1.2 million households. Now, whatever the average number of people is per household, whatever that may be, 2 people per household, 3 people per household, you're talking about millions of people who are in public housing. And obviously, their Second Amendment rights are equal to the Second Amendment rights of somebody who lives in a 20,000 square foot mansion. And that's what this is really about, okay? Now, I want to just talk a little bit about what exactly is the reason why you should care about this. Why should you care about this? After all, it's just one public housing authority in upstate New York. But you should care about it because we have a slippery slope here. Ask yourself the question, can we tolerate the existence of one little pocket, even one little pocket in the United States of America, where people do not have the right to keep and bear arms in their home? Obviously, we cannot tolerate that, because today, they'll be doing it in the housing authority. Tomorrow, it'll be you, it'll be your home, and it creeps, and it creeps, and it creeps. And we heard before, we are moral people. As people who care about protecting not only our fundamental rights, but the fundamental rights of our neighbors, our friends, our family members. This is not a situation that can in any way be tolerated. And that's why this case is important. This case is also important because when a public housing authority bans firearms categorically, they're basically just spitting in the face of the Supreme Court of the United States. They're basically saying, on this property, Heller does not apply, which is utterly insane. Now, this is not the first time that this has happened. The San Francisco Housing Authority, which is obviously a major housing authority, they did this in 2009. They entered into a stipulation of settlement, and obviously they had to knock it off with their gun ban. 2019, the East St. Louis Housing Authority, they did it too, and they ended up with a permanent injunction stopping that practice. Now, what we did, we filed this case in December 2023. This followed a number of instances where the plaintiffs, they told the Cortland Housing Authority, they sent them emails that verbally, they said, this is unconstitutional, you can't do this. And the response that they got each time was, the ban will remain. That's what they were told. One of the plaintiffs, Mr. Hunter, made a post on the Cortland Housing Authority Facebook page complaining about the ban. What do you think happened to that post? It was deleted. As you might imagine, we also have First Amendment claims. The arrogance of this housing authority is breathtaking. It does not stop there. After we commenced this case, they concocted this story that Mr. Hunter had gotten into an altercation with a maintenance worker. We later learned that the maintenance worker had engaged in some rather profane language and menacing conduct towards Mr. Hunter, but never mind that. They sent Mr. Hunter a letter threatening to evict him. That is retaliation 101. So there is a major First Amendment component to this case as well, as there often is when you have a government actor that is doing something that is, for lack of a better term, bonkers. It is indefensible. It's black and white. So you would have thought that they would have listened. You would have thought that they would have just knocked it off. But they didn't, and we had to make a motion for a preliminary injunction. They argued it. And after oral argument, after briefing, on January 30th, 2024, the Honorable Glenn Sotheby in the Northern District of New York granted the preliminary injunction. So since January, the Housing Authority has been enjoined from enforcing this unconstitutional firearms ban, thank goodness. And now all of these individual plaintiffs, they all now have firearms in their housing units, we're proud to say. I'm also proud to say that we just learned today, incredible timing, the individual plaintiffs all received in the mail the new lease. After months of negotiations, the Cortland Housing Authority has finally amended its lease. And I can tell you that it was a torturous process. They tried everything to keep the firearms ban in place. They also wanted quote-unquote safe storage provisions. They wanted a gun registry. They would not go down without a fight. But I'm proud to say that when we looked at the amended lease, the official amended lease that just went out to the plaintiffs this week, we received it today, we saw that the lease is now constitutional. We saw that there are now no more unconstitutional firearms provisions in this lease. We're not done yet. We still need a permanent injunction. So the case is not over, but we have the preliminary injunction and we have the new lease. So we've come a long way. Now, all of this was clearly worth it. It's rewarding. It's great for these plaintiffs. It's great for the other people who live at the Cortland Housing Authority. It's great for other public housing tenants. It's great for the country. It has broader implications. But truly, the thing that really made this case worth it was a particular paragraph in Judge Sotheby's order granting the preliminary injunction. Now, before I read this, I want to just note, one of the counter-arguments that the Housing Authority raised to try and defend this policy is, they said, well, these plaintiffs, they could still have crossbows. Yeah, they have nail clippers also. I didn't make this up, and you can't make this up. It wouldn't have even made it into a script if this was a screenplay. That was one of the defenses. Judge Sotheby wrote the following in response to the crossbow defense, we'll call it. The court, and I quote, "The court notes that it must flatly reject defendant's argument that the individual plaintiffs do not need handguns in self-defense because they possess crossbows. As if a home invader typically pauses long enough to nibble the leaves of a potted fern. Far enough away from a homeowner to be stopped by a feathered bolt." I read a lot about the Second Amendment every year, as I'm sure you all do. This is far and away the best quote that I've seen, whether in the Supreme Court, in the United States Circuit Courts of Appeals, or the district courts. I've never seen a quote that good. And I think it should go down in the annals of Second Amendment history. I want to also emphasize a few other points just so I can drive home how outrageous this entire process has been. As if everything I told you already was not outrageous enough, the level of corruption that is associated with this firearms ban is actually quite staggering, because it's never just the ban itself. It's all the activities, the corrupt and unconstitutional activities that are adjacent to the ban. And one of the most appalling corrupt acts I've ever seen in this space actually occurred in this case, which is that the former leasing director of the Cortland Housing Authority, for some time, would sit down with new tenants, go over the lease, go over the firearms provision, and ask them if they had any firearms. She would tell them that, well, you have to surrender your firearms before you move in. But, you know, it would be a real shame if you just had to give them up for nothing. I'll buy them off you. And this actually came out in a deposition in this case. We took the non-party deposition of the former leasing director, and she admitted it. And in some instances, she would buy these firearms that new tenants were forced to give up. She would buy them at astonishing amounts, $25, $50. And, you know, she was basically saying, gee, that's a real nice gun there. It'd be a shame if anything happened to it. And when you look at that, that is appalling. And I think that is really the best way I can end this talk, because I really want you to think about that. I want you to think about how absurd that is, how beyond the pale that is, and how egregious that is, and how egregious this whole situation was. The moral of the story is that we have to be vigilant. The moral of the story is there is no Second Amendment case that is too small for us to pay attention to. Thank you very much.
Thank you, Edward. Great stuff. That was great humor to close out the hour, brother. That was great stuff. You believe that? Just when you think they can't go lower. It's fun stuff. All right. Oh, this next speaker, I don't even know what to say about her. The citizen social media activist is the topic. Cheryl Todd, most of you know her. She's the executive producer and co-host, of course, of Gun Freedom Radio. She's also a very dear friend of mine, and I'll just leave it at that. God bless you for everything that you do. Thanks for being here and shaking hand. I don't get to do that with you. I know you'll kick ass and take names. Have at it.
All right. Fantastic. Thank you all so much for hanging in there. Thank you so much to our hosts, the CCR, KBA, and SAF, for giving us this beautiful room to meet together, to share ideas. Let's give them a round of applause. So yes, my topic is the citizen social media activist, right? So all day today we've been hearing about what lawyers are doing and need to do. This is about you and me. And it is time for us to invest in a way that maybe we're not really understanding that we should be. We'll start here. We all hold certain truths to be self-evident. And among them is that every single person has the ability to be a citizen journalist. If you have ever published a social media post on any platform, including email, you are a citizen journalist. And also, we hold true that it is imperative that you tell your story. Harness the incredible power that you inherently have in the world as a unique individual with a unique lived experience. Who can fact check that? No one, right? Your sphere of influence is so powerful because it is unique unto yourself and cultivated with shared values with others. And I say sphere, not circle of influence, because you have people above you at work, maybe people older than you in your life. You have peers on either side, and coming up, the most important is the next generation, our children and our children's children. So how are you going to do this? What is your gift? What are you already known for? What are you good at? Poetry? Maybe you're great with a camera, videography, maybe humor or spirituality, gardening, the cooking arts. Use that gift to tell your story as it's related to freedom. So a good friend of mine, her name is Paige Rue, and on Instagram, she goes by the handle Some Chick Who Shoots. Look her up. I don't even mind if you look at your phone right now to do it because she's awesome. She is a firearms instructor and she loves fashion. So she has married those two worlds together, and she does these really great videos called the Get Ready With Me videos. And so she shows us how to conceal carry with everyday clothing, formal wear. She's got a friend who's about to have a baby, so, you know, how do you carry with a baby bump? And we're all gonna need to know how to go to the restroom at some point when we're carrying a firearm, and Paige covers that as well. So please look her up. But that's such a great example of what she decided to do to get around some of the algorithms and to reach the everyday person. So when we harness that power, we will impact, create, and define our culture. For too long, we have allowed other people to define our culture that it goes completely against our values. It marginalizes us and treats us as though not only do we not belong, but we're not wanted. And we sit back and act like we don't have any ability to impact that field and play a role. Well, I started this by saying it's time for us to invest. Well, when you invest, there's an ROI, a return on investment, right? Well, our return on investment is exactly this. I think we all know and understand that culture, right? It's here. Downstream is politics. Downstream from there is legislation and laws. So let's say that the culture decides that X is bad. Well, who's going to get elected? People who agree that X is bad. And what are they going to do once they're in those seats? They are going to create and pass laws that agree with what? X is bad. Well, what about Y is good? Same exact scenario. So those of us that are like, oh my goodness, politics, I don't do politics, I'm so uncomfortable with politics. I think we need to better understand the flow of how things go. And the time for us reacting is over. We must insert ourselves in the cultural conversation in a proactive way. So let's define these terms. So an activist, one who is, oh, there's that word again, politically active. But active is the key word here. Active in making changes, changing what that person believes is wrong. So I always like to look up where words came from. I like to see what the etymology is. So the etymology of the word activist comes from 1915, and this is what I thought was extra interesting, is that when you watch the graph of the use of that word, there's a huge spike in the United States in the 1960s. So a lot of these people that were cutting their teeth on how to do activism are right now have been sitting for decades in elected office, continuing to be activists, not representatives, right? So the next word, advocate. Now, advocate is really where I see myself in this world. An advocate is one who intercedes for another, is a protector, a champion, and a patron. And an advocate wants to protect what that person sees is good. So then that word journalist, ooh, that's another uncomfortable one, because that sounds like somebody with a ton of college degrees and some fancy byline and some big media corporation. Actually, no. It is one who collects, prepares, and distributes news or commentary in newspapers, magazines, books, blogs, podcasts. I'm a podcaster. My husband and I have Gun Freedom Radio. We are not trained journalists, right? Email is on the list, as well as radio, television, and even motion pictures. So the etymology, again, is interesting in this word because it started, the first recorded history of it is in 1821. Did you know the Gutenberg press was created 400 years before. So it was 400 years that we didn't even know what to call the people that were doing this activity. So don't let it intimidate you. So a journalist is someone who reports or expresses something. So every year during this amazing event, on the Friday, so yesterday, there's an event that's called AmCon. It's where Second Amendment media people come together to workshop and network. And this year, we had a gentleman whose name is Gabe El-Taib. He is a comic book artist. He left a lucrative career at DC Comics because what they wanted him to draw, their storylines, went completely against his personal values. So what did Gabe do? Did he just take his pens and go home? No, he created his own brand called Big Man Comics. Look that one up as well. Because Gabe understands that what we buy into, including comics. And nothing will persuade you more than story. Charlie Cook, who is one of our MCs, he's a musician. He uses music to influence, entertain, and impact our Second Amendment rights. I am a wife, a mom, and a grandma. Really, that's basically all I am to the rest of the world. But I appeal to my sphere of influence through areas we have in common. I say that polka dots are my camo, right? I'm the Betty Crocker of the gun world, right? I appeal to others through the things that are familiar and ordinary to help them see themselves in what I do. So finding your niche and honing your voice is only part of being a social media activist. So you must also protect your ability to create and share your content. The First Amendment, right, we have that. It guarantees that we have the freedom of expression by prohibiting Congress from restricting the press or the rights of individuals to speak freely. Well, wouldn't that be nice? But in the meantime, right, great idea. In the meantime, we have Mark Zuckerberg, the founder of Facebook, telling us that government pressed him to interfere with the free flow of factual information. And now that we know that the conspiracy theories were actually spoiler alerts, it is up to us to reach out to our legislators. We have to tell our representatives how we want to be represented concerning the First and the Second Amendments. We have to show up and testify. We have to write letters. And we have to influence others to do the same. I have been a business owner since I was 18 years old, so at least 2 or 3 years. Don't do the math. Don't do it. I see you at the calculators. Knock it off. Only in this social media world have I experienced the playing field, the algorithm, to be some secret part of the process where I have to guess how to effectively connect with my audience. Imagine this, with each of my businesses in the physical world, I fill my shelf with products. I hang up a sign, and passersby decide whether or not they want to do commerce with me. In the digital world, the powers that be block off my street, cut the power to my sign, and build barriers to passersby from even seeing my business. In the physical world, you and I would walk into the mayor's office, the city manager's office, and speak with city council to demand that they unblock our street, restore power to our signage, and remove the barriers to us conducting legal commerce. In the digital world, we shrug and we take it. But we must walk into our state reps and senators' offices and demand that they stop playing footsie with the social media companies. We must demand that their strongly worded congressional hearings actually cause a positive change. In the digital world, we need to understand truly what power we possess Our sheer numbers could create a tidal wave of change. We need to understand that we are the ultimate product that these social media sites sell. They need us so that they can sell advertising revenue. And we must understand that our silence is consent. In closing, we have so much power to be the change we want to see in the world. Identify your unique voice. Begin making your version of journalism. It doesn't have to be expensive or elaborate. Just start telling your story and living out loud. Make a joyful noise and also share the work of others. And finally, in this digitized era of electronic communication, don't ever lose track or connection to paper and ink. If you haven't read Ray Bradbury's Fahrenheit 451, put it on your must-read list. This is very similar to Orwell's 1984. It tells of a futuristic time in America when people spend every minute of their lives watching wall-sized televisions and not speaking meaningfully to one another. In this era, books have been outlawed, right? Firemen show up not to put fires out, but to burn any books that are left over, which is kind of like the ultimate form of fact-checking. And with no paper books, it therefore mandates that all information can only come to people through electronic means, which is changeable and editable in real time and on a whim. Hang on to your books, but also engage in the digital space. You have a story to tell. You have a sphere of influence. You have a camera and microphone in your hand every minute of every day. Bloom where you are planted and begin or expand your social media activism today, and tag me so that I can cheer you on. Thank you very much.
Awesome sauce. Cheryl, you're awesome. Thank you. Okay, guys, so we're actually getting close to winding this down, so we're going to do something a little bit different right now. We had a video for our next speaker, but we understand the video quality is not that good, so we're going to run the audio. It's only about 3 minutes, I take. Is that right? About 3 minutes? Okay, so we're going to do the 3-minute audio, but just to give a little bit of time, I'm actually going to read this gentleman's full bio. Christian Craighead is who we're talking about here. Christian Craighead, he's an advocate and an author. Let me pull this up here for you. Born in Northeast England, Christian Craighead has always taken an unorthodox route, constantly defying the odds stacked against him at every level. At the age of 16, he joined the British Army, initially serving in the fearsome Parachute Regiment, and was then selected for the elite Pathfinder platoon. Craighead's natural get-the-job-done mindset secured him a coveted spot at the principal of most soldiers' dreams, the Tier 1 Special Forces. So this guy's a badass. As a senior and highly decorated member of 22 SAS, the British Army's Special Mission Unit, known for covert reconnaissance, counterterrorism, and hostage rescue, he participated in an exceptionally high number of high-risk missions and was wounded in action. This hard-earned combat experience underpins his reputation as a renowned counterterrorism and special tactics instructor. In 2019, Craighead single-handedly shifted the outcome of a terrorist attack in Kenya. His actions and leadership during the brutal attack are credited with saving hundreds of lives. Those unauthorized actions earned him global praise as well as an invitation from personal gratitude from the 45th President of the United States, one Donald J. Trump. After 28 years of active service, Craighead retired in 2020. He continues to conduct leadership and specialized training and is sought after for the keynote speaking engagements. The goal of his work is to encourage anyone to become the necessary leader, to have the courage to make decisions, and to actively reshape the narrative instead of being the passive bystander. Staying true to his unconventional manner, Craighead is also the author of a children's book, The Wrong Wolf. He now resides in Texas. Can we run the audio? There we go.
Hello and welcome to the 39th Annual Gun Rights Policy Conference. My name is Christian Craighead, and I'm sorry that I can't be there today to address you all in person. I come from the United Kingdom, and when I was asked to do this address, I briefly looked into the Constitution of the UK. And as old as it is, it's been constantly modified over the years, and to me seems to be written by the establishment for the establishment, unlike the Constitution of our great nation, which was written by the people for the people. I say our because today I'm extremely privileged to live legally in the United States of America. After an horrific school shooting in 1997, the UK government banned all private gun ownership. There are some exceptions, but it's extremely difficult to own a firearm in the United Kingdom. And this is a sobering reminder to us all that whatever rights you give up, you will never ever get back. Without sounding disrespectful, and in my humble opinion, I view the Second Amendment of the US Constitution, the one that protects all others. As an outsider, I view the US Constitution with a kind of revering envy. And when I'm a US citizen, I will hold on to it dearly and protect with my life. When I first arrived in the United States, after a long and active career in the United Kingdom Special Operations, owning a firearm to me was not a priority, yet now it's an integral part of my daily life. And God forbid if I ever had to return to the United Kingdom, I would feel very helpless and pretty vulnerable. We can all clearly see today in the media how a population can be controlled and be destroyed by an unthreatened and unchallenged government with no real love for its country. When the Founding Fathers wrote the Constitution, they knew that armed groups of men could and would be necessary to defend the freedoms already fought for at such a great cost. However, as the Second Amendment is an individual right, they also knew, as I do very, very well, that just one man who is armed and willing to do the right thing can save many lives and keep evil at bay. Thank you all so much for all that you do in protecting all of our gun rights. If this seemed a little tense, it's because I'm filming this on my iPhone in my study at home, and this is about take 45, so I'm pretty fucking pissed about it all. So anyway, hope it's well. Thanks again. Goodbye.
All right, guys. As my kids used to say when they were little, "Are you tricking me, Dad?" I just got tricked by him. Yeah, that was legitimate. All right. Well, we're at the end of our hour. We've got the last speaker coming up, and you might know who he is. You might not. He's got just a little tiny YouTube channel. It's not that big of a deal. Make Your Influence Count is the name of it. He's over there chuckling because it's maybe a little bit bigger than tiny. Jared Yanis, you know him if you follow YouTube and follow Jared. It's Guns and Gadgets. Jared, welcome up, brother. Take us to the closing remarks.
All right, y'all, I just pounded a Red Bull and I can smell colors right now. So bear with me. One of the good things about going last is you're last and you don't have to worry about it anymore. One of the bad parts about going last is everybody who got up here said something I was going to say. So I'm not going to drill down further into that. We're going to pivot on the fly here. Let's start out first by thanking Second Amendment Foundation and the Citizens Committee for doing this for us. This is my first one. This is my first GRPC, first of many, hopefully. So let's give them a round of applause and let them know we care. That's also helping the adrenaline stop pumping through my veins there. So we've heard a lot of folks here on this podium who are the people who are in the courtrooms fighting to keep our right to keep and bear arms, right? Those who are financing those lawsuits, and for their hard work for helping keep what we have. Let's give them a round of applause because they don't get enough thanks. Now, while we are winning, as you heard countless testimonies of today, there are still a lot of people out there that say we're not winning fast enough. And, what can we do for those people who feel disenfranchised? Well, that's where you all come in. Everybody in this room has influence. You might not be an influencer, you might not be an attorney, you might not be anyone you feel is special, but rest assured, my friends, you hold a ton of influence in your own little spheres. All you have to do will take on a role of an advocate or an educator or defender of the Constitution is just to get involved. And absolutely, you have the ability to help keep our most sacred right, the fundamental right to keep and bear arms. You might not believe it, but this won't be possible without you and your input. So how do you become an advocate? It's pretty easy. Just start having conversations. Start spreading the word. Talk to your kids, your neighbors, your family. Have those tough conversations. I wasn't born to have a YouTube channel making fun of government. It didn't just happen. I had to work at it. I was uncomfortable doing it. I'm still uncomfortable speaking before a crowd, but I just keep working at it, and that's something you can do as well. All you have to do is just take that first step, and it's pretty easy after that because you're just falling downhill, and if you don't keep running, you're going to fall on your face anyway. How can you help educate folks? Well, you can do it a few different ways. The easiest way you hear is like take family and friends to the range. Give them that satisfaction of seeing just how fun it is to be a gun owner. To pull that trigger and line up those sights and actually hear steel go, ting, or a can fall, or make a smiley face in a target. It's fun. And when people get that bug, that's how we learn. Like, nobody in this room was born with an M16 in their hand. We all had to go through that experience. And it's fun, right? We wouldn't be here if we didn't think it was. Have those tough conversations, like I said, because those tough conversations are the conversations that save liberty. If our forefathers didn't have those tough conversations around 1774, 1775, we wouldn't be sitting here right now. It's one of the reasons that during COVID, what did the government do as fast as they could? They shut down taverns and bars. Why? Because we were going to have those tough conversations to save liberty. And they were able to perpetrate whatever they wanted during that time because we were stuck at home. What can you do to help defend our right to keep and bear arms? And how do we defend it? Well, our forefathers died to give us a four-letter word, VOTE. And the left has worked for 50 plus years to try to make you think that your VOTE doesn't matter. And there are people all across this country who think, I'm not going to do it. I'm not going to go vote. It's not going to matter. I have no say. And that's what we have to have another tough conversation. Now, because I can smell colors, I even brought my own track here for what I'm going to show you. If you don't start having those tough conversations with the people that you love, you need to get used to hearing this.
Hello.
I want to talk to you.
Okay. That's what's coming for America if we don't get involved. I can't even shut her up. Shut up, lady. Can't stand her. Have those tough conversations, otherwise her ilk win again and again and again. And like we heard so many times today, this election, guys and gals, might be the last one for America as we know it. So get out, get involved, have tough conversations, and vote. Otherwise, I got to play her again, and nobody wants that to happen. There is some interesting things happening during this election as well. We all talk about the presidency, but there are other things that matter maybe a little more than the presidency, because we heard an executive can only do so much. It's like you hear Biden and his friends say that, even though they've been in power for like 20 out of the last 24 years, the guy who was there for 4 years is the problem. Joe Biden's been in power for over 50 years, but the guy who was there for 4 years is the problem, not these dinosaurs who just don't leave. So some of the things we have to do this year is we have to maintain the House of Representatives. We have a very slim lead that can be evaporated like that if we don't get out and vote. There's a thing called voting down ballot, and this is where everybody comes in, no matter how disenfranchised you feel. Vote down ballot. It's huge. I have a personal friend of mine. You might have heard his name before. His name is Brandon Herrera. He's a huge YouTuber, huge influencer, and Brandon put his money where his mouth was and ran for Congress in Texas 23 this year. And fortunately for Brandon, he made it to a runoff, which nobody thought would ever happen because he was up against the machine, up against an incumbent who outspent him, I think it was $5 million to 1. He got crushed in the earnings, and he pushed it to a runoff. And we all did the calculations. If the same amount of people come out and vote that did in the primary for the runoff, Brandon's got it. Because there was a certain percentage that voted for other people who didn't make the runoff, and if they just didn't vote for Gonzalez, you would have the AK-50 in the Capitol. Well, what happened? On the runoff, they had some rough weather around Texas, and a shred of a percentage showed up to vote. Brandon lost by 407 votes. That's less than one human body for every precinct in that district, because people just didn't feel the need to go out and vote. That's just one single office. We lose many every year for the same thing. So we have to maintain the House. Something that's even more important is we have to flip the Senate. Now, we have a situation this year that we will not have before us again until 2030, and that's to be able to flip blue state senators to red state senators. There are 11, I hope I have this right, there are 11 red state senators that we are defending. The blue side, 23. We're down by 2, right? We have to flip 2. There are 2 easy ones to flip, but then there's a problem. So we should be able to flip West Virginia because Joe Manchin is retiring, and he's already said he's not going to back the gaggling geese because she wants to get rid of the filibuster, which is huge. We also should be winning Montana with Tim Sheehy. He was up 5.6%, so as long as that carries through, we'll be good. However, Ted Cruz's seat is in trouble, y'all, in Texas. Texas! Blue is on the rise in Texas, which is why we need to get out and vote. Okay? Does everybody know what the filibuster actually is? Okay? The filibuster is at risk. If Kamala Harris and her cronies win, Chuck Schumer said he's going to get rid of it, and so has Kamala Harris. She said they want to get rid of it for the abortion. But once it's gone, it's gone. And they will force through everything. They'll pack the Supreme Court. They'll pass semi-automatic rifle bans, magazine limits, because all they need is that 51st vote. And in the event of a tie, the vice president will cast that tiebreaker. It's extremely dangerous times we're on right now, and nobody you talk to in the younger generation even understands that. And that's something that we have to have those tough conversations. All right, so we need to flip to and maintain what we have at a minimum. Another big reason you need to vote is you've heard that the 2 best justices we have right now on the Second Amendment side, they want to retire and go play. Clarence Thomas and Samuel Alito, they're done. They're holding out for this election. They don't want to hang around anymore. They're getting to be older gentlemen. If we don't win this election, we're not going to have the makeup we have in the United States Supreme Court right now. So you can kiss all the stuff we've been gaining ground on, you can kiss it goodbye, because they're going to pack the court, they're going to ram stuff through, and if they get rid of the filibuster, America is screwed. You want suppressors? Get out and vote. Okay? You want to destroy handgun rosters? You got to get out and vote. These are some of the things you need to tell your youngins when they say, why can't I have a Gen 5 Glock in California? It doesn't make sense. Did you vote, dingbat? There you go, let's start there. There are 10 million unregistered gun owners, there are 10 million gun owners and hunters who are unregistered to vote. Never have registered, ever. If you got a pen in your hand, write down VOTE, V-O-T-E, the number 4, America.org, voteforamerica.org. They'll get you registered to vote. You still have time in every state. You have probably another week or 2, depending on the state you're in. And then once you get people registered, get them to the polls. Challenge everybody you know, and we all know people who didn't vote before or didn't vote last year or voted for a box of rocks because they don't like Trump's Twitter. Get them out, grab them, put them in your car, don't tell them where you're going, and show up at the polls. And that's kind of kidnapping, but you know. I got 4 minutes. I'm going to rip through these numbers because some of these people heard it yesterday at AmCon, but the rest of you need to know these numbers. Once you hear your state, if you're from it, make some noise. Alaska, anybody travel from Alaska? Probably not. 16,815 gun owners and hunters are not even registered in Alaska. Alabama in the house? There we go. Yay! 215,126 of your friends and family that own guns or hunt are not registered to vote. Arizona, you here? Well, you might not cheer after this one. 209,817. Arizona, I know you're here. 133,094. Anybody from California here? 511,345 gun owners that don't vote to stop the infringement on the Second Amendment. Think about that, 500,000 plus. Colorado, you here? It's too cold. 147,754. Connecticut, I know you're here. 66,483 people need to get on the train. Anybody from DC? 5,794. Delaware, anybody from Biden state? You wouldn't speak up if you were. 26,871. Florida, I know you're here. 659,718 people in the gun-shy state can't see that much interest in keeping the Constitution. Georgia, I know you're here. 350,897 in a huge swing state. Hawaii, anybody come over from the islands? 13,190. Iowa. All right. 136,747. Idaho. I love it. I love it. You had a Red Bull too. 101,421. Illinois. 305,507. Indiana. 251,031. Kansas, I know you're here. 102,551 of our brethren got to get with the program. Kentucky, if you're not underwater, 214,999. Louisiana, my old home, 170,739. Massachusetts, yeah. Freedom was born there and it died, but 113,324. Doesn't sound like a lot compared to others, but Massachusetts is about as big as this remote control. So, Maryland, 125,898. Maine, you can't get there from here. 60,617. Michigan, 370,619. Minnesota, 261,559. Missouri, I will show you, 281,102. Mississippi, 172,776. Montana, 52,233. North Carolina, they got destroyed, y'all, with this storm. So pray for Florida, North Carolina, and Tennessee, because people are struggling hard. 370,470. North Dakota, 48,219. Nebraska, 82,121. New Hampshire, 56,586. Jersey, 166,563. New Mexico, 51,641. Nevada, nobody? One, there we go. 59,173. New York, 326,895. Ohio, yeah, this is a big one. Oh, you should be saying, oh boy. 625,676 people who own guns or use them to take food but don't want to fight the government to keep it. Oklahoma, 151,351. Oregon, 137,949. Pennsylvania, nobody from the Keystone? 515,277. Rhode Island, 16,289. South Carolina, 229,423. South Dakota, 43,493. Tennessee, 311,090. I mean, everybody carries a gun in Tennessee. Everybody. Texas. Anybody here from Texas? All right. Now the biggest infringer of all is Texas. 663,985 gun owners aren't involved. Utah, 121,383. Virginia, 277,390. Vermont, 28,622. Washington State, 153,706. Wisconsin, 338,894. West Virginia, 95,676. And Wyoming, 38,508. For a total, if you were running your fingers, 9,988,407 Americans who utilize firearms but don't care enough to vote to keep them. We all know these people. You might not know it, but that's why tough conversations save liberty. All right? I'm out of time. Get on your folks. Time is running out for the Republic, y'all. And it's on us to be advocates. It's on us to educate. And it's on us to defend it. Otherwise, our kids are going to hate us a little more when they get a little older. I appreciate y'all. Thank you to Second Amendment Foundation. Thank you to everybody involved. Appreciate you.
Thank you, Jared. Thank you, Jared. Appreciate it. We did it, y'all. We're back. We got through the day, didn't we? We got through the day. I hope you all had a great time. Oh, no mic. Then we'll go to this one. Hope you all had a great time. Here's 4 words you don't want to hear on November 5th or November 6th at 3 o'clock in the morning. We did it, Tim. We did it, Tim. You don't want to hear that. And Jared was spot on. We can lose everything. Everything this organization has worked for 50 years is now on the line. She wins the election. The Democrats somehow take the House and keep the Senate. It's over. Supreme Court is gone. It will be years, and I mean generational shift, before we get back these hard-won battles that we've fought over these years. Ladies and gentlemen, I want to thank you all for being here. A couple quick questions for you. The veterans, I've heard from some of you. Those of you who are new, I want to thank you for being here. Again, raise your hands. How many first time again? It's great to see you. I know a lot of you from California. Did you all like the format this year? Did you like the breakdown? Did you like the fireside chats and all? Expect to see more of that. We kind of cut our teeth on that this year, but I really enjoyed it. I hope you did too, and we'll learn as we go forward for the next GRPC. I don't know, Charlie, when you're hosting tomorrow if there's any fireside chats, but regardless. Okay, well, I hope everybody sticks around as well. I want to thank Alan Gottlieb, Adam Kraut, everybody at the committee, all of our great speakers today, the Second Amendment Foundation, and more importantly, each and every single one of you for being here and fighting the fight. Thank you all. Right now, right across from us on the pool, across from the pool on the other side where the reception was last night, go get free, not I would say free drinks, I better back off on that one. Because I ain't buying y'all drinks, I tell you that much. There's a cash bar over across the way, and I guess there's free hors d'oeuvres, so we'll leave it at that. All right, and those of you who are traveling tonight like I am at 11 o'clock for a 6 a.m. arrival in Georgia tomorrow morning to go to work at 8 o'clock tomorrow night, travel safe. I hope everybody is here tomorrow. Enjoy your day. I'll see each and every one of you on the radio tomorrow night on hundreds of radio stations. Thanks for being here, guys.